Hi, how are you today? Alrighty. So, thank you for being here, Exposure. Hope you're having a good night. So tonight we are just gonna finish up with the Madison Poague trial situation, and with that situation, I think we're gonna get the verdict tonight. Last time, I believe we saw the defense and the prosecution rest their case. And before the prosecution rested their case, they called in some more investigators. So we had previously seen some different investigators earlier on that they had called. They called in a couple of more, and one of them was one that had, I think, two more. Maybe I'm wrong. I actually can't remember if we did one or two more investigators, but we definitely did at least one more investigator and the the coroner. So we did the coroner and the investigator. And did we do two investigators or just one? I can't remember, but I know we did at least one last time. In day 3 of the trial, part 4. So there, one of the investigators had taken evidence from the cell phone. Let's see here. Exposure says to ignore that. Ignore the yo. Got it. And so, the investigators had taken evidence from the sister of the baby's father. And when that happened, the sister and the baby's father were in their room together. And they testified to that. But the defense was trying to basically say that, the investigator was interrogating both of them at the same time, and the investigator and both of them had, not both of them, and him, because I don't think she testified, just him. The baby's father and the investigator both testified separately that they had done the investigation and the interrogation at different times than that, and all that was happening whenever they were in the room together was her getting information from the sister's phone. So in the footage, the defense showed that is what it looks like is happening, because the whole time she's got a phone in her hand going through something. The investigator and the baby's father both say that phone is the baby's father's sister who was there too. You following? So yeah, so the defense is basically trying to say that the investigator is a liar and breaking her own rules and procedures and interrogating both of them at the same time and trying to act like she's not credible, basically. So that's what happened last time for part of it. And another part, there was the coroner. And so both of these people were called by the prosecution, and they were recalled by the defense. And with the coroner, I forgot what he said, but he was, okay, so first of all, he had been interviewed by a news outlet, and the guy was like, the defense was like, have you been interviewed by this news outlet about this case? And the coroner was like, I did so many interviews, probably, I don't remember what I did or didn't do an interview for. Maybe I did, maybe I didn't. Like, I don't know, probably. It was basically what he said, not word for word, pretty much. And, the defense was basically like, no, you did do the interview, and you said X, Y, and Z. And he was like, I don't know if I said that. Maybe I did, but I don't remember saying that. I don't think I did, because I don't remember it. It was basically what the Reverend said, if I remember correctly. And then the defense found the footage, replayed it back, and was like, see, you're a liar. And so, if I remember correctly, though, and I could be wrong, the coroner had basically said something to the effect, he was being asked general about autopsies, and he had said something that sounded to me like a general answer to the general procedure of autopsies or investigation of cases, if I remember correctly. And the defense was trying to act like that's what he was saying happened with this specific case. And maybe I missed it, and maybe that is what happened, but I don't know. Yeah, it was like a whole thing. There was just like a lot of time spent on that. And so then the prosecution was basically kind of pointing out that what the defense was harping on wouldn't have made a difference in any fact or facet of this case, and it just makes no sense, basically, if I'm not mistaken. In other words, is basically what they were doing, I think. But yeah, and that was kind of, in my opinion, the defense's strategy the whole time, is to like kind of attempt to discredit every single witness by acting as if what they were saying was not the truth, if, in my opinion, kind of, in a way. Well, the prosecution rested their case after that. Then the defense got started with their case, and I thought they were going to bring more to the table or something, but they spent their time recalling the investigator and the coroner I just told you about, if I'm not mistaken, and or maybe I'm getting confused with things, but I think that's what happened. I think they also recalled the baby's father, if I'm not mistaken. But yeah, and then they brought in 4 new people, and if I'm not mistaken, when they recalled those witnesses, we didn't really get anything new. They were just re-harping over the same shit we've already been through, in my opinion. And then when the new witnesses came, there was 4 new ladies that came on from the defense, and there was 2 different women that Madison had babysat for, and they spent a lot of time. The prosecution was trying to argue, like, oh, they shouldn't be allowed to testify because it's a character witness testimony. The judge ruled it could go, so whatever. And so they were basically like saying, oh, Madison did a great job babysitting for me, whenever the defense initially questioned them. But in my opinion, whenever the prosecution would cross-examine them, they would be like, so, if you knew what you knew now about Madison with this case, would you still want her to babysit for you? And both women were basically like, nah, I'm good. And he was like, thank you for your time. And then there was 2 other ladies who were also in the same dorm, but not roommates, but in the same dorm. No, one of them was in the same dorm. One of them went to school, but was in another program, I think. I think that's it. Definitely both went to the same college. That's a fact. With Madison. And both of them were supposed to come on and say positive things, I believe, if I'm not mistaken, because the defense is the one that called them, right? And so they were able to discuss, their association with Madison in a more positive light, trying to paint her as a hardworking student, I think. But then when the prosecution came, they were basically like, so, has Madison ever talked to you about the baby? And both of them, in my opinion, if I'm not mistaken, if I remember correctly, both discussed that Madison had discussed resentment towards the baby to them previously, if I'm not mistaken. So none of the witnesses, if I remember right, went well for the defense. And now we are gathered here today. Oh, and then the defense rested their fucking case after that. And I was like, is this really it? That's it? That's all they got? They're fucked. That's what the fuck I said last time. I was like, they are absolutely fucked. So now we're going to roll my intro, and then we're going to get into day 4 of this trial, where both the prosecution and the defense are going to give us their closing statements, which theoretically should basically be recapping this whole fucking trial. So we'll kind of do that at the end, I guess, but not really, because we won't really have to, because it will be in the closing statement, so we can just recap today, right? Kind of, I think. So yeah, that's kind of the plan of what we're going to do now. But yeah, I appreciate you. Thank you for joining me today. I'm going to roll my intro. We're going to get started. And, oh, before we get started, if you've been following along about that case where I did try to take legal action against my former employer, there is an update on that. I don't want to ruin what that update is, because I'm going to make a video on it, or ruin the surprise, but I will be covering that. I'm going to try, if I'm not too late to do something, I'm going to respond to it, and then I will update with you guys on what all of that was. And also, somebody had requested I make a video. I'm looking into something a little more, but I do have that video coming. And I got a bunch of other things happening. They're in the works. It's happening. It's a work in progress. It'll get here when it gets here. But yeah, Okay, so I'm gonna roll my intro. We're actually gonna do this bitch now. And yeah, thank you for your time.
Hi, my name is Alexis, also known as Lexie or Deaf Child. I was born deaf, hard of hearing. I began doing business as Deaf Child 2013, marketing 2011, sales 2009. I've earned 50 plus certifications in marketing and sales. My Bachelor of Science from Loyola University, New Orleans, with a music industry studies major and a business administration minor. Deafness runs in my family genetically. Speech is not fully accessible to me. Anyway, I'm here to bitch about whatever the fuck is on my mind. So here we go. Visit my site at noladeafchild.com.
Okay, so first things first, we are going to be getting right on back into our trial that we have been covering. Oh, I forgot to mention in my recap earlier also that I did in the intro previously. In the last stream, I had, at the beginning of it, we went back to the hearing that I found on Court TV because I thought we were going to get something from the hearing that they filmed and posted there. But in that video, we didn't get much. All we saw was that she changed her aesthetic. So previously, her hair was basically, it looked as if it had been dyed, if not black, a very dark brunette color. And her aesthetic, she looked like she was wearing more black, dark colors. I couldn't see the shoes. I really feel like the shoes would give you a more of a placement on the type of aesthetic she was going for. You know, if she was going for punk, emo, goth, I don't know. I don't think the goth or emo kids are likely to claim her. Maybe the punk kids would. And then we've got Res Runner, Res Rocket in the house. Thank you, Res Runner. I appreciate you. I hope you're having a good evening. Res Runner has been walking all the way from his reservation to Washington. Just, and honestly, I don't know where he's going once he gets there. But what I know that he's doing, what the intent of the walk is raising awareness in general for just not only indigenous unity, but tribal sovereignty. And general just awareness of what the fuck is going on with all the bullshit in the world. So I think that's real cool. Definitely follow Navajo Res Runner on TikTok. If y'all are on TikTok, you know, follow his journey and shit. And Isla keeps changing her username though. So fuck, man, I don't even know what to tell you. Let's see what it is right now. What the hell is Isla's username? Because it was Isla Picante. It was Isla Walks These Streets because people were saying that about her. So she changed her name as a joke. What's her username now? It's Isla Gia. Yeah, we'll see how long that lasts. But look, Agia Isla Agia is currently her name. Yeah, but anyway, I love Isla. Navajo Res Runner is easier to find right now on TikTok. Go follow them. But yes, and we've linked nobody previously, so. Yeah, alright. We're gonna actually hit play now and get on up in here. Apologies, y'all. How the fuck do I turn? Here we go. Here's my button. Let's get into our bigger window. And let's see. We are going to skip past this. It says the same damn thing it always does. As usual, we're gonna speed this up to 1.5 speed. Also, if you want to watch this video without my commentary, it's linked in the description below. And let's see, it looks like they don't come back for a minute here. Let's skip through that. Okay, now it looks like they're about to come back. We're gonna double time it while we wait for them. I hit play. And Exposure says, been telling people about a bad person in the TikTok area. Was that Cherokee guy with the Cherokee name in his username that you were telling me about? I think I'll cover that next if I can find some documentation. I haven't looked into it at all because I've been looking into something else that I don't want to discuss because, you know, just in case I can't reveal what I'm investigating until after the investigation's done. You know, because I have to be able to find out the information, and if they know I'm looking into them, they might block me. But y'all have no idea how easy Facebook makes it to your genealogy. Like, I mean, I can find your siblings, your parents on there. Then I just need a dead relative, and I can find your ancestry from there usually. It's like, bada bing, bada boom. Oh, exposure said yes. That guy. Okay, yeah. Alright, I forgot that guy's name. But you had commented it somewhere, I think. But, yeah, I do want to look into that. I just haven't even looked into it yet. If there are court records, that makes it even easier for me to cover, because legally he can't do shit about me covering court records that are public, you know? And there's no, like, it's the truth and it's documented, so I'm allowed to talk about it. It's public record. So I love when we have court records. I guess if they're speaking, we don't have access to the volume at this time. But this lady in the middle here is our person accused of murder. I don't know who we are zooming in on. Is that her parents? I don't know. But
Ms. Lamb, I'd like to address some matters if you could sit back to
her. So she really lightened her hair. Let's see. Exposure said the name is Daniel J. McKay. Damn, isn't that the doctor? Or no, not the doctor. Isn't that that's the, I'm thinking of Rodney McKay from Stargate, Atlantis, I think. Yeah, there it is. And Daniel Jackson from Stargate. I think I'm combining the two. That's what it is. But anyway, yeah. So for a minute I was like, Daniel Jackson, Rodney McKay, Stargate. Oh, hi, I love you. Sorry, people, because my new office, well, it's not really an office. Is it an office? It's my office now. My new office is kind of basically in my kitchen, so I'm not always alone in here. Anyway, I just muted myself instead of turning that off. Okay, let's see if I can. This court starts.
You can leave that there. I just want
to say over here, so I can use it while you're.
Okay, it looks like something's happening.
What I plan to do is, because it is morning, and I've gotten the impression from the jurors that they need breaks during the morning, and so every hour or so during closing, regardless of where we're at, I'm going to.
You know, I'm the same way though. In the morning, it's like I'm slow to get started. I need my coffee. Give me like 3 hours for my coffee to kick in. Then I'm like good for 4, 5, 6 hours, and then I'm done. Yeah. Okay, so Daniel J. McKay. So it's a case in Oklahoma. And he's like the first dude that pops up on Google. Got it. Oh, phone's at 5%. Have a good night. Bye. Yeah, that's that. Okay. Oh, all right.
Take a pause for the juror's sake. Brandon, at the back, I want to limit the incoming and outgoing traffic during closings. If I look at you and nod my head, I want you to go to the outside and don't let anybody else in except in between the arguments. Okay, hopefully it won't be a problem, but I don't want a lot of distractions going back and forth while the attorneys are giving their summations. The other thing, you know, the closing arguments are the part of the process where the attorneys, you know, try to persuade one way or the other. So they're going to talk and they're going to make argument, and it's going to offend people that are in here that are interested in the case. I do not tolerate any reaction to those matters. So if that becomes a situation, then we'll stop, and somebody could end up being removed. Brandon, if you tell Deputy what I just said about the disturbances, so or about the coming and going.
I wonder if that was like a general warning or if that was like a pointed statement, because the older people behind her, who I assumed might be her parents, I don't fucking know who the hell they are, were like real emotional. Or maybe I'm weird. You know what? While I'm at it though, I had Googled Daniel. I had copied this name. Let me just like go ahead and open up a tab for it. Real quick while we are paused. There's a few different ones actually, I think. But yeah, we'll look into that one. Okay, anyway, apologies. Here we go.
Sharon, can we check and see what the status is on the juror? I know they're supposed to stick their head in and tell me. We were waiting on one juror according to the bailiff when I walked in. I also put I think Mallory gave.
Okay, cool. So they're waiting on something, so I don't know.
You the verdict form for each of you to use during your during your closings if you wish to. Otherwise, is everybody ready to proceed?
Yes.
All right. As soon as the jurors are here.
Still waiting on the ball.
Okay. When we have all 12 jurors, I'll come back in and we'll go right into the closed arguments. If anybody needs a break, now's the time.
Okay, I think I'm going to double time through here. It looks like they are waiting on the jury and stuff. Okay, so this is a break. Can we skip through this? Do I need to skip through it? Okay, looks like they're about to come back here. So far we are just in the hurry up and wait portion of this court case. As all administration goes. Hurry up and wait. I thought I was about to start. Maybe I should have gone more further. I didn't want to miss anything. Here we go. Well, I thought we were going somewhere. It looks like the second 2 days into this case, she's straightening the hair. The first 2 days, it was a curling.
Good morning.
Okay, here we go.
Is everybody ready to proceed? All right. We're about to allow the attorneys to present their closing arguments. The state has the burden of proof in the case. Well, first of all, did everybody have a good evening? Did you all follow my instructions yesterday? All right, thank you. We're about to proceed with closing arguments. The state, having the burden of proof, has the right to open and conclude the arguments. During the morning, as these arguments proceed, we'll take breaks, even if we're in the middle of one of the attorneys' argument. I don't like to do that, but I will most...
You know that movie, not movie, the TV show, Home Improvement, where Tim had that neighbor? The judges, what I assume that neighbor must have been. Yeah.
Importantly, want you to be comfortable and alert, all right? Mr. Lamb, does the state wish to make an opening argument?
I do, Your Honor.
All right, you may proceed.
Just one moment to move this over.
Oh man, you know every time they do technology, we gotta wait a minute. Here we go, let's double time here. I'm drinking ginger ale, what are you drinking? I've had some ice cream, I might do next. I'm frozen chips, I'm being kind of unhealthy. I might eat some corn. I need to eat healthy, work out.
Let me get there.
Together. Ooh, damn. What was this? Oh, the horrible, what did I say? Hold on, do we need to go back or is that going to come back up? If that doesn't come back up, we're going back.
Please, everybody, make sure that your phones are off.
Order in the court.
Tuesday morning, I stood here and I told you that what this case was
Short
about.
life and horrible death of one precious little boy. Ooh. Yeah, that's going to hit the jury right in the feels. Okay. Sorry, I kind of cut him off, but he said Tuesday morning, I stood here and I told you that this case was about...
Was the short life and the horrible death of one precious little boy. By now, of course, you know who that is. It's J.D. Angeles, born June 25th, 2022. He died January 14th, 2024. The state, of course, has charged Trinity Poague with causing his death. She's charged in an indictment which contends that she committed several violations of the law, several huge crimes, beginning with cruelty to children, aggravated battery. From each of those felonies, there's a charge of felony murder. And then finally, there's a charge of malice murder. And when you get to the point where you're having to move from this, we have this fact, and we have this allegation. How do you get there? And there's really not, I mean, the judge is going to tell you what the law is, okay, but there's not really in the judge's instructions, typically there's not really a roadmap for how you get there. And so what I would suggest to you, ladies and gentlemen, is this. And again, I mean, it is, you are free to decide the case however you choose to decide the case and by whatever process you choose, but I would suggest to you or submit to you that you might consider this process. And that is, you start with the facts that are beyond dispute. The things that you know that are established, where there's just not a realistic argument, where there's not a realistic dispute, where there's no
So, things that are not in dispute for me. 1. According to the doctors, the fatal injury was the skull fracture. 2. That skull fracture was not the only injury present. There was also a laceration to the liver and multiple bruising. 3. The doctor said that the way the bleeding happened meant the injury had only a short time span that it could have occurred before the baby was brought into the hospital. 4. In that time span, the father can prove where he was and that the baby was with her. Did I say 4? Am I on 5? 5. She is accused of having sent some malicious text messages about the baby, basically, essentially saying, or implying that she could be resenting her role as a stepmother to the child, and that she didn't want to be in a relationship with him when it wasn't her kid that she had to take care of. And she said that to not only him, but also her roommate in text message. And she was also alleged to have said it verbally to others as well. 6. The hospital medical doctors discussed that they didn't believe that the fatal injury that occurred could have happened from a fall, even as high as 3 or 4 feet off the ground. So let all of that sink in, marinate with that, yeah, let's keep going here.
Controversy. Start there. And then the reason you start there is this, because you can resolve the disputed issues in the way that is most consistent with the facts that aren't in dispute. Okay, so if you know that 2 and 3, that these 2 things are true, and then you're trying to decide whether this third thing is true or not, you can take that third thing and view it through the lens of what you know, of what you've already established or what you've already decided is an indisputed or undisputed issue. Once you've determined what happened factually, then you can apply the law to the facts. And of course, Judge Sizemore is going to give you a long explanation of what the law is, and he's going to tell you something very much like this. It's something that says to the effect of, you are the judges of the facts in the law, that you determine the facts, and then you apply the law to the facts to determine the outcome of this case. So for this part of my argument, what I want to do is this, ladies and gentlemen, is focus on some facts that are absolutely, at this point, indisputable in this trial. There is an indisputable medical fact in this trial, and that is that the cause of this child's death was massive head trauma. There's no question about, did he die because he had an infection? Did he die because he...
I wonder why it says unanimous, though, whenever they had like 3 or 4 different medical opinions stating that's what they believe the cause of death was. I'm curious why they made the choice to put unanimous there, but whatever, let's keep going.
Who lost his leg and bled to death? Did he die for any one of these other reasons that somebody that might cause someone to pass away? In this case, the unanimous...
I guess like all of the experts unanimously agreed, and so instead of putting on their names, they just put that. I don't know.
This opinion of the medical witnesses that you heard from, the physicians that you heard from. I'm not talking about Dr. Gamble now. I'm talking about the actual doctors, okay, who testified in trial. Okay, Michael Busman, who's practiced medicine in this town for 30-something years. Jill Olick, who has practiced medicine in this town for...
Okay, does the attorney Gamble have his actually I think his name is Gimble. Does the attorney does that attorney have his doctorate? Or was isn't his name Gimble? Or was he calling him Dr. Gamble as like a shot? But, ooh.
15 or 17 years. Dr. Anthony Clark, who has served as a medical examiner both in Georgia and Florida, for the last 30-something years, who's done 8,100 autopsies, who's testified in court as an expert witness hundreds of times as to the cause and manner of death. They all agree this child died from this wound. Now, there are other injuries, and we're going to talk about those later in my argument, okay? But for right now, I want you to focus on this one, and that is that it is an undisputed fact that this child died from head trauma. It's also undisputed that the trauma, or the cause of the trauma, is also undisputed. Dr. Clark says it was a tremendous impact to the back of the head. These are quotes I wrote down while I was listening to the testimony. He says it was a tremendous impact to the back of the head. Dr. Busman says it was a direct, high-impact blow. There's not a question as to whether or not or how you get this kind of head trauma. In other words, it's beyond controversy. You can't get this kind of head trauma from bumping your head on the door back here, or you can't get this kind of head trauma because you have weak bones. You can't get this kind of head trauma because you have some rare childhood disorder like Paget's disease or Alagille disease or whatever it was that was brought up. Okay, rare childhood disorders, bone diseases, all these other things. None of those things will cause the trauma that this child suffered. To get this kind of trauma, it is an undisputed fact that it must be a direct, high-impact blow. The time frame between the trauma and this child's death, this child's appearance at the emergency room and subsequent death, is also not reasonably in dispute in this case. Okay. None of these doctors who testified even allow for the possibility that this child's...
You know what's interesting is, if I'm not mistaken, the father was gone for about 30 minutes. Then within 5 to 10 after that, if I'm not mistaken, was able to get the baby to the hospital. He left like a couple minutes after he came back. And then the baby died not soon after. So I find that time window that they mention, even like that's how it gets narrowed down, Yeah.
Injuries were suffered the day before.
And when he was gone, the baby was with her, so.
Before, or the night before, or even 3 or 4 or 5 hours before. They certainly weren't built up over time. It wasn't that he had a partial occipital and parietal skull fracture, with a massive hematoma at the back of his head and 3 or 4 other brain bleeds across his head, and that they just built up over some period of weeks. That's not what happened. The high-impact trauma that this child suffered would immediately, according to Dr. Bussman, very quickly, 30 to 60 minutes at the most, result in essentially a full onset of symptoms. Dr. Olick said there is 0% chance of normal behavior from the time of impact forward. What are the chances? I asked, what are the chances? What are the chances that this child could have sustained this blow and behaved normally for any period of time? And the answer was, there is a 0% chance of that. Dr. Clark makes it 3 for 3. The time frame that Dr. Clark establishes is this. He says that at a minimum, initial symptoms like drooling, staggering, vomiting would have appeared very quickly, within seconds to minutes after the impact. He said, in his mind, you probably would be in terms of the initial onset of symptoms. In his mind, it's probably more like seconds than minutes before the symptoms begin. Those facts have been established, ladies and gentlemen, by the evidence that you heard in this courtroom. Okay, you don't have to Google it. Okay, you don't have to have a discussion about what happened, when you were a child or when somebody else was a child or those kinds of things. You don't have to talk about what people in the medical community really think. Okay, we're not talking about vaccines or something where some people say it's this, you should take them, and some people say you shouldn't and all that. We are talking about medical facts as to which there is no disagreement. That brings you to this point. The question for you to answer as a jury is this: who could have caused the trauma that killed this baby within the time frame that it had to have occurred? Okay? No telling. In any number of things, any number of people, any number of circumstances could certainly have caused severe trauma to this child at some point in time. But that's not really the question. The question is, who could have caused this trauma within the time frame that you have available? There's an answer to that question. From 8 o'clock p.m. Saturday night, when we were in Albany, Georgia, on January 13th, 2024, until about 12:30 Sunday afternoon, January 14th, okay, for that whole time period, there was only one person who was ever alone with this child. One. There was one person who was ever alone with him for any period of time during that 16 and a half hours. You know who that was? That person was Trinity Poague. Not only that, ladies and gentlemen, when you focus on this time period and you reduce it down to the time the time frame that the doctors talked about, the time immediately prior to the onset of the symptoms, the answer becomes clearer. One person was alone with JD during the time immediately before his symptoms appeared. That one person was Trinity Poague. At 11:55 a.m. on Sunday, J.D. Angelus was a healthy little boy. By 12:30 p.m., he was in a literal death countdown. It wasn't a question anymore as to whether or not he might live. It wasn't a question anymore as to whether he could be saved. It wasn't a question anymore as to whether he would ever be able to grow up. By 12:30 p.m., at 12:30 p.m., he was dying. There were...
See, if I were on the jury, I wouldn't even need time to deliberate at this point. I would just be ready. I would just be like, this bitch is guilty. Let's just go home. I got things to do, people to see. This bitch is guilty, like, at this point, you know?
Symptoms that appeared during this time frame, that appeared when Julian Williams, Jay Williams, when he pulled up to the dorm and he got out of his car, he went inside to pick up that child. Actually went inside to put down the pizza and the drinks because he thought they were going to have lunch. But when he went in and he picked up that child, there were immediate symptoms that the child was suffering right then. The child was essentially unconscious. Okay? The testimony is that his head was limp, that he couldn't hold his head up, that his body was limp, that his head was bobbling around. He was nauseated. Before he got to the car, or as he was getting into the car, the child threw up all over his daddy. He was draining CSF, cerebral spinal fluid. Okay, the fluid that circles your brain, that encircles your brain, that helps protect you from impacts, that helps protect your brain from shock, from harm. Okay, that fluid, by the time he got to the hospital, was literally coming out of his nose and his mouth. It was no longer contained here where it's supposed to be. It was here because of the head injury he had suffered. He was in cardiac or respiratory, cardiac and respiratory arrest at that time. When he got to the hospital, he wasn't breathing and he didn't have a pulse. Those symptoms, when you go back to the time frame that the doctors established, those symptoms would have had, the impact that caused them, the impact that caused those symptoms would have had to have occurred within minutes before the child presented at the hospital. During those 35 minutes that we're talking about, okay, these 35 minutes right here, 11:55 to 12:30, during those 35 minutes, one person and only one person was alone with that child. Trinity Poague. So think about some of this, ladies and gentlemen. You have a circumstance where you have two people in a room. We see this in cases that get presented. I mean, I guess.
And what makes the defense attorney's defense so bad is, I think it was day 2, if I'm not mistaken, of trial, where the defense attorney was like, when they were questioning the doctors, they kept saying, so this could have happened from a car wreck, right? And he spent so much time trying to be like, this could have happened from a car wreck, only to then say, well, we know this wasn't from a car wreck, but it could have been from a car wreck, right? I was like, what the fuck is this defense attorney doing right now? Because I was like, are you trying to run out the clock? Like, what is this? I don't know. The defense has such shitty arguments. It's infuriating. And I'm like, I wonder if that's their strategy, to be so bad that the witnesses want to be like, what the hell, dumbass? So then he could invalidate them or something. I don't know. Like, sometimes the shit he says is so bad, you just wonder if he's provoking people at this point. But yeah, okay, hold on.
Prosecutors everywhere see it at some point or another. You have two people in a room. One of them ends up dead. There's a fight. One of them ends up dead. Okay? You would think that's an easy case, right? Like, you have two people, one's dead, now we know who did it. Okay? But those aren't typically easy cases. And the reason they're not easy cases is because the person who is alive says, it wasn't my fault. It wasn't my fault. He attacked me. He threatened me. He did this. He did that. I was fighting for my life. Or he angered me so badly that I didn't really have a choice. I was overcome by the emotion of the moment. So it should be voluntary manslaughter or something like that. Okay. So there's a myriad of issues that sort of layer on top of each other when you have two people in a room, except in this circumstance. Okay. Because the two people in the room during those 35 minutes were J.D. Angeles and the defendant. Those are the two people who were in there. There's not an argument that can potentially, possibly, in this universe or beyond, there's no argument that can be made that it was caused by the child, that the child, was aggressive, that the child was the initial aggressor, that the child, attacked her and she had to defend herself. Okay? So it makes the two people in a room situation, instead of it being a hard case anymore, it becomes an easy one. I'm about to wrap up here in just a moment. Sit down and turn over the podium to Mr. Gamble. But I want you to think about something, okay? As you listen to him nitpick the evidence, and you heard the examination, you heard opening statements, you heard the examination of various witnesses, and so you already know it's coming. But as you hear him nitpick the evidence, I want you to keep this question in the back of your mind. What do any of these things really have to do with the death of J.D. Angeles? Did poor parenting, missing well baby doctor appointments, misusing a car seat, did those things kill this child? No, those things didn't kill this child. Did it? With testing some.
Oh, god damn it. Was I muted for that whole time? I hope I remember to timestamp that later. Basically, all I was fucking saying that the defense attorney nitpicked some stupid ass shit. Like, such as, he was trying to say that the father of the child drinking and driving was endangering the kid. And, yeah, fucking, I don't know. It showed me that I was muted. So sorry if I'm repeating this twice, or if you didn't hear it, then I need to repeat it twice. I don't know. But anyway, fucking, yeah, just in case. So, and nothing that he nitpicks on is relevant to the case. Like, for example, when he was nitpicking on the drinking and driving, yes, that's problematic. I highly, highly disagree with that. That is something to hold him accountable for, but that's not what killed the child. And it doesn't clear his client's name. He never nitpicks on shit that would clear his client's name. He's just trying to make the other people involved look bad, and there's no perfect victims. There's no perfect human.
Dirty diaper that came out of the dumpster, or testing the vomit that was on Jay Williams' shirt and jacket, with testing those things, with interviewing some people in Colquitt, 50 miles or 75 miles away from, not it's more than 50, right? Like 75, 80 miles away from where this happened. We're going down to Colquitt and interviewing some people. Would that put somebody else in the room with Trinity Poague and the baby? Would that put somebody else in a position to inflict this trauma? No, those tests, those things, you're not going to get that. Did a bottle of rum or a dispute or a fight over social media passwords kill that child? No. What killed that child was beyond dispute. It was a massive, tremendous blow to the back of his head that cracked his skull from here to here. So, there's a smoke and mirror show coming, though. I promise you. There's a smoke and mirror show coming. And I was thinking about this in terms of, like, how do you see through smoke? How do you clear the smoke? Right? Firemen, okay? There's a house on fire. Firemen go in and there's smoke everywhere. They have to get through. They have to navigate through. The smoke can kill them. I mean, if you just breathe it in, it'll kill you. If you just accept it, if you just let it be there, if you don't fight against the smoke, it'll kill you. So what they do is they put on goggles, and a face mask, with a breathing apparatus and a breathing tank, so they can navigate their way through the smoke until it clears and they can get to whatever it is they're trying to accomplish. That question, ladies and gentlemen, that question is that provides your goggles. Okay? That provides your breathing apparatus for getting through and seeing through the smoke that's coming. That girl killed that little boy. She killed that little boy. She cracked his skull out of anger, out of malice. We'll talk about that later. She killed that little boy. She's the only person who could possibly have done it in the time frame in which it had to have occurred. Don't let these other things that don't have anything to do with the answer to that question, who killed J.D. Angeles? Don't let these other things cloud.
Oh, and another thing, the defense attorney had also tried to blame the liver laceration on the baby. He tried to blame it on the medical doctors, and I don't think that made him look good at all. Yeah, like, he'll be blaming it on everything but that. So, sometimes when people have, their closing statements and they try to basically gaslight everything, maybe it could work. But because of how this defense attorney behaved in this entire trial, I'd actually be shocked if he takes that approach still with this closing, if they're going to go with that, because they're just going to look at him and be like, yeah, you're full of shit, possibly. I haven't even seen the defense. This is the prosecution speaking, and I've been talking about the defense the whole time. But that speaks to how bad I feel strongly about the way the defense handled the case in all the other days we've seen so far. And the prosecution, I feel like he could have delivered it better, but the points he's making are like spot on in my opinion.
Out your vision and fob your mind. Thank you.
Thank you, Mr. Lamb. I'll let the jury step back in the jury room while the attorneys switch over their computers and such, and go ahead and take yourself.
Oh, damn, is he done already? Apologies, I'm knocking on chips over here. Yeah, I think he's done already. Fuck, man, that was quick. Alright, it looks like the defense's closing argument is longer.
We'll be back in 10 minutes.
We're going to double time here and skip through. Okay. The defense infuriates me. I'm going to try to let him speak. I find myself pausing the video a lot when he talks and interrupting because he infuriates me.
Oh, Lori's not back yet.
Oh, I think they're about to come back here. Here we go.
You good? All right, let's bring the jury back in.
Oh, bring the jury back in. Oh no, she wants to cry again. And I also have a theory. So in this case, in days 1, 2, and 3 of this trial, I have caught her smiling, and I'm noticing when the jury's not present, she loves to be laughing about this thing. But when the jury is present is when she wants to cry. And I don't know if anybody else is noticing the timing on that.
Good morning, ladies and gentlemen. This will be the last time that I have an opportunity to speak with you. I have as many as 2 hours to speak, and I can assure you it won't be that long. And I'm sure you'll be glad that it will not be. But what I have to say is important, because some of the things that the district attorney said just a moment ago, I'm not going to try to address that particularly, except one thing he said was that this is an easy case. And when I first came before you, I told you this was a case in which the state had a case that was filled with suspicion, but
it is easy. It is an easy case, and it's not even suspicion. These are facts. That's what if he had a valid alibi for his client, or if there was a valid explanation for what the cause of death was, or a valid person to blame it on that wasn't his client, then I feel like he could make this argument and it would work for him. But because he doesn't have any of that, and because all the facts point to his client, this just makes him look like, some people are going to look at him and be like, dude, are you stupid? Like, and it's not to be rude. It's just like a straight up fact. Like, this is not the approach I believe you should be taking when your client looks this guilty. Maybe I'm wrong. Maybe that's just how it's supposed to be done under court procedure. But if you have a choice to do it differently, because optics, the jury, I believe, would think he's full of shit.
empty on evidence. And then this is exactly what I mean. Would the state consider this an easy case that did not require any investigation, did not require much to be done because they were so sure of who they thought it was that was responsible?
What the fuck you mean did not require investigation? Sir, we've already seen the prosecution witnesses, and I'm positive that there has to be more people on the staff involved in these cases than who was actually interviewed. I believe it was point leaders on the case that were interviewed, or the people who were the primary person of contact or the one on the job at the time of this case were the ones who were the witnesses, right? But I know that just like with the way these departments work, that there would be more people involved than who we saw testify. So we saw not only, I believe, 2 doctors from the medical treatment team, as well as the medical examiner, as well as the coroner, as well as police department from the university where it occurred, as well as, believe, at least 2 investigators from the Georgia State investigation thing. I don't know what the fuck they're called, alright? I could have fucked that up. But, you know, Georgia Bureau of Investigation, I don't fucking know, something like that. But yeah, so we've seen all of that. And he wants to, and it's just like he wants to be like, oh, you didn't do enough investigation. How many more experts' opinions do you need? How many people does it take to screw in a light bulb? It's just like...
They fail miserably in every phase of the investigation otherwise. And if you look at the evidence, the question that was put on the screen about whether or not any of this has to do with the death of the child, this is not a case about whether or not the child died. We all know that. If that is what the state needs to prove, they have done it. And we concede that. That is not what this case is about. This case is about the state of Georgia accusing this young lady of a very serious crime of murder. And when the state makes a claim like that against someone...
His argument is literally she didn't do it because she's a white young lady. Is that his fucking argument? For real? Yeah.
It is their sworn duty to prove it. And not just a little bit, but prove it beyond a reasonable doubt. That meaning that if there's any other reasonable explanation for what could have happened, any at all in your mind, you cannot come back with a guilty verdict. Now let's look at what we have in this case. I'm going to go through several things. You can imagine I'm having to unwind quite a bit of evidence that's come through these last 4 or 5 days. But I'm going to try to take you through, not piece by piece who testified, but about certain things that matter. And the first one is, and a very important one is, that Agent Gibson came and testified. You remember, he is the person who said he is a crime scene specialist. He also has special training in crime scene preservation. He said he was told to go to a particular location where they believed the crime scene occurred. That would be the dorm room at the Oaks of Trinity Poague, where also Mr. Williams had been staying and the child. Now we know when he went there that really quickly after arrival at the hospital, an officer was posted at the door and it was taped off and someone stayed there, and so no one came back to that room after Mr. Williams and Ms. Poague left that room. We know it, one, because it was roped off and had officers there, but also they got video. So we know if someone had come through in that dorm and tried to mess with anything from the time they left until the investigator got there. That's not possible. The investigator says that's right. So we don't have a question about it. There's been a cleanup.
Oh, so you admit that there was an investigator involved, but you said there was no investigation. So which is it? He's hypocritical.
In this room. Has there been some tampering in this room? Nothing has happened in this room except the people left, and they left it in whatever condition it was in at the time they left in a hurry to go to the hospital. And what did he tell you about the investigation? He said he took photographs of everything that he saw in each room because they like to show the setup of each room to begin with and let you know everything is there. And then his secondary purpose and most important purpose was to gather any evidence that he felt was important to the case. That could be used in this case to prosecute the case, whether it be against Ms. Poague, whether it be against Mr. Williams, whether it be against some third party, who knows, but to gather that evidence. And I asked him, at the conclusion of questioning him, isn't it true that you did not obtain a single piece of evidence that was any use to you in this case? And he said, yes, that is true. Not one thing. I asked him, did you find any blood in that dorm room anywhere in that location? And it was.
He, in my opinion, is misrepresenting what happened. Because what I interpreted as what occurred is he was questioning the investigator as to if the investigator retained physical items for anything in the room. And the investigator said, no, I just took pictures. And for us, that counts as the documentation of the evidence. And there are certain things we just really don't need to retain if we don't have a reason to test. So he was trying to act like the investigator didn't do a good job for not keeping a dirty diaper, for example. And the investigator was just like, there would really be no reason in this case for me to keep or retain a dirty diaper. And when we know for a fact this is the child that died, like, there's just no need to keep a diaper of poop in this situation. We know that this belongs to this baby. There's no other baby it could have belonged to. It's just like there's no need to keep a diaper. Like, you know what I mean? He said he documented everything in the room, and there was nothing found that could indicate the source of the weapon, which is very common in murder cases for a murder weapon not to be found. And mind you, I had said before that I believed it could be possible that a murder weapon or something like that, or any other evidence, could have been hidden or moved between when the father of the child took the baby to the hospital and then the girlfriend joined him after. That would have been a window to hide any evidence related. But I also believe that they had the footage from the apartment complex, from the dorm room. So if there was anything to show for her that could indicate that, I do believe in that footage, I do believe it would have been put into court evidence potentially. So maybe I'm wrong, but that's what I questioned. Or if something happened, maybe it was with her body, like, she was able to physically attack the child she wouldn't necessarily need to hide evidence if she was the assault weapon as well. Or it could have been something like a shoe, or boots or something like that, where there may not be any evidence remaining that they would have realized to test for potentially. I don't know. I'm speculating. Who knows what it was? But what we do know is she was the only one with that baby at that time. So questions remain, and I think they will always remain, because who else knows but her?
The answer was no. Did you collect any type of human fluid that you thought would have been beneficial to tell you something? He said, no. I said, did you find any type of weapon in that room that might have been used, any kind of instrument that could have been used to cause blunt force trauma? Did you find a bat? Did you find a paddle? Did you find some statue that's sitting in the room that might be used? And his answer was, no. I found nothing that I think could be used as a weapon. I asked him, did you find any place in that room or those couple of rooms where it looked like someone?
So I also believe, depending on the type of material of the floor, if she did do something to the baby, such as slamming the baby against the floor, that wouldn't leave a mark on the floor potentially, or maybe if she injured the baby with the chair, because she's the one who keeps bringing the chair up, would that have left a mark on the chair? Who knows? Not necessarily always, So I think it's also possible that perhaps the murder weapon was around there, but there was no visible damage to the weapon to think that it was a weapon potentially as well, is a possibility.
Someone could have hit, an arm of a chair sitting out, or a high countertop that might have a sharp edge, anything that looked like it could have been a child pounded into. Did you find anything that would have drawn your attention when you got evidence? He said, no. So what about the walls? Did you look at the walls to see? You would look at that. Yes, I would. Did you see anything? His answer is no. So we know that the state claims they have a crime scene, but a crime scene in which they have obtained zero evidence from. I'm talking about a little evidence, zero, unless you believe Agent Ford, I think, said they did get a receipt from Walmart that proved they went to Walmart to buy the drinks. I'll give them that. That's it. Nothing of evidentiary value from a supposed crime scene. Now remember, they said this is a violent, massive force injury. Yet there's no evidence within that room of anything that occurred like that. And I remember I asked the agent, I said, have you ever heard of luminol? A lot of people I know have heard of luminol. Luminol is used to spray it across the room in case you don't see blood evidence. But just because you don't see it doesn't mean it's been cleaned up or it's only a small spot and you can't see it with the naked eye. Spray with luminol, turn the lights down, turn on a certain light, and if there's any particular speck of blood, it'll light up. And I asked, did he do that? And he said, no, he didn't do that. He didn't offer
Okay, but this injury had no external bleeding. So what cause would there be to look for blood spatter when there was no external blood bleeding present? You know what I'm saying? So it's just like this, where you keep saying, well, they didn't test for blood spatter, so therefore, trying to invalidate their argument. There was no external bleeding present, so what reason would there have been to test for blood splatter if there was no blood splatter? The jokes write themselves in this case.
an explanation why he just didn't do that. It is inconceivable that someone, individual, intentionally, did harm to this child in that way.
Did you check for monsters under the bed? If you did not check for monsters under the bed, then you must acquit.
And it didn't leave some type of forensic evidence in that room. And remember, you also told the child supposedly was throwing up on the way out of the room, and there was no throw up coming out of the room into the hallway. No evidence. The state is required to provide evidence. A defendant comes into a courtroom under the law cloaked in innocence, and it does not be removed from the defendant.
So he doesn't think that the camera footage from the dorm room is evidence. He doesn't think medical examiner testimony is evidence, coroner testimony is evidence, the medical doctor is evidence, the dead body being evidence, the evidence that exists of where the father's location was in terms of the Walmart receipt, the pizza boxes, the Walmart bags, and the camera footage. So there's a lot of circumstantial evidence. He may be correct that there was not the direct evidence of what happened at the time of what is believed to be the fatal injury, but to deny that there's any evidence present or that the circumstantial evidence isn't enough to, do something, I feel, because it's just, I feel it invalidates the justice system entirely. Rarely ever is somebody, unless they really have a guilty conscience, rarely ever is someone gonna be like, yeah, it was me, I did it. You know what I mean? Like, I don't understand his logic here.
And that from the time they enter until they leave, unless some actual evidence comes in that can disprove that innocence beyond a reasonable doubt. But their crime technician, the one that's charged with collecting evidence, has collected nothing. So we don't know if that's a crime scene or not. We didn't get any evidence from it if it is. And we also know, when I interviewed and questioned most of the arresting officers and GDI agents, anyone that was involved in this case, the autopsy people, all of them, we do know that the child suffered from blunt force trauma. We know that. But not a single person that I asked, number one, I asked each one, can you say, based upon what you saw, who did that? And the response for each of those persons is, no, I can't.
When none of them were there, that doesn't invalidate their testimony, and it doesn't invalidate the evidence that it exists for she was the only person with the child at the time span in the window of time that the injury occurred. They're not legally allowed to say without a doubt that she's the one who did it, but they could all say, from their opinion, she's the only one around when that fatal injury occurred. Which is another way of saying she fucking did it, bitch.
I can't tell you from what I'm looking at, from what I observed and what evidence I had in front of me. I could not tell you. I could not say, yeah, I can tell you so-and-so did it. I can't tell you that I took ballistics from a gun. I can show it matches John Brown's gun. No.
Because they're only allowed to give their expert testimony on the actual injury or as itself. You know what I'm saying? When it comes to the medical examiner and the person who did, the person who did the autopsy, which is the medical examiner, the other doctors who actually practiced on the baby, as well as the coroner, they can only tell you what is the cause of death. They cannot tell you who did it. And the people who investigated it believed that the person who did it is Madison. But then you're saying they didn't investigate, but they did Then you're saying they were the ones investigating. Duh. And now you're saying they can't tell you who did it, but they can tell you who did it, or there wouldn't be a charge against... Did I say Madison? Her name's Trinity Madison Poague. Whatever. You know what I'm saying? So, it's like he goes all over the place. It's like, make your fucking mind, dude.
I can't tell you I found a weapon that was owned by somebody and now it's been used. And more importantly, I can't look at the body and tell you of a single mark that shows there's anything been done to it other than it has blunt force trauma, but not in a sense of you can see a paddle mark or a baseball mark or something that says someone did this to this child individually. They have none of that. So they don't know who, but they also don't know how. I asked the autopsy people. I asked Agent Ford. I asked every one of them. You know?
There are a lot of murder cases where the exact weapon is unknown. That doesn't invalidate the fact that someone died from blunt force trauma. And that they couldn't have done it to themselves. You know what I'm saying? Like the way that this injury occurred, the doctors already ruled this wasn't the type of injury that could have been some sort of accidental fall or something that he did to himself. That was just highly unlikely. It was just really basically almost impossible is what they were saying, in my opinion. So, because this baby had fractured skull and bleeding, internal bleeding from that. He had a liver laceration and he had multiple bruises is what they were saying. That's not going to happen like that from just a random fall. So, and the only person this baby was with is with Trinity Madison Poague at the time of this fatal injury. And he's trying to say that's not enough evidence to say she did anything. If there was, for example, say there was like a cupboard that, like those like pantry cupboard thingies that are not nailed into the wall, for example. Say it was offloaded, or say the baby was strong enough to pull it down or something like that somehow, and like something heavy fell on the baby, and there was evidence of something that like broke and was fallen, and or something pulled onto the baby or something like that, then I think there could maybe be an argument of like this was some freak accident. But in this situation, it's just like, there's no evidence to say that there was anything else that could have caused harm to the baby other than her. It's like if your client had a gun and there was a bullet wound and you're trying to say, and the only person that was with the person with the bullet wound was your client, and you're trying to say it must have been someone else who shot them. It's kind of like that. And that there's no evidence that the only person with a gun that was around the person shot is the person who shot the person. That's kind of what he's doing, you know? What?
How? What happened? Well, they've got some theories. Maybe this, maybe that. I don't know. We just know the child had significant injury. So now we don't know where the crime scene is. We don't know necessarily who did it. And we don't know how they did it. We don't have any type.
We do know where the crime scene is. What the fuck you mean we don't know where the crime... We saw the video footage of where the baby was picked up from the dorm room. We know from video evidence that and text message evidence and witness testimony that the baby had spent the night there the night prior and that the baby was fine the night before. They believe the baby was fine whenever the guy went to the Walmart, not to the hospital, to Walmart to get pizza. And if the baby wasn't fine, then why would the client, Trinity Madison Poague, not have called the police, not have called the hospital herself, right? And we have evidence she called the father to tell him something was wrong with the baby. Fucking, you know what I'm saying? Like, so we know exactly where it took place in the dorm. You see how he contradicts himself. He makes himself look stupid. If there was a situation where you could actually prove, like, say that the injury that occurred, that how the baby died from, say there wasn't the time span with the way that the bleed out occurred, where like the baby could have bled out over 20 hours instead of the 30-minute window, then I think he could make that argument. But because the baby only had a certain time span from when the fatal injury occurred to when he died, of how long he had to live, that does not work because we know where he was in that window of time. So there's so many loopholes in his argument. It's not a good defense for his client.
Weapon. We don't have any kind of instrument that supposedly caused it. And you're left with some speculation of, well, could it have been just the hands of someone, just the person themselves? Could they have done that themselves? And somehow grab him, somehow punch him? Could Trinity Poague have done that? Should you grab a child and done that with her hands? Well, you would think if that's a possibility that the GBI would have looked at her hands, photographed her hands, would have looked to see if there was any signs that she used her hands. Because remember again, this is a violent, forced, blunt force trauma. She used her hands because of that. And you talk to her within a few hours of it, and you look at those hands, it's going to show. Whether they're going to show redness from blows, whether they're going to show scratching, whatever it may be. And it took quite a bit of pressure, of course, according to Dr. Clark and some of the others that testified. And we also know Mr. Williams was around the child. Who's more able to use great force to cause injury? Who knows who caused injury? But if there is injury, we do know from Mr. Williams, nobody looked at his hands either. They didn't do anything to check that. And they didn't do that because they weren't going to check on Mr. Williams anyway. Because they were already down the rabbit trail they went down to begin with.
He keeps trying to imply that it could have been the father of the child that has done this. But mind you, if that were the case, the girlfriend, herself, still never called the police, never filed a police report, never reported him for abuse, never tried to get help for the baby if that were true, and never took the baby to the hospital. So, even if that were true, in my opinion, that would just create evidence that she was complicit and enabling and part of the abuse. It would not clear her name, if that were true. You know what I'm saying? Even what his arguments do not make his client look less guilty, they only also implicate the father of the child.
Trinity Poague is guilty, and we don't need to look at any other evidence. Hey, you know
But the father of the child, I don't believe he did it because I believe the evidence shows he wasn't there. I do think there are certain things you can criticize about perhaps his lifestyle, his relationship choices, the drinking and driving, the eating, dietary, like health and stuff, and how healthy made the baby have been eating, there are some valid criticisms, I think, from what has come out in the trial, if any of that is true. But when it comes to, does any of that think I mean he killed the baby? No. And he can prove where he was. She was with the child. It's just,
That because I talked to Agent Ford, and I asked her about what their investigation did. We know that she talked to everybody that she knew in that dorm, or had agents with her do so. Interview them all. Try to find out what they know. She got a phone. She had a phone of Mr. Williams. She did a few other things. She talked to different people. Well, then when I asked her about what effort she made to try to find out anything about Mr. Williams or his sister, Ashante Burke, what did they tell me? And the reason I asked that before I go any further, remember I asked that agent, I said, when you have child abuse cases, isn't it true that sometimes or often you find that a child...
My opinion and my understanding, the investigators followed each lead until they came to dead ends. Whenever the father of the child could prove his location and everything like that, they no longer were considering him a plausible cause because the timeline at that point no longer matched up. Then he was trying to implicate the sister, the father's sister or the child's aunt, so the father of the child lived in a different city than where the girlfriend lived, who is accused of murdering the child. And when the father of the child spent, I don't know how many days, but let's just say he spent 3 to 5 days at his house, and in that time frame, his sister helped him with the child. And he spent the other, give or take 2 to 4 days, with the girlfriend, who would then take care of the child in that time span. So they're also trying to imply that maybe the girlfriend could have been involved or something, I think, when they say, oh, you didn't look enough into not the girlfriend, the sister. When you didn't look enough into the father and the aunt or his sister, So she was not around the baby at any point in the time span of the fatal injury, so that cleared her name. You know who was around the baby at the time span of the fatal injury? Trinity Madison Poague. That's why the investigation continued with her. In every investigation, they only investigate the lead as long as they need to. Once there is evidence that can clearly debunk anything that would, that can clearly prove where they were and debunk the allegation, that's when the lead is no longer going to get investigated, because that's a waste of resources unless there's a reason to revisit it. So, if what has come up in the investigation continues to show where Trinity was the only one alone with the baby at the time of the fatal injury, why would you waste time investigating other people when you can see what the facts are with this lead? And this is the lead where the facts show she was the one involved. It's just, that doesn't make sense to me. And they did investigate. And matter of fact, you had a problem with the way they were investigated. So they were investigated. I believe, if I'm not mistaken, the father of the child testified that he was questioned 3 times. And the sister, his sister, the aunt of the child who passed, she was also investigated, I forgot how many times, but she was also interrogated, and she gave evidence on her phone to the investigator. So, to act as if they weren't investigated enough just because the fault lies with your client doesn't negate the fault with your client. So instead of discussing why or how his client's not guilty, he just tries to throw mud on other people, has been his strategy. It's real frustrating to watch. I have a hard time looking at it. Let's keep going.
Has had injuries before the situation that leads to their death. They kind of show they've been abused in the past, but now it's occurred. And she said, well, not all the time. And I said, but sometime, right? And she said, yes. And I said, isn't it important to then look, to try to see to try to find out if that's the case. Now, she discounted and said no. Why did she say no? Because we already had a dead child here. I know it was in that dorm room. I don't need to look anywhere else. That's what she told me. I don't need to look anywhere else because I know where it happened. That's it. I don't need to look. I said, did you go to the house where the child lived and at least look at the house? No. I said, you wouldn't even know how to get there. Right now, if I wanted you to take me to where the child lived, and the answer is no, she wouldn't.
What is the point in that, though? You see, he's constantly trying to use shit that is not relevant to this case to argue that makes his client not guilty or something. The baby was not in the father's house at any point of time in the window of time from the fatal injury till the time of death, okay? So what point would there be in going to search the father's house for evidence of the death when the baby wasn't there for anything resulting to the death? What was the point in that? I don't understand. If they didn't know the window of time from the fatal injury, how long it would have been, from the fatal injury to the time of passing, if that was up for debate or questioning, then I would say maybe there's a valid argument to go see if there's anything in the father's house that could be evidence or point to cause of death. But in this situation, they know that the injury, because of how the bleeding occurred, that the baby only had a set time frame to live from when that injury happened to when the baby died. So therefore, that argument doesn't make sense because of the time frame of which the baby was at the girlfriend's house.
Not even looking to see what type of condition was she living in. I don't know. No one knows. They didn't investigate it. Did they talk to any neighbors to see anything about the relationship going on? No. Did they talk to anybody that he worked with? No. Did they go to his workplace? No. Did they make any effort to find out? No.
Because there's no reason to. And you're the one who brought in the witnesses that testified to how the baby was treated, in my opinion. The only witness that they brought in was the girl's roommate. But his witnesses for her only helped the prosecution. Like, it's so hard to watch this. Okay, let them speak, goddamn.
Because they'd already gone down that trail. And they decided at that point that this is the story we'll tell, and you'll see, and I'm going to talk about this in a little bit, about the testimony being shaped to make sure it fits over here, and struggle and fight no matter what to keep it there. Because that's what they decided early on, and they don't want to break away from that. But now you have a case, you got no evidence. None whatsoever about how the blunt trauma was occurring. You don't know for sure where it occurred. You don't know who did it. But they say
he keeps saying you have no evidence. It is true they don't have the murder weapon, but it's not true that they have no evidence. You can have evidence on a case and it not be the murder weapon. That itself makes him look bad. Okay.
Easy case. They say now we just got to look at it and we should be fine. But maybe the most important witness that came in the courtroom was the one that's not tied up.
Okay, if the footage showed that the boyfriend and the girlfriend, that the father of the child and his girlfriend were both home in the apartment together, then I would think that he is valid for saying you have no evidence that it was just her, right? But if the Walmart receipt, and the Pizza Hut evidence didn't exist and all of that, then this would be a valid argument. But because there is this evidence and everything like that, it makes him look like he's just intentionally trying to gaslight. I think you need to use these arguments when it actually works, when it's actually aligning with what's happening. Because if you're just trying to dismiss and gaslight people for the sake of arguing for your client, to a point you have a diligence to your client to defend them, but on another level, if the jury doesn't believe you, they won't believe what you say to defend your client, and you looking bad makes your client look worse. There's like a balance there. Like, there's a way to argue on behalf of your client without making yourself look stupid or making yourself look like a liar or making yourself look like an asshole. But he makes himself look like a liar and an asshole with his own arguments.
And that's what everyone else, that's not buzzing. The rest of these folks, they got some allegiance one way or another. GBI can say what they want to. Dr. Clark been working for the GBI forever. Yeah, he's going to testify for the GBI, and you can bet your bottom dollar he's going to support whatever side he came in the court to testify about. He's not going to break off that. And you got these law enforcement.
When he said bottom dollar, I'm like, no, I'm back on it again. He should have been an auctioneer. He missed his fucking calling. Yeah, welcome back, Exposure. I appreciate you. Hope your phone's alive and well. My phone is not alive and well. You see this bottom half of the screen here, how it's faded out and dark? That's because I dropped my phone. It should all be the same color, but this is faded. Oh, that's a calculator. This is, that's not working. Yeah, okay, this is faded out. Anyway, sorry. Why am I like this? Okay, let's move on. Back to this. God damn, man. We're not even like, we got like another hour to go on this part of the video, but I can't shut up for it because he pisses me off.
They've already gone down the rabbit trail. They decided what they know. They're not going to break off. But Dr. Busman didn't ask to be in this case, didn't want to be in the case. He had one duty and one thing he had to do, and that was he was an ER doctor, and he had to try to give some type of treatment for this child and see if he could save it. That was it. And then he got called to come testify. And he had to do that. I'm sure he didn't want to. As you could probably see, at least somewhat, he wasn't that comfortable in testifying, but he testified. So you can bet he was trying to be truthful about what happened. He told you some things that were extremely important. And one of the things that, as important as anything, I believe it's exhibit number, let me make sure I got the right exhibit here. Exhibit 26 is medical record from the treatment that he gave the child when he came to the emergency room and all that happened. And that record's already been introduced. It's an authentic record. You're going to get it back with you. You can look at all of it. And it's got some pretty important stuff that's contained in it. The most important stuff it's got that's contained in it, if you look at that document, and I'm going to ask you that you do when you get the chance at the end of this trial, you're going to see that there are numbered pages. There's two sections of numbered pages. You first look in it, and there's just a bunch of preliminary stuff with no numbers on it, maybe 20 pages or 15 or 20. Then you'll come up with pages 1 through 39. Well, in that section of 1 through 29 on page 23, you'll need to look at. And then you'll see a second section of 1 through 28, and on that section you need to look at page 20 and 21 of those. Now, why do you need to look at those? Because those medical records on 3 separate occasions say within the record that the father presents bedside and states the child fell around 5 minutes prior to arrival. Why is that important? First of all, we know from
Okay, so what he's referring to right now are 3 cases about children who experienced injuries which resulted in a different type of like, I forget what's the word, like a hemorrhage or hematoma or some shit, like a different type of injury which caused different type of bleeding, or these kids had longer to live because all of their injuries were similar to each other in these studies. So what he's citing, they all had similar injuries to each other, they all had better chances, but their injuries were not the same as the injury to this baby, is what the medical doctors already testified. And what he tried to do was, so these sources, what he's citing was referenced by, let's call this reference B, or from person B. So a reference from person B. So he asked one of the witnesses, I think it was like the medical examiner, and he said, so you respect person A, right? And he was like, yeah, I love person A. I've gone to person A's seminars. And this isn't word for word. I'm highly paraphrasing, summarizing. And then the defense attorney was just like, okay, so if you like person A, well, person A cited person B. And person B said all of these things that he's referring to right now. And the guy responded with, person A only referenced person B as a contradictory or deferring or opposing opinion. Not to agree with her, but to show evidence of a different view, because that's what you do in academia. And he pointed out how these injuries, he explained it in better terms, in the medical words too, and how the injuries that this guy's referring to from these falls were not nearly the same types of injuries of what happened to this baby. So he was also able to debunk that already. This has already been debunked if it's the same thing that he's referring to. So yeah, I'm just putting that out there. This does not help his case. It just makes him look worse for me. Because why is he still bringing this back up as if that helps him when we already know that those babies had a very different injury that would give them a better chance at living than what the baby who died did, you know? So it's not the same case. It's comparing apples to oranges.
Dr. Buzzin, that the only person bedside was the father. The girlfriend, Trinity Poague, was not there yet. So the only person, it's not a mix-up that they said he told her. We know that because it's in this record. Now, what was interesting about that, did you see how the state struggled so hard when they got back up to pull that out of the record? To say, well, didn't that get entered a few hours later? I mean, that didn't happen right away. Trying to insinuate that maybe some mistake was made. Maybe that's not really what got said. On and on. Buzzman, you know, you can see he was most confused. Why is that happening? But I'll tell you why that's happening.
No, that's, in my opinion, okay, so the father's attorney repeated what was told to him, which the girlfriend had told him that the baby fell, so that's what the father had repeated. And then later the father said he didn't know what actually happened. And the attorney has been trying to invalidate them the whole time on that, but it's like, how else would he have known that if that's not what he was told? Like, it doesn't help him.
Because they didn't like what Buzzman had to say, and they didn't like what he had to say because it's a lot more than just the father coming in with a story that we know is not true. We know that the child didn't fall 5 minutes prior. I don't think he did. Or if he did, maybe the father knew it. And
God damn it, I just realized I was muted. I have no idea how long I've been muted for. That's really depressing. But anyway, so I guess that's just gone. I was just bitching about this dude. Fuck him. Fuck it. Whatever. I'm not even gonna bother. I was just, you know, what? Fuck it. I can't even. I was muted. Sorry, guys.
we didn't know it. But they tried to then claim that maybe Ms. Poague had told him that, and that's why he told the doctor that. Remember when I got Agent Ford up and started asking her about the interview she did with Mr. Williams? But before I put her up, I asked Mr. Williams, did you tell the agent when she first interviewed you what you believe happened to cause the injury? He said, first interview, yes, I did. Second interview, I said, did you tell her? Yes, I did.
Okay, I think I was bitching because he keeps trying to act like... So the father of the child has said that he believed that the baby fell because, you know, the girlfriend told him that, right? So that's why he had first thought that, but then he wasn't sure. So he first said that, and then he went and said he wasn't sure, and now he's part of, you know, the team helping prosecute her. So from all of that, the defense is trying to act like, oh, so the father wasn't telling the truth to begin with then, huh? But it's like, he was telling, he's always said what he believed happened. You know what I mean? Like, the fuck, I don't know.
And I put the agent up and asked her, can you tell me, here's your summary, if you look at it, do you have it from the first interview that first occurred when you got there with Mr. Williams? Yes, I do have it. It's 10, 12 pages long. Okay. Can you turn to a certain page there and tell me, if you're looking at that, tell me anywhere do you see where Mr. Williams says what he thinks caused this injury? She said it's not there. In fact, what she read from that report was him saying that he came back to the room and asked Miss Poague what happened, and she said, I do not know. And then it said that nothing else in the report. Now first, you know, the agent wants to avoid that too. She doesn't like that. She's protecting her story now, trying to make sure that we got the blame for Trinity. That doesn't fit the pattern. So she said, well, you know, it may be in the report somewhere else. And what I told her, we got time. Read your report. Go through it. When you get through, let me know if you find it. Well, they sat here a few minutes, 5 or 10. Guess what? She finds that up, look, and I said, you find it? She said, no. Well, then, here came the real squirm. Let's say maybe I just didn't put it in the report. He may have told me I just didn't put it in the report. That's interesting. You got a trained GI that is taught that anything of importance will be put in a summary report to make certain that you're preserving that. We know that. We've heard testimony about that to some degree. But yet, someone tells them because they believe of what could have led to the injuries to the child, and they don't put it in the report. But maybe they got told and forgot it. And she says that on the first one.
So, you just said that he claimed he didn't know what caused the injury. And you're mad that they didn't think it was important to document that he was unaware of what caused the injury. But he wasn't around at the time the fatal injury occurred, so how would he have known? So therefore, why would that be important to document when it's obvious he wasn't present then? And he's acting as if she wasn't taking notes at all. You know how hard it is to get every single fact down? You're writing as much as you can, man. It's just like thoughts and prayers.
Well, the second report, I asked her the same litany of questions, said, what did he tell you there? And he said in that report, absolutely, he did not know what happened. He didn't say, but my girlfriend told me something. He didn't say that I know something. He said it didn't happen. So we know.
Why does that matter? He wouldn't know what happened. Like, see, this is what I'm saying. He's harping on him, like, so the girlfriend, and the defense himself has already been testifying that the girlfriend has claimed that the baby fell. So if that wasn't their defense and there was a reason to argue that if that's what happened, then I would see why you would be arguing over this, right? Maybe there would be a reason there. But in this situation, that's what their defense hinges on, right? So their defense hinges on he's trying to convince the jury that the baby just fell. That's what they've been that's been their defense. So now he's basically saying that the father's testimony is invalid because the father had originally claimed didn't know what happened, and then was claiming that the baby fell because according to the girlfriend, that is what happened. And if I'm not mistaken, I think it was the security guard or a doctor at the hospital, if I'm not mistaken, that also testified that the girlfriend claimed to them that the baby fell as well. So it's already been out there. So depending on, you know what I mean? It's just like, so I don't think that harping on this when that's what your defense is, so you already know it's a fact, so why would it matter if he said that when it's what your defense is hinging on? But he can't verify what happened for when he wasn't there, so he's just saying what he's processing as he goes.
When he went to that hospital, no one had told him anything about falls. That came from his idea. That came from his mouth. Now, if he got interviewed by the GBI and he knew it, you can bet your bottom dollar in that in only an hour or two.
Are we living in the same reality? I don't think I'm making shut up. I don't think that the father of the child was making shut up. I don't think that just came out of nowhere. Am I remembering wrong? Is that what gaslighting is? It's just, this is like making you question your memory, but I don't know. Like, cause there is a chance I'm remembering wrong, but like, dude, I don't know. I just had a complete different interpretation of what had happened.
After all this occurred, he would have said, yeah, the girlfriend said this. So we know that came from him, but we also know he didn't just tell the hospital that. Lieutenant Allen told us. He came up when it was going on, remember? He saw him come into the emergency room. He saw him standing in the doorway watching while they were doing the workup. He pulled him back and talked to him and asked him what happened. And guess what he said he told him? That my son just fell face down a few minutes ago. Again, twice he's told that version. Twice he's told a different version to the GBI. And you know, if you really get down to it, looking at some of the questions for Mr. Williams, let's talk a little further. Remember when he got on the stand, he told those two things that it seems pretty apparent that maybe they weren't exactly on the up and up what he was saying. Well, let's get to the third one. I asked him about being interviewed the third time. And the third time was important to me, maybe more than some other people, but I wanted to know, at the time that he was interviewed, did the GBI agent allow his sister to come in and be interviewed with him in concert? And he said,
I've already harped on this. I don't want to go down that road again. But yeah, he's over there. He's already said that he was interviewed separately, but the agent had them in together whenever she was getting information off the sister's phone. And that's all they were doing, was getting the information and providing the context. It wasn't a full interview. So, and he's trying to act like that's unethical or that they're liars. And they're all testifying the same statement as to what occurred. So,
Well, yes, she came in, but when she came in, I left. I said, so you're safe. If they asked her any questions, you left. And he first said we wasn't really asking questions, just looked at cell phone stuff. And then he said, no, she asked anything, I left the room. That's what he said. That's what he told us, right down there, wasn't it? What he said happened. And that's important because, remember, I was asking the agent earlier. I asked her when we were talking about
my understanding was he was saying he left the room whenever they had their official interview together. I don't think he clarified or said or implied that he necessarily wasn't in the room for that phone call statement. Maybe I was wrong for that. I believe he was saying he left the room whenever they did separate interviews. He discussed being in the room at the same time with his sister. So I took it different from him.
Mr. Williams and Trinity Poague. I said, when they were at the hospital, did you just interview them together? I mean, they were already there together. She said, no. And I said, why not? She said, of course not. I wouldn't do that. Why? She said, well, it wouldn't make any sense. You would divide them up. I said, that's because it's protocol from the GBI. And she said, well, I wouldn't say it was necessarily protocol. I said, well, you think it's from training? And she said, well, I think training might tell you to do that, but it's common sense that you would never put two people in together to interview them. I said, you wouldn't do that. She said, no, I wouldn't do that. Well, now Mr. Williams talks about that. And I brought the agent up on the witness stand. And I asked her about it. And she got amnesia. She said at one point, it's been 2 years, I'm not sure. Is that the standard we're using here for this case today? That it's been 2 years?
But in this situation, the sister was not involved in this case at all. In this situation, at that point, had they not already cleared that the baby was only with the girlfriend and the father of the child, so therefore the sister could not have been involved. So this wouldn't be her, the sister isn't a valid lead. This wouldn't be her doing any sort of conflict with leads because the sister is not one. She's just the fucking sister, in my opinion.
Years, so I'm not sure. So everyone that's come in from the police department, well, it's been 2 years. I mean, I'm not sure we can depend on anything if that's the case. I've been 2 years. I'm not sure. Are we to believe that agent hadn't reviewed her case file before she got here today? Or yesterday when you testified, or starting on Monday? She just came in after 2 years and just winged it? You bet your bottom dollar she'd already looked at everything. She didn't want to talk about that interview. And then, when we refreshed her memory, what did the interview show? Almost 20 minutes, interview by themselves, 40 minutes with him and his sister together. Now, why would it matter him and his sister? Well, it matters because him and his sister.
He's over here talking about how she didn't want to talk about the interview. She never said that though. So how can he just make these statements that never happened?
Who was keeping the child. We know from the evidence that the sister actually did more caretaking from the child than he did. She fought me about that some too. Well, I couldn't say that. He might have been some. Well, first of all, she can't say because he didn't do any investigation to determine. But we do know a few things. We know that he came to the college at least twice a week, every week.
I thought lawyer wasn't allowed to testify.
And he came every weekend, and most of the time without his child. 4 days out of 7, he is not at home. He does not have his child. He has left the child with his sister. She is a caregiver of this child. Now, she is a caregiver of the child, and there is some suspicion of the alleged abuse. It would make a lot of sense to try to separate people and talk about that some, not put them together so they can be
I don't understand him harping on this abuse allegation thing. He's basically saying that his client is innocent because he believes the father of the child and the father of the child's sister are abusers. Is basically his argument, right? But even if there was any indication of abuse, okay, why would his client have never called the police, never filed a police report, never tried to get help with CPS, none of that, never taken the baby to the hospital? It does not clear his client's name. It just implicates her in that situation as well. It doesn't help her, it hurts her, in my opinion. And also, in this situation, he's not making any sort of argument to show how logically it had to have been them because the baby was with them. Instead, he's saying, oh yeah, I know that the doctors testified to how this fatal injury was the skull fracture, but let me tell you, let's just say I believe this baby has been abused a long time, so ignore that the fatal injury was this skull fracture that happened with my client. Why aren't we looking into these two abusers who there's nothing to prove they abused a baby from? What? Do I disagree with choices that he has made that has come out? Yes. Do I think it's unhealthy? Yes. I think unhealthy is an accurate description. But abuse is different. You can be unhealthy and not abusive. There is a difference, and we should clarify that. Like, oh my goodness. And it doesn't, there's been no evidence to support this type of shit, it makes him look like he's not credible, and it makes his client look guilty, because how the fuck do you not have a better argument?
Interviewed and get their stories together. But that is a sign of what was going on here. Now, we're not worried about them as being any suspect. We've already decided this case. We decided this case when January the 14th came, by 5 o'clock in the afternoon, it was over. It may have been a couple more days before the arrest occurred, but
whenever they realized that from the window of time of the fatal injury to where the baby was located, which would have been with the girlfriend, there is not really a need to go investigate other people who couldn't have had anything to do with the fatal injury. Make that make sense. His defense hinges on invalidating the doctors on what was the fatal injury. And I don't think that there is reason to do that at this point. There have been cases where I've been like, maybe there is reason to question what the medical examiner put or what the doctor put, because there will be reasons for there to be suspicion, right? But in this situation, because, people get paid off. But in this situation, there's no reason to believe, in my opinion, that the doctors are going to risk their credibility in this case. Like, I don't know. I don't believe in his argument. I believe in the doctor's testimony over him.
The investigation had shut down, and nothing else was going to happen. You were just going to have to live with it, and too bad. Why? Because we got suspicion. We have suspicion. Well, it's a scary world out there if your government can all of a sudden just decide I'm a little suspicious.
I would say that evidence, the circumstantial evidence pointing to where you were the only person with the baby and now the baby's dead, isn't suspicion, it's circumstantial evidence. Especially when there's a skull fracture and multiple other injuries, the cause of death being the skull fracture, which had a particular form of bleeding and injury that caused the baby to die in a short time span, which can confirm that therefore the only way the baby could have died was from something that happened in your care. That's not suspicion. That's evidence, in my opinion.
I can arrest you. It's a scary world. But you have that going on, but think about that sloppy investigation a little bit more. It's not just that problem. Remember when
It's basically like saying, look, I know I just shot you. I know that the bullet inside of you matches the bullets from my gun. But arresting me for murder, for shooting you with my gun, you've got the bullet from my gun, that would be suspicious. You can't arrest me for that. That's suspicion. That's basically what his argument is, in my opinion.
I asked the crime scene specialist about the dirty diaper. Now, he already knew that was coming up because we had filed a motion to ask to test the dirty diaper. We wanted to see if it had blood in it. And I already asked Dr. Busman about it, and he said normally he wasn't sure.
Back on this diaper, what reason would there have been to test the diaper when the cause of death was a skull fracture? And we know whose diaper it is. There's no probable cause to waste resources on testing the fucking diaper.
You have blood in your system from abuse, but I got to ask, but you could have some trauma at times that causes you to have blood in your bowel system. Can you not? And he said, yep, you could.
And notice he never establishes foundation or reason to test the poop. Because there is none. Like, if there was something, to do with testing poop related to the skull fracture, maybe I would get it. But in this case, it's just, fuck.
I don't think the injury that's caused his death would have caused that, but it could be from trauma. It doesn't take a genius to figure if somebody punches you hard right in this area that you might end up bleeding from that area through your system. It doesn't take a genius to figure when you hear about boxers when they've been finished a hard 12-round fight that sometimes they bleed out the rear end from it for days on end. It doesn't take a genius to know that you got trauma in here, that you will have blood coming through, and it takes time. I asked Dr. Busman, how long? And he said, well.
Okay, so here's the other thing. So for the liver laceration, first he was saying that the liver laceration had to have been the medical doctor's fault because they didn't know how to do CPR right, is basically what he was saying. And then he was saying that they should have tested the poop because the liver laceration could have caused the blood in the poop. But the doctors testified that the liver laceration wouldn't have caused the bleeding, like the blood from that liver laceration would be more likely to be absorbed in the body. It wouldn't have like gone through the digestive tract out. That would have been unlikely, is what they were saying, if I remember correctly. So no matter what, this argument and line of thinking, and he's all like, well, you can't know that. And the doctors are like, yeah, we kind of do. That's how I got my degree, dude. I know how the body works. And he's like, the doctors don't know how the body works. Yeah, that's what he's doing.
Well, you know, you can't really say because obviously people's systems work different. Few hours to maybe a day or more. What does that mean? Well, it means there was blood in that diaper. We know a few things. It did not come off of that child on the day the child was taken to the hospital. The child had on a diaper different that they took off of that child at the hospital.
I wish I could go leave dirty diapers on this guy's front porch.
So it was previous to the child going into the particular situation that led to the hospital. And probably many hours passed or even a day passed by.
I feel the legal reasons, the need to say, do not go do that. If you know where this guy lives, don't do that. And don't light it on fire either. That's for dog food, not being
whatever happened to cause that cannot have happened at the hand of Trinity Poague. Because we have a very short window of time you can claim Trinity Poague did anything, which would be from 10 o'clock or 10:15 on Saturday night until 12 o'clock on Sunday, about 14 hours. That's the only time period she was around the child in that within a week or so. Well, why is that important? I mean, you say, well, that's still not what caused the blunt force trauma. No, it's not. If you find that to be some abuse that caused that, it certainly would make you start looking a little further as to who might have done it. But if you choose not to investigate it, and worse than that, throw it away.
Okay, it's like if I shoot you with a gun, and I throw my gun off the bridge, and then say, well, you can't find the gun, so you can't prove I shot you, even though you know I shot you. It's like that. It's kind of like that.
So that this girl right here has no chance to defend it because the test that could have been run cannot be run because they threw it away when they knew it was a test they could run, and he got on the stand and tried to make like he didn't know that.
Testing the poop has nothing to do with the skull fracture, which was the cause of death, dumbass.
I don't know anything about a fecal test. I've never heard of being able to test it to get for blood. I asked if you ever heard of the test, and he says, oh, no, I've never heard of it. And then he starts realizing, boy, that's going to be trouble, so what does he say? Well, I do keep a test for myself, and I can test for blood. If I'd have seen blood,
He wasn't the only doctor that had said that they wouldn't normally be tested, that even though another doctor said that technically it's possible, but that's not what they normally fucking do. That's not what they would do. You know, like, so he's just like trying to like make some shit up, and the poop has nothing to do. There's no probable cause. There's no connection. There's no reason to, you know what I mean? And he had also, right now he's focusing on the poop, but he had also made this argument, I think, about the sippy cup as well. Like, why didn't he test DNA for the sippy cup? Because there was no fucking need to. The sippy cup had nothing to do with the skull fracture, and neither does the poop.
tested. He hadn't said anything about that the whole time I've been asking him. All of a sudden he pops that one up, but said I didn't see blood in that diaper. Now here's where Dr. Busman really comes in, really important. Probably one of the most important witnesses. Dr. Busman had no idea about the diaper.
They forced us to look at pictures, and I think it could be one of three things. I think the diaper, what we saw, was definitely more on the runny side towards diarrhea, I think, and I think that could be explained because in testimony they discussed that the baby didn't have a healthy diet, in my opinion, that they were giving this baby soda and chips. You know what I mean? And fucking pizza. Like, this is the baby's daily diet. Like, he was not eating healthy. And so I think it could be like the upset stomach from lack of healthy diet. I think there could be possible discoloration from some of the junk food related, which can change the color of your poop and stuff. And I think, you know, like they were saying that they did, one of the doctors was saying that yes, it's possible for there to have been blood in the diaper, but he didn't think there was. And so I've seen a lot of dirty diapers. I felt like from a quick glance that looked more like an upset stomach diarrhea diaper, but yeah, for whatever reason, the defense is like harping on and on about that there must have been blood in the poop. And because he didn't test the poop, you cannot commit my client of murder for the skull fracture. And I just don't think the logic makes sense for me. I'm not a doctor, so maybe that's why. But I don't understand what the baby's poop has anything to do with the fact that the baby died from a skull fracture. Nada. It's not making sense.
You can tell
And
that.
mind you, the poop was from before the fatal injury. So, if I'm not mistaken.
I'm going to ask him. I told him before I asked, you're going to find these questions a little bit weird or something to that effect. You know, I've been going on a path that you may not understand. And I asked him about those diapers.
Yes, you are going on a path I don't understand. That is the one thing we can agree on.
And I asked him if he had experience with blood and fecal matter. He said, yeah. Oh, yeah. I said, you probably tested that. Yes. Is there a test? Oh, yeah. So the hemocoat test. Easy. You know, it's done. I said, is it done quite frequently? He said, well, I don't know about frequently. I said, but yeah, you've done it more than a few times. And he said, yes.
See, this is what he was saying. So one of the persons he interviewed was basically like, we don't do that. I don't think I've ever heard of us doing that when he asked. And another person was like, yeah, we can do that, but we don't. We wouldn't. There's no point. You know what I mean? Because there's no reason to test dirty poop for a skull fracture. It's just, none of this is going to create reasonable doubt. It just makes you look really stupid.
I said, if you see what you believe may be blood or suspect it, do you run? Yeah. He said, there's two ways I do it. Sometimes you can just see blood, you know it's blood. Other times you look and you say, well, maybe I better test it. And I said, so you can observe it, yes. And then, if you will, put up that diaper number 2. I showed him this photograph right here that you're going to be able to take back with you to the jury room. I showed him this photograph that I'm talking about, that he had never seen, had no idea about it. And my first question was, Dr. Busman, looking at that photograph, does there appear to be blood in that diaper? And he said, yes. I'd say probably so. Now, yes, that sent the state back scrambling again, where they tried to rehabilitate that answer and say, but yeah, it could have been something else. And he finally said, well, yeah, maybe like if there was dye in some food, it might have caused a discoloration. But in his opinion, just eyeballing it, yes, that diaper seems to indicate. You see right there on that screen.
You know, I feel like the conversation went differently than how he's saying it, but I'm gonna just let him keep going for now.
Blood within it. He said, your crime scene technician didn't think that. Now, you can decide which one you want to believe. That's your
God
job.
damn it. Do
Credibility
they have to
issue,
show
which
this
one should be
again?
believed. Dr. Busman, who's done tests many, many times to test for blood, or this agent that decided to tell you all of a sudden that wasn't worthwhile. And it's interesting to note that diaper was not unfolded when he got it out of the trash. It was in a box. That was the first exhibit 1. You'll see those diapers.
And mind you, it doesn't even fucking matter. And he keeps saying, oh, the state's scrambling. The state's not scrambling for shit because the poop has nothing to do with the fatal injury of the skull fracture. You're the one who's scrambling, dumbass, and you're self-projecting.
Yeah, he took a picture of that, and then he unfolded them to take pictures. So you know that he knew that might be evidence. There's no reason to open them up and take a picture. And yet, after he got them, and once he saw what it looked like, he just chucked it back in the trash and left us with no way to test it. He left us with no way to test it. So he doesn't care about what Trinity Poague has to say. He doesn't care about that at all because that doesn't fit his case. That wouldn't help him prove his case. That would hurt his case. So chunk it away. Chunk it away. It's inconceivable that was done. The crime technician tried to make like 1. He doesn't believe. You can take it down now. He does not believe that it is blood in that diaper, or number 2, that it should be tested. Because if it was tested, it would show, obviously, there was some issue going on with it.
I personally didn't think it looked bloody. I thought it just looked like diarrhea. But I don't fucking see the point in fucking looking at it, and I'm not a fucking doctor.
The child, now, the other things could be going on. The child could have colon cancer, which would be almost unheard of for a 1.5-year-old child. Could have some type of ulcer, again, be extremely unusual for a child that age. If that child that age is bleeding, other than
Mind you, if it had any of those types of diseases, wouldn't there have been some sort of indication in the autopsy? And also, none of that negates or disputes the cause of death, or debunks the cause of death, which was the skull fracture, and none of that is relevant to the cause of death, and none of this clears your client's name. This is just like, are you fucking kidding me? Like, this baby had a skull fracture, and you're like, well, it could have been the cancer. Like, what? What? How stupid are you? This does not give the jury doubt. It makes you look like a bad attorney, in my opinion.
right around the very bottom of the bottom where it might have had some kind of irritation, it came from trauma. If it came from trauma, and we came in the courtroom and showed you that, well, then you really got to wonder, why are we not looking? Why are we not looking a little bit further? Now let's talk back a little bit about the
No, I
statements
really want to know, how the fuck is this guy in business?
that there's no one that's been alone with the child but Trinity Poague. No, there's two people who've been alone beyond Trinity Poague with the child. Mr. Williams was alone with the child for a period of time. I'll talk about that in a second. And more importantly, the child itself for a long period of time as well. Now, you may remember the testimony of Mr. Williams when I had him on the stand on the day of, the morning when this all erupted. I was going through a litany to try to determine.
So, you're saying that your client left the baby alone and that's how the baby died? Is that what his argument is now? But if it's any other, or if you're accusing the father of the child leaving the baby alone at any other period of time outside of the window of which the baby was fatally injured, even if that is, theoretically would have been more important if the baby was still alive, you know, in terms of negligence, even if that does point to unhealthy issues in that family, that's not evidence that clears your client's name from the murder, and it doesn't indicate he was involved in the murder. And it's just like, that's what he does. He just keeps trying to throw dirt and mud on the father of the child's name. And even if anything he said about the father of the child's true, none of that clears his client. None of that helps. It's just, I don't.
What was he doing and what happened? He said they got up in the morning, he didn't know the exact time, nobody really gave me a time, but we do know he laid on the bed, and he said he put the child on his chest, and he also said at that time he had ordered the pizza that you know that he went to get. We got proof of that. Well, you can assume then from that, we don't have concrete evidence of what it is, that he must have ordered the food at some time getting toward the time you would normally eat. In other words, it's unlikely it was 8 o'clock in the morning he ordered the pizza. But regardless, he orders the pizza, and once he orders the pizza, they did not eat the pizza right now, go get the pizza right away. He told us that he got up after being there with the child for a little bit, after having already ordered the pizza, and I'm assuming he's giving enough time for the pizza to be made, so he didn't want to just leave right away. He and Trinity Madison got up, took a shower, together. And that's important in itself, together, because we know from the text messages you're going to see that are going to be introduced into evidence. One stream was to Miss Poague's roommate, where she's talking about in one sense on the Saturday night that she had told Mr. Williams, I'm through. He wanted him to go home that night, but he wouldn't, and she said, but I'm going to go ahead and let him spend the night with JD, but she wants him to live.
In the messages he's referring to, though, that's where she had told, the roommate that she didn't want to be a stepmom and that she couldn't handle being around the baby, if I'm not mistaken. And I don't understand, like, him pointing out that the father of the child wasn't present whenever the fatal injury occurred only implicates his client more, in my opinion. Throwing that out there.
It's over. I'll be the first to tell you, we've already heard a bunch of evidence that it was an on again, off again, I'm breaking up, I'm getting back together thing. So I don't put a lot of stock to I'm broken up and necessarily saying that it was over. But it could have been what was going on. I do know that Mr. Williams had been drinking the night before. He says only a glass or two after he got there with the child. Questionable whether that's true. We know that we have a bottle of liquor that only has about that much in it that he left in the dorm room, and we know Trinity Poague didn't drink it because he admitted she doesn't drink rum and wouldn't have, and it was his rum. But he tried to say that guy drunk at some other time. We don't know how much he did have to drink, but that night we know he went to sleep before everybody else. Saturday night, young man in bed by 10 o'clock already, and sound enough out that when he cried to a child that woke people up in the dorm at 1 o'clock or thereabout, he didn't wake up either time. So it's reasonable to believe he woke up hungover, not happy because his girlfriend is wanting to break up, and he might not have been in the best mood. Or it's also reasonable to assume that maybe the romantic breakup is being a makeup now because they're going.
So, in the time window that the baby was fatally injured, and the girlfriend was the only one with the child, they're trying to claim in that time window, it wasn't the girlfriend that did it, it was somehow the boyfriend. What? Is that where they're going? With some sort of, like, using the makeup breakup as motive that the boyfriend was the one who did it? However, it's the girlfriend who has made statements about resenting the baby, not the boyfriend, as far as documented to my knowledge. I don't know. Like, I don't understand where this is going. I don't understand the logic. Like, what the fuck is this?
Go into the shower. And if they go to the shower together, and they're young people, and they're making up, the chances are of them being in the shower for only 5 or 10 minutes is pretty slim. I mean, when you go in the shower with your mate, it tends to make the shower a little longer for young folks, sometimes even for old folks like me. But I can tell you,
I don't know, it depends. You can get in and out of the shower pretty quick with somebody, depending on if they had done other activities prior, and it was the clean off after, and it might have been a quick shower.
when they go in that shower, they didn't stay in there just 5 minutes or 10 minutes. They are showering together and most likely doing other things.
How the fuck fact that you know how long they were in the damn shower together, though. That's just weird. And it's like, he's consistent. One thing, he's consistently, like, okay, so the difference between him and the state. When the state goes on a speech like this, they are summarizing and paraphrasing what the evidence shows and what the witnesses have testified to. They are not adding their own interpretation. They are not adding their own theories. They are just, or if they do, they clearly state, this is what we believe. They're just letting you know what the witnesses says and what the evidence points to. Versus he's sitting here like saying, yeah, they spent 10 minutes in the shower together. Like, what? This is weird. It's weird. It's weird, and it has nothing to do with the fact that when he left the apartment is time-stamped. You know what I mean? And none of that would, and say that he's trying to create some narrative to say that, oh, the father of the child was involved in any sort of harm that happened to the baby which caused a fatal injury, then it's also true that when the father of the child left, the girlfriend never did anything to help the child, never called the police, never did CPS, never took the baby to the hospital. The girlfriend's also implicated in enabling and being participant of those activities then. So it does not clear her name either. Like, he's really not smart in my opinion. The fuck am I watching?
I'm not judging that. I'm mad at that. But what does matter about that is a 1.5-year-old child is sitting in that little pink chair that y'all saw a picture of earlier and will get a chance to see when you go back to the jury room. And that little chair that sits there, it's not a danger to the child as far as I can tell of something happening in the chair. 1.5-year-old, that by testimony by Ms. Permott back in October, she was watching the child learning how to walk. He's a toddler, so now he's got a few more months under his belt of walking. I don't know what in the world that child may have done while they're in the shower. I do know this. They were probably in the shower for more than 5 or 10 minutes, maybe 20 or 30 minutes, a pretty long time in the shower. They're in there. The child, I've got children, you got kids, my kids were never growing up, my 1.5-year-old boy, if you left him for a minute by himself without looking, he might be on top of a chandelier somewhere. He would climb and go and do all kinds of things.
Mind you, even if it's true that it's not a smart thing to do, none of that clears your client's name at all. Like, it's a weird tangent, in my opinion, to go down.
And who knows? Who knows what that child was doing right now? Who knows whether that child himself on that morning climbed up on something and fell back off of it? Who knows? But what we do know is that when the shower ended, Mr. Williams was the first one out of the shower. He testified to that right here and said he got out of the shower first and Trinity Poague got after next.
Mind you, none of this fucking matters. It's,
You can say, well, so what? He got out and immediately she got out. But he said something else. He said, I went and I was staying there with JD and I was waiting on her to get out of the shower before I left. Well, that tells you two things. Waiting is a term you would use if she's taking a little time. Not I'm waiting and she's following me out of the shower. But secondly, he told us as soon as she got out of the shower, he waved to the child and immediately left, so we know he was fully dressed. So he got out of the shower and got...
So he knows that the baby has a set of eyes on him at that point where he decided to leave the house. And, you know, it may be true that perhaps it's not a good thing to leave your kid, well, when they're a certain age of youngness, you know, when they're too young, when you're in the shower without a set of eyes on them. But at the same time, if they can, some babies in their year and 6 months, they can at least communicate certain things that they need, and you can hear them and you'll know if something's gone wrong by what you can hear. Because if they're in that tiny ass dorm room, there's really not far. It's not as if, you know, they were upstairs and the baby's downstairs and there's no way for them to hear. They would be right next to the baby to jump out if the baby needed anything. So I don't really know why they're harping on that either. To me, I mean, yeah, it's probably not the smartest thing, but I don't think it's the biggest deal either.
Fully dressed before she came out of the shower. So there is a time period where he was the only one around this child. And there is a time period when the child was alone and no one was there. Now, I can't tell you that something happened when that child was by itself. I can't tell you there was something happened.
What? Okay, so is this where he's trying to say no one was with the child because they were in the shower and the child was in the next room? That's a fucking joke. That is a fucking joke, okay? Dumb.
Mr. Williams was there with the child. But I'll tell you one thing else. I can't tell you something didn't happen either. Because all we know is that was the situation. And so to say that there was no other opportunity for anyone, and the evidence they brought into court was if something had happened, it would take anywhere from seconds to a few minutes for it to show signs. Trinity Poague gets out of the shower, the child is in the chair, he scoots out, she's getting dressed, she's cleaning up around the house, doing the things you do. It might take a few minutes, you can see over in the chair a little way, but not think a whole lot about it. Finally, if you go over there in 10 minutes or 15 and go, uh-oh, what's going on? And something had happened to the child, whether accidental or maybe worse. But you can't discount that. You can't say that's not a reasonable proposition of what could have happened, because it could have happened that way. And we don't.
Theoretically, if we didn't have the witness from the doctor's office, and if they didn't know what happened to the kid, if they didn't have the skull fracture, then I would say this. Yeah, we can't discount that. But because we have the testimony and the evidence, and we know that there's a skull fracture, I mean, we know the type of bleeding revolving around the skull fracture, to where within 30 minutes or so of that injury is when the 30 minutes to an hour or so, like how long that baby had before he died. Like, I feel like this is like, yeah, we can discount anything beyond that certain time point, you know? I don't know where this is going. And it doesn't clear your client's name, because all it does is say, so something could have been happening to this baby and your client still did nothing about it, even if she wasn't the only one responsible. She would still be partly responsible in these alternative scenarios you're discussing.
Don't know for sure. And we don't know because there's not been an investigation. There's not been anybody that's tried to push on those issues. They just said, we just don't accept it for what it is. We see you got a child that's not alive, and we're going to blame it on Trinity Poague.
And what I mean is, in these scenarios that he's discussing, which also implicate Julian, it doesn't negate her involvement. All it would do would set precedent for if she was charged to then arrest him as well. It wouldn't clear her.
That's what we're going to do. That's what they did. And you'll see that Trinity, and I'll talk about this a little bit later, but Trinity told people at first, when this first occurred, she had said that the child had fell off the bed. She had actually mentioned that the night before, talking to Mr. Hermont.
Objection.
Let me not talk.
Okay, you see this right here? Before, he was trying to act like the father of the child, Julian, was some sort of liar for saying he didn't know what happened to the baby fell. But now he's again saying that's what his client said, and again hinging his defense on it. It's hypocritical, in my opinion. We're circling back here now.
That's fact, not in.
The text message, I'll tell you about it. Through the text message. She didn't tell it in the sense of talking, but you'll see on the text message from Ms. Hermont where she said that the child had fell out of bed the night before. And you'll see that she said that then. And so then you have not only her statement that happened, but I brought two witnesses in to talk about they heard a baby crying sometime between midnight and 1 o'clock or so. Loud enough to wake them up. Now, these weren't even particularly favorable witnesses to me. They had some things.
And those were the witnesses who also said that she had spoke to them about resenting the baby, if I'm not mistaken.
Say that weren't all that favorable for Trinity Poague, but they were important witnesses because they established when she said something happened that night, that fell out of bed. Well, you got two witnesses that said, well, I'm right across the dorm, one straight across and one to the caddy corner, and I heard the baby crying enough to wake me up. They both said the baby would cry a lot of different times for various reasons, but this was enough to get their attention. So we also know that happened. Now, she did say, when some of the records will show, there was a claim, if you remember, Dr. Wright, or Reverend Wright, I should say, said that she claimed that the child was in distress and fell out of the chair. Talking about that little pink chair. Well, if you look at the pink chair, you'll be able to quickly see it's fell out of the pink chair and nothing happened. I'll suggest to you, and I believe that I asked him about it as well, that what she meant by that is when she noticed a child in distress, the child was slumping over, and it just sort of slumped out of the chair. That was not the cause of the injury. She was not presenting that to say it was caused by the child falling out of the chair. She was telling them, what do you know? Well, I came up, the child's in distress, and it fell out of the chair. She wasn't insinuating. There were two different things here. Two different things entirely.
I feel like that is not what he was saying in previous arguments, and it makes him look hypocritical.
I had lots of questions I was asking about possibilities of falling out of the bed, and I know that some of the experts try to discount that to some extent and want to say, well...
Oh, yeah, because mind you, earlier he was, in the previous days of this trial, he was basically trying to say that, isn't it possible that the baby just fell out the chair? And, like, he was using that as a defense. And now he's basically like, well, we never really said that. But, you know what I mean? Like, it's just like... And the jury, any jury member who's been listening to this trial for these days and has seen those previous arguments is going to look at this and be like, yeah, we literally basically just saw you say the same thing. And you might want to get into the technicalities of the semantics and the literal word for word. But sometimes to a point it does matter, because when someone is accusing you of saying something and you didn't say it, it does matter if they quote you correctly. However, sometimes if what they said is basic, even if it's not word for word what you said, if it basically means the same thing, and you then go after them about the semantics or the technicalities, it just makes you look like you're trying to deflect from accountability from what you did wrong, right? And so that's the issue here, is he looks like he's deflecting.
We're not talking about it. Time may not be right. I don't think that injury could occur. 40-inch bed is pretty high. 40 inches as high as my hips. You're talking about a small child that's 31 inches tall, falling onto a hard concrete floor. That child lands flat, bam, the back of its head.
And doctors already ruled that even at 40 inches high, that's not high enough to cause the fatal injury that occurred. It's extremely unlikely, is what the doctors discussed.
Have some significant injuries. But I asked Dr. Clark about it, and he was kind of waving around, but then I asked him, remember, about particular scientific journals and treatises. And he didn't know I was going to ask him about it. I didn't know that they...
Is this the one that I think I harped on about the whole, like, he misquoted the situation? I don't know.
He would know what I was talking about, but I asked him if he was familiar with Mary Case. Dr. Mary Case, she's a forensic scientist out of St. Louis County's forensic department.
Yes, this is that. This is what I was telling you about earlier, where it was just like, he's literally using cases that are not relevant to this baby's death. And Dr. A, he was basically had quoted Dr. B as an opposing or deferring opinion. And he's using Dr. B and had gotten and he was basically saying to the witness, so if you agree with Dr. A, that means you agree with Dr. B, right? And the witness was like, no, Dr. A and Dr. B did not agree. And also Dr. B's case examples are completely different injuries to what this baby had. So those results would be drastically different.
I said, is she well known? Yes. Do you know her? Yes. And I said, how do you know her or whatever? And he said, oh, I just went to a seminar, a week-long seminar with her. I've been to 2. You can tell. He valued her opinion. And I brought that up because I wanted to point out a fact that was contained within that particular literature. And there was a particular page I turned him to. And I'm going to read you about that page one more time because I think it's critically important. The paper was talking about accidents in which children had fallen from not particularly large heights.
And every single one of these cases that he's referencing, those kids had a different type of injury sustained than what the baby who passed away sustained in this case. So all of the doctors were saying, this is like apples to oranges, this is not relevant. And he keeps bringing it up as if it is. And so it just makes him look bad.
It was severe enough that it killed him. And admittedly said it was rare. It didn't happen all the time, but from time to time, a fall would occur that would appear that wouldn't be enough to cause.
It's like if you have cancer and the doctor is like, you need chemotherapy, and you're like, and you get 3 other doctors' opinions saying that they all say you need chemotherapy, but you're just like, I'm not gonna do chemo. I'm gonna put some oil on my hair and hope the cancer goes away. You know what I mean? And everybody's gonna be like, why the fuck wouldn't you go get treatment and listen to the doctor? That's kind of how he is. It's like, why wouldn't you listen to the doctor? Why the fuck are you saying this random shit? I guess because he gets paid to as a lawyer. I don't know.
Significant harm, but did. And the first case study said that a 4-month-old male child was taken to a children's hospital. They did a CT scan, and it came back normal.
Mind you, he did not have the same type of injuries as this baby who passed away did. Why do we even have to fucking listen to this shit? It's so frustrating.
He would not eat or sleep well. He survived for 2 days. They would then try to take him to see his pediatrician. He died on the way there. They said he fell out of an adult bed and struck the edge of the bedside table. So an adult bed, unless it's something really unusual, would not be even 40 inches tall. A second one said a child that was 21 months old male. He cried after he had fallen. He was able to be comforted. He vomited, but then put back to bed after he was through vomiting. They found him dead in the bed the next morning.
And another thing is he's discussing the symptoms that these babies all had, which are similar to what this baby ended up having, but he's not discussing the specific types of injuries these babies had, which are all different from what this baby who died that we're on. So that's the thing, where it's like, if you're gonna do this, it needs to be the same type of injury. You know what I mean? If they all had the same injury as this baby, then this could work, but it doesn't. It gets debunked. It was already debunked. And so for him to be repeating something that's already been debunked with evidence makes him look like a flat earther. It doesn't look good. Did you have no time to really come up with a better defense? It's bad.
he had fallen out of his own bed. A third one was a 7-year-old female who fell off of a 36-inch tall tree stump, and she hit the back of her head. She complained of headache and vomited several times. Over the next 12 hours, she's found dead the next morning. And then finally, a 10-year-old boy who had fallen off his bicycle, and he was found on the
And
ground.
again, another key difference in all of these cases, the way that all of the injuries occurred for these cases, they had a longer time to live or to get treatment. There was a longer window of time between when their injury was sustained and their time of death. Versus in this baby's case, the window of time, that's the key difference in the way the injury occurred. The key difference in the type of injury as well. In this baby's case, he only had a much smaller window. And none of this is relevant. It's just like, why is he always harping on irrelevant shit? And I wonder if it's just to wear people down, antagonize them, and run out the clock. Like, I don't get it.
He went to the emergency room. CT showed a fracture of the right temporal. Then it cuts off as to what happened. But he died. Now, these all involve subdural hemorrhages. Now, the expert, Dr. Clark, wanted to try to walk away from that some by saying, well, wait a minute, those deaths weren't caused by a fracture back here. They were fractures somewhere else in the skull, so that just sort of didn't count. But one of them did involve falling.
Yeah, and he was also saying the type of hemorrhage was different as well, and that was a key factor in the way the bleeding happened, which determined the fatality of the case as well. So,
back of your head. But regardless of whether they were the exact same fracture, it's pretty good proof that at time to time, a fall from not too high can cause significant injury. And if indeed that fall from the bed caused that,
yeah, it's true that a fall from not too high can cause a significant injury. For example, if you fall on a knife, you're gonna fucking probably get really injured. But comparing other 3 cases where they all had a similar skull fracture, and those cases had the same type of hemorrhage, to a different case where they had a different type of hemorrhage and the skull fracture was in a different location, it's not comparable. And it doesn't help your case, and it's wasting time, and it's frustrating to see.
Sometimes it can't be discovered right away, and you look at it, you see these examples. No one thought these children were in great danger. 2 of them went to the hospital, and were given the clearance to go home, and they died. This young lady here, Trinity Poague, she's not a doctor. There was no real visible signs, even according to the doctor, to the officers.
You're not a fucking doctor, so why the fuck are you over here trying to discredit them?
First look at the child. That was not in a real heavy area of what might be considered harm, where you look at a child just visually and think something serious was wrong. In fact, even the autopsy doctor said, and the doctor at the scene of the ER said, you had to feel the back of the head to realize that he suffered any injury. If that child got injury out of the bed at around midnight or later, it may have taken a few hours before it all of a sudden erupted and showed itself. Trinity Poague had no reason to think that was any serious injury.
You see, this is what I don't understand. The doctors have already ruled that it was a skull fracture injury that had a very small time span from when it occurred to when the baby died, and that he was brought in, that it could have happened. And here he is, and he just keeps saying, well, it just could have been hours. It could have been hours. Who fucking knows? Nobody knows. And the doctors are like, yeah, we can tell from the injury. We know for sure. And he's like, the doctors have no idea what they're talking about. It's so frustrating to watch. And if any jury member is thinking like me, he's losing his case for his client. I have a hard time seeing a world in which she's not getting some form of a guilty verdict. And, you know, let's say like half of it is her fault because she's the one who did the damn thing she's getting found guilty for. But I swear to God, we can blame 50% or more of the blame on him because he sucks ass, in my opinion.
She would have no reason to. And she certainly would not have been the person that caused it. And if that's a possibility, and it certainly is a possibility, there's enough evidence to show that that most likely did happen when a child falling out of bed. That's reasonable doubt as well. You cannot say that Trinity Poague was the cause of it.
Okay, so if we know for a fact that the time frame of which the baby fell, or whether or not the baby fell, we know that the baby did fall the night before, but we know that the baby was fine. The time frame from which the fatal injury occurred to when the baby was in the hospital was within a short time frame according to the doctors. When the baby fell, that was the night before. The baby was fine from that. So when it comes to this other situation where he's trying to say he himself knows the time window of what these injuries are better than the doctors? How? What is your experience? Are you trained as a doctor? Were you going to be a doctor then became a lawyer? If he's going to make those statements, I feel he should credit how he is a valid source of authority on medical expertise. He needs to show how he's a medical expert so we can understand why he's making those claims, or prove to some evidence with some sources that backs him up. Otherwise, he just looks like a dumbass.
And I know, ladies and gentlemen, that you've heard some other things that you may have questions about Trinity Poague's posting of certain text messages that are in evidence already. She was in an immature relationship at 18 years old with a 23-year-old man, and she made comments from time to time as they went back and forth with their up-and-down relationship that could have been said better. And she did say at times she was not very...
Okay, it's one thing to make comments about your partner, but to make comments about your partner's child, and now that child is dead, and you want to act like that's not relevant, it totally is.
She did not like the child and those type of things. But never once has anyone said that they saw...
And here he's admitting that she said she did not like the child. She's admitted she didn't like the child. The attorney admits she said that. And oh my goodness. Okay, alright.
Saw her anyway.
And he doesn't think that's evidence to investigate her for the death of the child if she was the one left alone with the child at the time of the fatal injury?
In any way harmed that child, including the father never said that. He never claimed that there was anything abusive going on. These were a matter of speech. It's much like if my wife were to go out shopping and come home and I thought she was buying a $100 coat and it was $1,000, I might call one of my friends and say...
He could have been in denial. You know what I mean? Like, some people, it's like, or if they're also raised in a toxic environment, they're either in denial or they are like not able to process it because they didn't think it would happen to them, or it's so normal to them that's just what they know, so they don't realize it's not good. There's explanations there, but either way, it doesn't, like, what he's saying does not help his client. Oh, god damn it, I meant to hit play, but then I clicked away from the fucking thing. That's not the right button.
I could strangle my wife. She just bought a coat for $1,000. Do I mean I'm going to strangle my wife? Of course not. Poor language, perhaps, but just simply talking, in this case, mostly to Miss Permont, who is her roommate, who is a person that she is very close with, who that she discusses her relationship. In fact, you will see in this thread of information on the text messages, you will see where in parts of this, Miss Permont sort of agrees with her on stuff. She's talking about having trouble in State's Exhibit number 39, and she asks, is he sleeping with JD in your bed? And Trinity replies, probably. And she says, TRIN, that's so messed up. Make him get on the air mattress with his child. That's not your kid, and y'all aren't together.
Even if I agree that it's really ridiculous, if you're the girlfriend and you're inviting the father of your child over, why the fuck aren't you sleeping in your own bed? Why is he sleeping in your bed and you're on the floor? Yeah, that I agree with is ridiculous, but that doesn't negate her role in the death. It has nothing relevant, you know what I mean? Like, it's just not relevant to what happened that night, in my opinion, in terms of clearing her name. I don't know why he's going down this rabbit hole in that.
I know I told him after the night, you better not contact me. Was Trinity's reply. This is a conversation between Permont and Trinity. So we know a few things from just that little thread. First of all, Miss Permont's saying to her, you need to quit letting him just give the child to you while he goes and sleeps and does whatever he wants to and won't tend to the child. It's his child. Tell him to come be responsible for getting him into bedtime and doing what needs to be done. So she knows that that's been an issue. And then secondly, offers her a place to sleep, and she says in return, though, after the night, better not contact me. Let you know it's on that downswing again. That's what I was talking about just a moment ago. And then there are conversations after that. But this is not proof at all of any type activity by Trinity Poague toward that child. You don't have any evidence that Trinity Poague made.
This is fucking ridiculous. That doesn't help your client at all either. So it's like, why is that even part of your defense? Because none of that is relevant to any of these charges at this point.
Type confession, which of course she did not. You don't have any evidence that she talked to some people after this event and has told them incriminating evidence somehow or another and they brought it into court. Again, you have no evidence that says she...
No, and part of this storyline, some of that information was relevant to explain where people were at the time and what they were going through and what was happening, so you could see the events leading up to the murder. When we were at that point, I could see why some of these things were relevant then, But here in the defense closing statement, I feel bringing like shit like, oh, she was sleeping on the floor while the boyfriend was in the bed, which I disagree with, but that's not, none of that like spiral, none of this negates or helps her when it comes to the facts of the day of the murder.
She committed this crime. You have the suspicion that she committed this crime that is given to you by the district attorney and then by the state of Georgia without evidence to support it. Now, you also heard that she searched some items after she was at the hospital about skull fractures on her phone. And I want to be very clear so there's not any confusion about this. This is not a search that was done before the child had been injured. This is not a search that was done during the injury of the child. This is a search that was done after she was at the hospital and after.
I think at this point, though, it doesn't help you because it makes her look guilty. I'm just putting that out there. Like, someone looking up if someone could die from the injury that they got when they were a baby and you were the adult that they were with at the time they got that injury, after that injury occurred. I mean, yes, obviously, if you searched it before and then it happened, that would look way worse because that would be like, wow, you searched for this and now it's here. But doing it after, it almost kind of looks as if you are like checking on what you did. You know? It's kind of like when you are running in the house, or, oh, no, it's like when you're throwing balls in the house, you know you're not supposed to, but you and your siblings are playing in the house throwing some balls around, and then the ball bounces, and next thing you know, you hear something shatter, and you've heard the shatter. You already know that something is broken, so then you look, and it's like, oh, yeah, that's bad. You know what I mean? Like, I don't, that's kind of like what looking for, the consequences of an injury are after it occurred is, in a way, you know, like it still doesn't help.
After Dr. Busman met with her and Mr. Williams and told them that the child had a severe skull fracture and was likely not to survive. Now, at that point, you can look at this, and I'm going to tell you where to look on this as well, because I think it is very important that you see this as well. On those same documents, the one that's 1 through 39, the medical records, if you look at page 38 of 39, it has a colloquy that shows at 1:15 that afternoon, he spoke to the family to update the condition. That is when they meet and say, this is really serious. Trinity Poague, an hour or more later, and then 3 or 4 hours later, did search terms about skull fracture. And what does that mean? And how can a child have a skull fracture? That's very logical to assume you would do that. If someone told me my child had a skull fracture, I've seen nothing happen to cause anything to injure to the head, I would want to know, how can that be possible? And I might even say to myself,
But didn't you just say, give a bunch of examples for what could have caused that injury? So how are you saying you saw nothing when you've been saying, oh, the baby fell off the bed and shit like that? So that's contradictory. And yes, it is normal to, if you have a child, or even if yourself or someone you know gets injured, to look up what that injury is. That is normal. It is. But when it's also been proven that since the hospital, you hadn't spoken to the father of the child since, but you're still looking into the injury, well, it's not like you were checking in on the child or the father of the child at this point. And at that point, didn't the baby pass already? So why are you looking into the injury causing the baby's passing if the baby's already dead? Are you, unless you're looking into the, like, what, you know what I mean? Like, unless you're looking into a defense. Just curious. Yeah.
so, well, I know he fell off the bed. That's out of bed, but is it possible he fell off the bed and it caused it? I would search. That is what happened here. This is not, again, the way the prosecution wishes to portray it. They want to try to make it some nefarious, evil thing that was done. She did the thing anybody would do. Check and try to find out what in the world does all this mean. Trinity Poague was 18 years old.
If she had checked in on the baby's father, then I would be like, okay, yeah. But when you're looking into the baby's cause of death, you were the last person seen with the baby, and you're not even checking in on the baby's father or the family, it does look suspicious, and bringing it back up does not clear it up.
She was living alone for the first time in her life at Georgia Southwestern College, and she'd been there one semester when all this happened. She came to the hospital after a traumatic event happened that she had no idea what was occurring on a child who was in distress on things that she had nothing to do with and did not know what was occurring. And then found herself within an hour or two being interrogated by GDI agents, by police officers, all that you can imagine, and her trying to figure out what in the world is going on. Now, ladies and gentlemen, you've been sworn in to follow the law in this case, to make a decision on whether or not the state has a right to say that she committed a crime, a serious crime. And your duty is to hold the state to their duty, which is they must prove that case, each and every element, beyond a reasonable doubt. If any doubt exists whatsoever that is reasonable, you cannot convict. You cannot discount.
In every other court case that I have watched, I may not have agreed with everything that each attorney said or did, but there was a much more level playing field between the chances of the attorneys winning, in my opinion. Almost every other case, except for certain cases like the Hannah Gutierrez Reed case. I knew that bitch was going to jail. Like, yeah, like that. She fucked up, you know. But then it's like other cases. It's like, wow, this could really go either way. And sometimes it's like, even in cases where it couldn't, where you know that someone's going to jail for sure, probably, it's like you could still really look at their attorney and be like, you know what, even though I think your attorney is guilty as fuck, your lawyering skills are really good. This was a really good move. You did great here. You did good here. I don't agree with your client, but your representation of the client is great. This is a good attorney. You know, you don't always have to be, just because I've made the decision that I believe this person is guilty, doesn't necessarily have to mean that I'm against the attorney, right? But in this case, I am against this attorney because I believe he makes his client look worse. Like, it's just real hard for me to watch this. And to be honest, if anybody had a reasonable doubt before he spoke, the more he speaks, the less doubt I think people would have, because he talks in circles, he brings shit up that makes his client look bad, and then when he tries to debunk the prosecution, all he does is make himself look like a flat earther. Like, it does not help him.
Now, the possibility that Mr. Williams could have been responsible. You cannot discount the possibility that an accident happened to the child while they were showering. You cannot discount the possibility that the fall from a 40-inch bed caused injuries to this child. All of those are reasonable doubt. You cannot come back with a verdict otherwise. You know, this place that I'm in today, I've been practicing law now for longer than I sometimes won't admit. And I've had many a trial, but it never changes in one respect.
The back of your head is ridiculous. But, okay, he's probably been practicing law for longer than I've been alive. Maybe this is just an off case for him, and I'm judging him off of this case, and he's done better on other cases. Maybe this client is so fucked, he really had nothing to work with, so he's just throwing the spaghetti at the wall, see what sticks, trying to win what battles he can. But I really feel that the methods he used did not have the proper setup to back up those approaches. Like, if you're gonna be a dick to a witness and call them a liar, you have to actually catch them on a lie. You can't just act like everything they say is a lie, or it makes you look bad. And I'm serious. You know, like, you can't just disrespect people just because they're not your witness. And him doing all of that for so long while not having a valid alibi or defense for his client, while basically saying these medical doctors don't know about medicine. I know about medicine, but I've never studied medicine, but I know about medicine, they don't. That doesn't help you, you know? Okay, let's keep going. We're not even 2 hours into this thing. Dude, we're gonna be here all fucking night, man.
Okay. When I'm in a courtroom, this is hallowed ground. Where I am at right now is the bedrock of what we do in this country. We're a country different than all other places. in that we require when someone is accused of a crime that it be brought before a jury to make a decision, and that the proof of it is not just, I think you did it, might do it, more likely you did it, but you must have solid, no question evidence beyond a reasonable doubt. It requires that to be evidence. There's not been evidence at all. The state still doesn't know how it happened, where it happened, why it happened, who it happened, or even with what was used for it to happen. Do not make the mistake of allowing your emotions to be involved in this case so that you say, we must have a verdict some way because the tragedy occurred.
He's literally over here like, don't let me down. Don't let me down. Okay, I'm sorry.
I need a verdict. Do not, as I said in the opening of this case, in your rush to seek justice, do so on the cross of innocent blood of Trinity Poague, who has not had a thing to do with the injury that occurred to that child. It was a tragedy that occurred for reasons that I will not stand here.
This doesn't help. We know that there is evidence she made specific statements about this baby, so therefore that doesn't make her look innocent. And so even if he was going to say, oh, my client is innocent of this specific crime, that might work. But just trying to say, oh, she's an innocent person, they're going to be thinking about the proof of the negative thing she said about the baby, and they're not going to see her as innocent, you know? And when you look at this whole thing where he's trying to act like, oh, she did nothing wrong, like, it's proven, like, she had nothing to do with this. It is proven that she was the only one alone with the baby when the baby had the fatal injury. So that itself is contradictory. And so, like, he's trying to say, like, if you have no reasonable doubt, but, I mean, if you have any reasonable doubt, then you can't convict. But his own conclusions basically, like, take away doubt from you because you're over here, like, you don't make sense. I don't know.
I can tell you I know the reason. But the interesting thing is, they don't know either. Oh, they know it's a death, they know it's blunt force, but all the reasons I've told you before, they do not know. I trust you when you go back to the jury room that you will consider the law, you will consider the evidence, or in this case, the lack thereof, and you will return the only just, the only righteous verdict that Trinity Poague is not guilty.
Thank you, Mr. Chairman. I'm going to give you a 15-minute recess. We'll come back at 12. Let's make it 12:10. 12:10. We'll come back at.
I feel like that's a terrible close. There has to be a better closing statement. Like, if you're going to come with that definition, you know, like, oh, not guilty, she's innocent, blah, 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 blah. Is that what you're supposed to do in a closing statement? And I'm just unaware. I just feel like he doesn't have the evidence to back up what the fuck he says. Okay, let's skip through this. We don't need to hear that. Oh, it looks like there's more here. Let's see. Let's double time it. I don't want to miss it. It looks like there's something else that comes up. Should I edit it? There we go. Okay, yeah, it's gotta be her family. It's gotta be his family. Am I being too harsh? Or does the defense attorney kind of suck? Maybe he doesn't suck in general. Maybe it's just this case, how bad of a hand he was given. It's like a poker game, you know? You're not going to be given a good hand every time, so some hands are just going to suck for you. Okay, Man, now it's saying we're on break. Shit, I thought we were getting like. It's showing them over here, so I was thinking something could be happening. I didn't want to miss it if anything did happen, but it looks like the judge is back over here. Okay, here we go. Is the judge coming back? Now I think the judge is about to be back. We're double timing through here. Where's the judge at? Marco. Here we go. We got our neighbor from Home Improvement right here. This is what he was really doing.
Probably. We'll see how it's going. No, let me just do it.
It says we're still in the defense closing argument technically, but I think we're about to get to the state's rebuttal. I'm gonna try to let them talk for a second. And let's see.
All right, Ms. Lamb, you can conclude your argument.
Oh, here we go. Okay, now we're getting to the state's rebuttal.
In the way back, probably just shows how old I am, which is old. In the 1980s, there was a movie called Scarface, and the guy was like a Cuban guy who would become a drug lord in Miami or whatever in the 1980s. And there's a scene in there where he gets caught, not for pushing drugs, but he gets caught for laundering money, like trading money for, swapping it out with somebody else for, percentage of the profit in order to account for all the millions and millions of dollars in cash that are coming in. And so he gets caught, his own video and all this, So he hires a lawyer, and the lawyer comes in and looks at him, and the guy says, I want my rights. I'm presumed innocent. I'm not idiot. And the lawyer looks at him and he says, under the law, he says, to be convicted, he says, the government has to prove that case beyond a reasonable doubt. And he says, and Tony, honey, baby, he says, I am an expert at creating that doubt. And he says, but it's awful hard to do when you're sitting there and there's no other explanation for you having $2 million in 20s rolled up in duffel bags. And that's sort of the situation that we're in here. I understand Mr. Gamble's a great lawyer. I mean, he is. He's an excellent lawyer, and he can find these things he created. And that's why, literally why, I ask you, so when you listen to this, nitpick, wait for an answer.
I was very curious where he was going when he brought up Scarface initially. But what he was saying about the attorney, that it being their job to create the doubt, that was golden. That really summarizes exactly what I think is the defense's approach this entire time. And mind you, this slide that he has, what does anything that the defense say have to do with the death of this baby? They never answered this fucking question, because it doesn't. What does the poop have to do with the death? Exactly. It's just ridiculous. It's ridiculous. The defense is ridiculous in my opinion. I agree with the state, and y'all, I'm anti-government, so when I'm over here like, damn, I agree with the state, that means, you're really bad.
Answer to this question: what do these things really have to do with the death of this child? And we're going to talk about it. We're going to talk about the poor parenting and the dirty diaper and the vomit on the jacket and all of that as we get further in. But first, ladies and gentlemen, what I want to do is I want to talk to you about what the charges are and what I have to prove. Okay, these are the charges that are in the indictment. Okay, and it's sort of starting actually. I think I'm starting kind of in reverse. I should have gone back and put them in the order of the indictment. But there's a reason that I wanted to do them this way, and that is that I wanted to start with what's kind of the underlying felony charges, which.
Okay, I'm actually glad they're doing it like this, because I want to learn more about this part, because I don't know a whole lot about I know to a point some of this information, but I don't know about what charges she actually has as it relates to this case. So I think this is actually really helpful for everybody to understand what is she even being charged with,
Then, go up the scale as you add other things. So, aggravated battery, the state has to prove the defendant maliciously harmed the person by rendering a part of his body useless or seriously disfiguring a part of his body, which the evidence in this case establishes that J.D. Angeli's brain was essentially rendered useless, that his liver was rendered useless, his liver was disfigured due to massive lacerations, and so forth. For first-degree child cruelty, the state has to show that the defendant maliciously caused cruel or excessive physical or mental pain to a child. Now, both of these charges include the phrase malice, or the word maliciously. And the law, and this is what I think Judge Sizemore is going to charge you with all of these things. That's the reason I'm putting them up now. And I think you may actually get a copy of the charge with you. And if you don't, if there becomes a question and you think, we need to be clear on this point of law, all you got to do is say.
And the text messages that she sent, denigrating and demeaning and talking shit about the baby, that's all going to be used in evidence for the malice aspect of these charges.
hey, judge, can we get a recharge on this or that? And they'll come back and tell you this again. But malice is not necessarily ill will or hatred. It simply means an intent to cause pain without justification or excuse. Malice also means willfully, intentionally doing an act while aware of a strong possibility or strong likelihood that pain may result. If you pick up an 18-month-old baby and you slam him down on a piece of furniture or on the floor or against the wall, whatever, with the degree of force that's necessary to fracture this bone, with the degree of force, in a separate blow, with a degree of force that is sufficient to tear his liver practically in half, okay, then you know, folks, that's malice. I mean, because you can't do those things to anyone, particularly not to anyone, a child or anyone, without knowing that there is a strong likelihood that pain is going to result. So if you find Trinity Poague guilty of aggravated battery or cruelty to child in the first degree, and I submit to you that you should find her guilty of both of those charges, if you do, then that brings you to felony murder. And what felony murder is a person commits the crime of murder when in the commission of a felony, he causes the death of another human being with or without malice. Okay? So in other words, it's not a matter of did somebody intend to kill him? Was somebody aiming to kill him? Was it a specific, I'm going to, I've got an hour, I've got 30 minutes, I'm going to kill this baby right this minute. Kind of thing. Don't have to prove that, okay? Don't have to prove a specific intention or intent or desire to kill. All you have to prove is that the felony, the underlying felony was intentionally committed with the person knowing that it was likely to cause pain. And if you do, then that leads to the finding, almost necessarily, I say I think, and not I think, but when you look at it, how do you analyze this? Do you find the felony, and then you look at this charge, which says that if a person dies in the commission of the felony, then that's murder. Well, that's exactly what happened here. And that circles back to where we were at the beginning of...
And that charge is with or without malice, mind you. I think the malice does matter, like, that can definitely be proven, but they don't even need to prove the malice to prove the murder, you know what I mean? That just goes to show with circumstantial evidence as well. I honestly, at this point, do believe she should be charged with the murder of the baby, because there was nothing to me to prove that she shouldn't have been, but am I wrong for thinking that? Like...
The first part, which is that the question is who caused the trauma that killed the baby? Within that time frame. I mean, that ultimately will answer those other questions, okay? Because if you know the answer to this question, then you know the answer to to whether the defendant is guilty or not guilty of those other charges that have been brought. I fully understand, I respect, and I honor the burden that I come in here with, and the judge is going to charge you, and there's no question about it. Mr. Gamble argued it, and he's absolutely right. The defendant is presumed innocent, and that presumption carries with her throughout this whole trial. She had it when she came in this courtroom, okay? She has it when you go to the jury room, okay? But when you look at the evidence, and you find that the evidence is sufficient to overcome that presumption, when you find that the evidence is sufficient to show you beyond a reasonable doubt that she's guilty, then the presumption goes away. Until then, she certainly has the benefit of it. The law says that nobody can be convicted of a crime unless the case is proven against them beyond a reasonable doubt. We have to prove all the elements of the indictment in order to do that. The evidence in this case is not, it's not as complicated as Mr. Gamble wants you to think it is. It's actually fairly simple at this point. And that is, okay, we start on Saturday, January 13th. Jay Williams was in Colquitt. JD was with him. He had been up here. He'd been up here earlier in the week. He stayed here like Thursday night, Friday night. Okay, he stayed at her dorm, or in a motel, whatever, at Hampton Inn Thursday night. This is his testimony. He stayed in a hotel there. She'd come over, and then Friday he was going to stay in the hotel again. And she came over, and when she came over that time, and she didn't want to stay. She said because they're breaking up. She's breaking up, right? So she wants to leave. She wants to go. She goes back to the campus, and when he doesn't come with her to the campus, she calls him or texts him and lies to him about having been in a car wreck. She lies and says, I was in a wreck. And he told you that, of course, his reaction to that was he took off to the campus, to check on her, and she was in a wreck. She wanted to talk to him. So it was sort of reverse stalking. Like, instead of following somebody, he said, here, come here and follow me. And that's exactly what she did. And so on this day, the next day, January 13th, she's in Americus, he's in Colquitt. She wants to go to Chipotle in Albany. Okay, so she asked him to meet her there. He doesn't call and ask her out on a date. He's not planning on going anywhere, and that's what his testimony shows. The reason that he wasn't planning on going anywhere.
I think they're trying to bring this up because the defense was acting like, like he was trying to mooch off of her and always be in her space. And the prosecution's basically like coming back as if like, no, actually, she asked him to be there, so, yeah.
It's because he was going to be home with his son, with JD, and nobody else was there. His sister wasn't there. Didn't have anybody else. He didn't trust anybody else to keep JD. And so he tells her, he says, I'll come, but I've got JD with me. And she says, Well, come anyway. Just bring him with you. They get there, they eat dinner, they go to Sephora. You know, she swaps the car seat from his car to her car because it says that according to his testimony, she says that it would maybe give her a little time to spend some time with JD, you know, while she's driving and you know, work on building some kind of bridge or relationship with him, etc. So then she
Fuck, I hate when I'm fucking muted. I think that's the time frame of which I believe that Jay may have been drinking and driving, according to Jay's own testimony, if I remember all that correctly.
She says she wants him to come back to Americas with her. And the car seat's in her car already, and he says, yeah, okay, I'll come back to Americas with you. Okay, so at this time, when they're in Albany, okay, this video is one of the videos that was played. I mean, it's not a video, it's a screenshot of the video, okay? But this shows the child in the car, okay? This is when Jay Williams has left Colquitt and is coming through Albany, that this video is taken, okay? And he's wearing his little his black Nike is what I'm trying to say, his black Nike hoodie and not hoodie, jacket and pants, his suit, or tracksuit or whatever, which is the same thing that Jay Williams was wearing himself. And he made reference to it that was they had matching outfits. Okay, this is what this child looked like. Okay, there's no bruise on the side of his face. There's no marks on the side of his face. His face isn't swollen or anything else. That's what he looked like when he's in Albany. Okay, now there are these claims that were made in opening statement, okay, that have turned out to just simply not be true. Okay. In opening statement, the defense said that Jay was drinking when he met her in Albany, and she just couldn't send JD back to Colquitt with him, so that's why she took the child, and then she let them come to Americas with her because they wanted, they wanted to go to Americas, or Jay did. That's what you were told you would hear. There's no evidence that says that. There's no witness who testifies to those things that you were told you would hear. In fact, what happens is on January 13th, if you look, after she has asked him to drive from Colquitt, from Albany to Americas, before she's even back at the dorm, she texted Paris, and she says, "Are you coming back? I got stuck with JD." Paris says, "Yeah, I'm coming back." And she says, he made me feel so bad because it's already late and JD is being so fussy, so he asked if they could stay. And ladies and gentlemen, there's just no actual evidence that is what happened. And in fact, it doesn't make any sense at all that he would have done that, because if he's in Albany, he'd be closer to home than he would be to here. So on Saturday, then what happens is this. They get to the dorm, they go through the doors, and you saw the video from Georgia Southwestern. They go through the doors at 10:06. He testifies that he blows up the air mattress for Poague and JD to sleep on. Trinity Poague and the baby are going to sleep on the air mattress. And there's not a lot of explanation for why that is, but the context of some of the other messages that we'll get.
There's no way in hell I'd be sleeping on a fucking air mattress while a man sleeps in my bed. Like, no way in hell.
To later, and I think the testimony of Paris in this trial suggested that typically when JD was here, that he would sleep on the air mattress with Miss Poague. That night, Paris came to visit them. Okay? She wanted to see the baby. She left work on her lunch break. She came to see the baby. She says that when she saw him, he was perfectly okay. He didn't have any bruises. He didn't have any marks. He didn't have any tenderness or soreness. She picked him up. She hugged him. You know, they kind of played around, and he wasn't tender. He wasn't shy. He wasn't any of those things. Okay? Because he hadn't been harmed at this point. He doesn't have any bruises. He doesn't have any injuries. Jay Williams fell asleep on the bed watching TV. So let's take a pause here and figure at what's the baby's physical condition at this time, okay, which is 10:30, 11 o'clock on Saturday night. There's no evidence of bruising, pain, soreness, or any injury. The only thing that was said was he might not have been hungry. There was some allegation that he didn't eat much. Of course, Mr. Williams said the reason he didn't eat much at Albany or wherever was because he had eaten in Colquitt before he came up here. Then that night at 11:46, Ms. Poague texted Paris and says, "Is it okay if I watch TV in your room?" She says, "Yeah." "Why, are you all right?" She says, "Yeah, I need a break, a mental break. JD isn't asleep, and Jay is knocked out all over the bed, and I didn't want to play the TV." Is what she says there. So 11:46, she's asking Paris if she can go to the other room with JD. So it goes Sunday morning. This is Jay Williams' testimony. He woke up. They woke up. She had gotten to bed with him off of the air mattress. They woke up. He said he woke up somewhere around 9, maybe something. Said she woke up like between 9 and 10, I think. Says that he picked up JD and put him on the bed with him, and he laid him on his chest for a little while, and whatever. And then they got up to take a shower. Now the allegation is that the statement from Mr. Gamble is that he says that they ordered the pizza before they got in the shower, The testimony, and you will recall it, of course, was that they talked about ordering pizza at like 10 or 10:30, but hadn't done so. And then they ended up actually ordering pizza, a little while later. And whether it was before or after they got in the shower that they ordered the pizza, don't know, but it doesn't matter. Okay, he gets out of the shower, he gets dressed, he says goodbye to JD, he leaves to go to Walmart and Pizza Hut, and at the time he left, and at the time Trinity Poague got out of the shower and went back in the room, JD was in that pink chair watching Katuri, a kid's show on TV, and had a Mountain Dew and some Fritos Twister chips. Okay, so when Jay Williams leaves at 11:55, what's the child's physical condition? Again, no evidence of bruising, pain, soreness, or any symptom of injury. He might not have been hungry. That didn't come out very clearly, but that's at his worst condition if you hear the evidence. Okay, he's gone from 11:55 to 12:30. When he's turning back into the parking lot, he got back-to-back calls from Poague. She didn't tell him that anything was wrong with the child. What she did was she called and hung up, and then he said, as he was parking, he was about to get out of the car, she calls back, and she's not talking to him. She hears him saying, JD, JD, JD. So he gets the pizza in the Walmart bags, and he goes into the college, into the dorm. You saw that on video as well. And if there's any portion of those that we can't send videos to the jury room because there's no way to play them back there. But if you should decide that you need to see them again, all you have to do is ask, and we certainly, the court will make arrangements for that. So he goes in the room, she's holding the baby. He realizes that there's something wrong with the baby, and he did. He testified that he asked, what's wrong, and frankly didn't testify real clearly as to what she said in response to that. We said what's wrong, but he wasn't waiting around to find out. He put the pizza in the bags down, put the pizza down, dropped the bags on the floor where they were, picked up the baby, and took off for his car, and he drove to Phoebe Sumter. At Phoebe Sumter, he went in with JD. The nurse met him and put JD on the gurney, and then he followed them to a treatment room. Now, Alan testified. So there's this thing.
I've said it a million times before, I'll say it a million times again. At this point is where the defense is trying to argue that it must have somehow been the father of the child, not her who the child was left with, but the father of the child who was somehow responsible for these injuries. If that were the case, this was a window of time in which she was alone with the child to get the child help, to call 911, go to the police, go to the hospital. Why did she not do any of that if that were the case? Even if she doesn't have her own car, because she has a phone, she could have called 911. I have a hard time believing she had nothing to do with it for that reason right there. Yeah.
That Mr. Gamble keeps making a big deal out of says that this note in the nurse's record. He says this note says that the child is limp and pale, that father present at bedside states child fell around 5 minutes prior to arrival. Okay? And that note has a time, an event time of 12:36. Okay? So Mr. Gamble wants you to interpret that as meaning that is what he told her at that moment when he went in, that he was standing at the child's bed when he told them that. And because there's other things in this note that we know, it's not exactly accurate. It's close, but it's not exactly accurate. Okay? The note says that the child is in ER, and the front is taken to ER 16. From the front entrance of the ER, he is carried by his father, who was unresponsive. The father wasn't carrying the child anymore. He got met by a nurse after he came in the door, went to the front desk or whatever, past the front desk, got met by a nurse and put him on a gurney, and that's what the other evidence was that you heard. He followed them to the treatment room, but Alan says that he didn't go in the treatment room. He wasn't bedside. He can't go in there when they're doing CPR and they're intubating the child and doing all of those things. He remains outside the room, just outside the hall, in the hallway, and he does that. He does that because that's the only place they let him go. So he's not bedside. Now, okay, by the time this note was written, he had been bedside. Okay? By the time this note is written, which wasn't actually entered until 8:04 p.m. By the time the note is written, he has been bedside. He was bedside when the child died. Dr. Busman told you that. But he wasn't bedside when they were administering treatment, and he wasn't bedside giving a history. Okay? The note's written 8 hours later, and despite everyone's best efforts, okay, it's very hard to separate all of the scurry of events that happened over the course of just a little bit of time with regard to the treatment of this child. Also, okay, Mr. Gamble says he told them that 3 times. That note is in there 3 times that he said that. He didn't tell anybody anything 3 times. Okay? The note is a nursing note on page 21 of 28 of the second batch of numbered pages. It's a nursing note. Okay? It's simply copied into the record because there's the nursing notes, there's a code blue report, there's physician notes, there's other reports, and they get cross-copied and copied on top of each other, which is why when you ask for your own medical record somewhere, you get 200 or 300 pages, they want to charge you for, and you realize ultimately there's only 20 pages of it that really matter. Okay? And that's sort of the same thing here. The same records are copied over and over again because different people in different roles have to keep them. And then when we ask for all the records, we get them all packaged together. He didn't tell anybody anything 3 times at the hospital, and the hospital didn't write it down 3 times. It's one note that was written at 8 o'clock that night.
Okay, you see right here, he's harping on this fact, like, oh, this was never said 3 times, it was just written 3 times by the staff with their records, right? Or copied, rather. But the defense will basically try and take that and be like, well, you said this 3 times, even if that didn't happen. So that's a lot of what happens in almost every fact of this case,
Alan wants to talk to him. Alan said he was emotional, that he didn't want to talk to him there, and he didn't want him to keep standing there because he was upset. So Alan asked him to go out and walked outside with him. And
I'm going to be right back in like 2 or 3 minutes. I'm going to let this play. I'll be right back.
Alan asked him to go outside, and he does. He told Alan, according to Alan, he told Alan that Poague had told him that JD had fallen out of a chair. Poague got there, and she told Alan that JD had fallen out of the chair. She specified it was one of those round beanbags, or at least he interpreted it as a round beanbag style chair. And she says he was eating chips and drinking juice, and she heard him fall over out of the chair. Not that he just simply slumped down, but she heard him fall over and hit the floor. Okay, that's what she tells Alan, not what Williams tells Alan. I mean, it's the same thing Williams told him, but it's not. But it's not his words; it's her words. Okay, there's a reality to what we do when people go back and you look at records and you look at notes and you look at reports, okay, from 2 years ago, and you ask people, you say, okay, I need you to remember line by line and word by word, second by second, minute by minute. Okay, I need you to tell me what did you say and what did they say next. And then we come into court and we have these, these prior statements, and we got reams of interviews and records from hospitals and doctors and phones and everything else, and we say, did you say that? Yeah, I said that. And they know, somebody knows they said it. They know they said it at some point back there. If you ask me, if I said it to this person, and then you ask me, did you say it to that person? Well, 2 years later, it might be really easy to say, yeah, that's what I told him too. Because it's kind of hard to delineate those things, and that's just the reality of the memory. Okay, that's the reality of the memory. Whether you're in a courtroom or you're sitting around, on Christmas Eve with your family, and you start talking about something and say, remember when so and so, and you realize that nobody there remembers it the same way you do. Okay? And you end up, like you have, people that's like, no, it wasn't. That wasn't on Christmas. That was on Thanksgiving. And it wasn't that year. It was the year before. And so, the reality is that the only person who had information about what happened to this child was Trinity Poague. And she's the one who told Alan what Jay Williams testified to, okay? What Jay Williams testified to, which is different than what Alan testified to, no doubt. Okay? What he says is that she was there and she told Alan in his presence, and that's where he heard the chair story from.
I don't even have much commentary on this part because prosecutors over here, like, what happened was, and then telling the evidence for, like, the summary of the witness testimony and what the evidence said, right? Versus the other guy was over there, like, he could have been anything. We just don't know what it could have been. And it's just like, he's like, no, we're pretty sure the evidence points to this one person. And so, it's just a whole different energy. So it's just less frustrating. It's just, I'm over here like, yeah, like, tell me what happened over here. Like, you know what I mean? I don't know.
In any event, ladies and gentlemen, the evidence as a whole shows you that it's Poague who is promoting that story, not Alan. Not Jay Williams. I'll go ahead and address it now. I'll skip it later.
I don't know who the fuck Alan is, to be honest.
He says, but ask him, did you tell Samantha Ford that you knew, did you tell her what happened? And he says, yeah, I told her what happened. I'm sure I told her what happened. And it's like, okay, well, what'd you tell her? Did you tell her he fell out of the chair? Yeah, I told him he fell out of the chair. Because that's what he told other people once he had heard it from her. But then he instead of getting the statement, the interview...
I said all this earlier. That's another thing. That's another reason I don't have, like, much commentary here. Because half the shit he's saying, I feel like I said this shit earlier when the defense was speaking.
that Fort had done with Jay Williams. Okay, what Mr. Gamble does is instead of showing the interview and saying, look, do you want to refresh your memory about this? Be sure that what you said. He doesn't do that. Okay, he's charging him with being able to have in his brain the knowledge of what he said in a 2-hour, I think it was an hour 45-minute long interview on the day that his child died. Okay, so in the 8 hours following the time that Jay Williams found out that his baby was dead, he spends 4 of those 8 hours at the America's Police Department sitting in waiting rooms or interview rooms. He spends most of that 8 hours sitting there. He spends 4 of those hours being actively questioned by Agent Fort. Okay, so did you tell her that without showing him the interview, without showing him the statement, without letting him look back over it and say, I don't know, let me see exactly what I said in that 2-hour interview. And Mr. Williams says, yeah, I told her, fell out of the chair, because that's what he had been told, and that was the only information he had ever had about what happened to his child. He told Coroner Wright that Poague had told him that J.D. fell from a chair. But Poague also told Coroner Wright that J.D. fell out of the chair, that he was in a chair eating chips and he was in distress and fell from the chair. She told Wright that Jay had been gone for 5 to 10 minutes at the time the fall occurred. Okay. That is the summons.
So there's evidence that Poague was saying something about blaming the injury on the baby having fallen. And then part of the defense had argued about the cause of the injury being about the baby having fallen. Then the father of the child had repeated that because he was thinking, could that have been true, as he was processing what had happened, when it happened. And the defense attorney tried to invalidate him for it. And I back on that again because I still don't fucking get it. But you know what I do got? I got some ice cream, alright? Yeah, don't judge me. It's the vanilla shit. I don't give a fuck. But I got this Reese's Hard Shell to go all over it. So, here we go. Yeah. Anyway.
Substance of the evidence of the people who have testified in this trial, based on their memories, based on their reviews of records, etc. That is the sum and substance of what the direct evidence is about the events of that day. But it's not just direct evidence, ladies and gentlemen, that you make decisions on. Okay? The court is going to talk to you about circumstantial evidence. Okay? What circumstantial evidence is proof of facts or circumstances, actually by direct evidence, from which you can infer other facts that are reasonable and justified in light of your experience. Sort of like if the child gets his head bashed in and his liver busted 20, 30, 15, 5, 35, 33, whatever, minutes before the doctor sees him, and he's 18 months old and he's in a dorm room on the GSW campus and there's only one person in the room with him when it happens, well, those are 2 direct facts, okay? Those are those are 2 direct facts, and the circumstantial evidence is when you take those 2 direct facts and you make the inference, which is, under these circumstances, the only thing that reasonably could have happened was this. This is really important. Judge Sizemore is going to tell you that the law does not require more or greater certainty by you if you're returning a verdict based on circumstantial evidence rather than on direct evidence per se. Okay, and that's because there is no rule that either circumstantial or direct evidence is stronger than the other. The comparative weight of the evidence is an issue for you to decide, just like it is if it's all circumstantial or it's all direct, if it's all testimony or it's all documents, if it's all video or it's all audio. Ultimately, it's up to you to make the decision as to what the evidence means and what conclusions you can draw from it. So you take those things into account, you think about it this way, you say, okay, now we know some facts, we know some direct facts. So what are the conclusions that can be reached from the direct facts? Well, I'd suggest to you that there's only 2 possibilities, okay? One is that it's accidental trauma, that's a possibility, or that it is inflicted trauma. Those are the only 2 possibilities. But accidental trauma, ladies and gentlemen, is not a realistic explanation. It's not even close to a realistic explanation in this case. It's not a realistic explanation, well, for a whole bunch of reasons. Okay, it's not realistic because you would say, how many times you fall off the bed now? Had you this bruise, and these bruises, and these bruises, okay? And they're not just bruises, okay? I'm not picking them up and showing them to you again, right? But you saw the medical examiner showed you, where they looking at the scalp on either, the skull on either side, okay? There's brain bleeds here, and there's hematomas here, and here, and here. And then there's bruises here, and here, and here. And those things don't all come at one time. Those don't come from one fall. Maybe if you fall off the side of a mountain, and you roll 500 feet, bouncing every which way, you might bruise your whole body. Okay? They might occur in one event or at one time if you're in a car wreck, and there's one impact and you get impacted from every angle. But those kinds of injuries, it is not realistic to think that they could be the result of accidental trauma when there is such a collection of them and they all occurred within the same within the same time frames, I think is what Dr. Clark's testimony was. That he thinks that those injuries, because they're consistent, they're all new, they're all fresh injuries, okay? The Dr. Oleg testified, like about the liver, for instance. She says that the liver, that you can tell that it's not an it's not a chronic condition, it's not something that's been going on, but you do that from the lab results, because you look at the lab results, and the liver enzymes are, okay, they're not 20 times higher than they're supposed to be, or 100 times higher, okay? The liver enzymes in one case are like 200 plus times higher than they're supposed to be, and the other 400 plus times higher than they're supposed to be, okay? And the reason the liver enzymes are so jacked is because it is an acute injury. It is something that has just happened within a short period of time. Now, none of the doctors are specific about that injury or about the bruises. They're not as specific. They're not saying we can narrow it down to an hour, or within minutes or whatever, because, there is a broader range in which those things could occur. But when they are there, when they aren't there, and then suddenly they are, and when they are there, they are in the presence or they're associated with or in addition to an injury that can be timed or dated, then you know that they almost certainly occurred all at the same time. Accidental trauma talks about falling off the bed. The only evidence in this trial of a fall from a bed, okay, all of it, the whole total of all the evidence. Nobody was told by Trinity Poague at the hospital that fell off of the bed, that the baby fell off of the bed. Jay Williams wasn't told that he fell off of the bed. Okay? The police officers that she ran across at the hospital weren't told that she fell off the bed, that he fell off the bed. Dr. Bussman said that he remembers, he said he didn't have a specific, he didn't know if there was a specific note, but he didn't remember for sure, if she said chair or what, but something about a fall, and he says, all I know is that when I asked her about it again a few minutes later, she completely changed her story. Okay, that's what Bussman told you. And that's not Bussman going back and looking at notes, okay, that are recorded by somebody else, etc. Okay, that's Bussman's memory. He says, I can't tell you what the stories were, but I can tell you that it changed significantly from the first time I talked to her to the second time I talked to her. Okay, so the only evidence of a fall off of a bed is this. I'm sorry, I think I skipped something here. Anyway, so you saw the message earlier, and I may have it out of order, and if I do, I'll apologize for that and try to do better next time. But you saw the text, you've heard it already, where she says that she told Jay to get on the bed, or she put the baby on the bed with Jay, and Jay let him roll off the bed. And she says, he's okay.
If you haven't watched all of the trials, I think that may have, I can't remember, it was either day or 2 or day 3, if I'm not mistaken. There's a small chance it came up in day 1, but I think it was day 2 or day 3. Look for the roommates. It was whenever the fuck the roommate was testifying is whenever that text message, whenever all of those text messages came out. Yeah, so go look for the roommate and go get some fucking ice cream.
Yeah, he's fine, okay? So, not only does she say he's fine, but her next text to Paris about what happened is this. Paris, this is when she's at the hospital. Paris says, did they say what happened or why they think that? She says, he hit his head at some point. I don't know, they won't give us much information. And Paris says, wait, didn't you say he fell off the bed last night? And her response is, I don't know, I was asleep. She doesn't know if he fell off the bed. That's what she tells Paris the next time the topic is raised. I don't know if he fell off the bed, I was asleep. The next thing she tells Paris is 3 hours later when they're talking about the skull fracture. Paris says, you texted me last night and told me he fell. That had to be it. And Trinity Poague's response is, but that was only off the air mattress. And the air mattress wasn't far from the ground. I can't text about it anymore. I don't know what's going to happen to me. So you have the one text, which is the only evidence of a fall from the bed, and in the next 2 text messages concerning that matter, Trinity Poague says, I don't know if he fell off the bed because I was asleep. Oh, and
I just processed this. Hold on, we need to go back. Apologies. Hold on.
That's what she tells Paris the next time the topic is raised. I don't know if he fell off the bed. I was asleep. The next thing she tells Paris is 3 hours later when they're talking about the skull fracture.
Yeah, no. Okay, yeah. This right here. This is what we went back for. If you did nothing wrong, why wouldn't it matter if you talked about it? And why would you be worried about what was going to happen to you? Say there was some sort of version of a freak accident. I wouldn't be worried about what was happening to me, and I wouldn't be thinking I couldn't text about it. Like, maybe even if I was worried about, oh, they might think I did it because, wow, this is such a freak accident, I wouldn't be feeling like there would actually, like, I would still be able to think there would be enough evidence for me to explain what happened, right? Say there was some freak accident in which a child in your care passed away. You know, for example, there's a recent story about some kids dying in a frozen lake, right? Or something. Like, there's some freak accident that could happen where a child could pass in your care. Say that happened, like, I wouldn't really be worried about me. I would be telling everybody what happened. Like, I can't believe this shit happened. Like, people are gonna question if you're involved no matter what. If a person dies around you, you know, you might as well tell your truth about it. But to me, only someone who they have a reason to think, you know, is guilty would be worried about that. Like, I don't know. I just feel like that's a really weird statement to make if you're innocent. Like, oh, I can't talk about it. I don't know. That didn't sit right with me. I'll have to process that more later. I'll bitch about that later.
Fracture. Paris says, you texted me last night and told me he fell. That had to be it. And Trinity Poague's response is, but that was only off the air mattress. And the air mattress wasn't far from the ground. I can't text about it anymore. I don't know what's going to happen to me. So you have the one text, which is the only evidence of a fall from the bed, and then the next two text messages concerning that matter.
Honestly, I feel like it's like an admission. Like, it's an admission of guilt. Because, you know what I mean? Like, why would you be telling someone you can't talk about a legal case that you had nothing to do with? And then they want to say that, oh, she's not involved. Well, she seemed to think she was. This is fucking wild. I'm almost done with my ice cream. Yeah, I keep adding more on top, so, you know, it's nice.
Trinity Poague says, I don't know if he fell off the bed because I was asleep. Oh, and he just fell off of an air mattress. Rolled off of an air mattress. Not only that, but the timestamps, and I think this testimony was in earlier, okay, the message about he fell off the bed was at 11:57 p.m. on Saturday night, okay? At 12:02 and 12:04, and I will tell you that I'm not 100% certain which one of those two videos that this screenshot comes from, but it's from one of those two, either at 12:02 or 12:04, okay? Either, no, maybe more than 10 minutes after the child fell off the bed, but it is 5+ minutes since she sent the text saying he fell off the bed, okay? That is the state of J.D. Angeles, okay? And you saw the video in court. That's a screenshot, of course. And you look at it, ladies and gentlemen, and there is no big fresh bruise on the corner of his forehead. And he's sitting up, and he's drinking out of a sippy cup, and he was holding on to her hand and playing, as you saw in the video. Dr. Oleg, okay, who's also not affiliated with the GBI or anyone else, other than her own practice, Dr. Oleg told you that there is zero possibility that following this injury, the child could be doing these very things. The nature and extent of the injuries can't be explained by a fall from the bed. Too many injuries, too serious. They don't happen like that. And Mr. Gilbert says, you know, he's like, Dr. Clark, you just can't trust Dr. Clark. Now, he works for the GBI. You know, he works for the crime lab, which is true, he is technically an employee of the GBI. He says, you can't trust Dr. Clark. You know, because Dr. Clark's going to say whatever they want him to say, I guess, you know, is what he's implying. It's not the case. Okay? Dr. Clark does autopsies, right? Sometimes the autopsies are, this is a natural death. This is a heart attack. Sometimes the autopsies are, this is an accidental death. You know, sometimes the autopsies are, you know, the death is unknown, it's unexplained, okay? And in those, he doesn't get called to testify because nobody's being prosecuted for murder. Okay? The only time he gets called to testify for murder is when he made the finding that this evidence establishes that this was a murder, okay? He doesn't get called to testify in a murder case because we decided that, oh, we got a murder case, well, hell, what are we going to do? You know, let's call Dr. Clark. That's not how that works. He does the autopsy. He did the autopsy 3 days after the child died. Okay, issues a 6-page report, orders all kinds of stuff. Okay, comes into court, and yeah, you know, we're going to call him, right? We're going to call him to testify because his actual live, in person, with his hands and a scalpel, findings were that this child was murdered. So of course we're going to call him. So Mr. Gamble says, you know, he says, but Dr. Clark ain't slick as he thought he was. He says, because I got him. I got him good now. I had this article. He got an article. Where's he going to find the article? Was that up here?
I don't know that it is. I think they gave it back and couldn't send it to the jury, so I can give it back.
It's all right.
You know, I will say, he has been more reserved previously in this court case, and now in his closing argument rebuttal thing, whatever the fuck it's called, he has like this heightened sense of emotion as he is speaking, and it comes off as passion. Whereas the other attorney, he has had his energy real high the whole time, but because he has a high energy, while he's trying to discredit everybody, but he doesn't have the evidence to really back up the shots he throws, he comes off as if he's real aggressive and real mad and real angry and real just blah 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 blah, you know. And it's like, to a point, fighting energy can be good from an attorney, but on another level, I think that works better when you have the justification to do it. And in his case, he didn't. It was a swing and a miss. So here, I feel like you can look the difference in their approaches and see how he is more believable to the jury as giving you a valid source on what occurred. You know what I'm saying? And I think that matters. Like, if attorneys are going to be, you know, it's one thing, like, every person, you know, has to have a valid legal defense, or you could have people in jail that don't need to be there, which is already a thing, but you could have even more of it. But it's also, it's like, this is like fucking, it's a whole nother level. To a point, you have a due diligence to your client to give them a good defense. But my struggle with this defense attorney is how many ways, from the differences in opinions he and I have on the evidence of the case, to how I saw him treat the witnesses, to how I don't see him have anything to defend his client with in terms of a valid alibi or another valid explanation for what occurred, to how at one point he was trying to argue that he didn't think the father of the baby should be in the courtroom because he would be a witness. But then he wasn't able to cite any sort of law for this. And I just feel like that's such a key point in the case. Shouldn't you be prepped for that? I don't know. Am I wrong for thinking his head was not in the game for this case? Like, maybe I have made some claims like, oh, this attorney sucks ass and stuff about Mr. Gamble, whatever his name is, for the defense. But maybe it's just that his head isn't in the game for this case, or that he was dealt with such a bad hand, this is the best he can do. But am I wrong for thinking like this is not good enough? I don't know.
Okay, this is the thing about the article. Dr. Clark says, well, give me a minute, let me read it. We took a little recess. Okay, he read the article. Mr. Gamble comes back and he says, 4-year-old child in Chicago fell off an adult bed, died 2 days later of an epidural hemorrhage. 9-month-old in, Portland, fell off of a table, suffered an injury, was taken to the hospital, and they did not have any findings, died 2 days later from brain trauma. And Dr. Clark says, yeah, he says, I'm not only familiar with Dr. Case or whatever her name is, he said, I'm familiar with her, he says, I'm familiar with the article, I'm familiar with it, he knows the other doctor too that's cited in there, Omabo or whatever his name was, who she's citing, okay? He says, yeah, I know these people, okay? And I know this article, now that I've looked at it. He says,
dude, I can't even give the prosecution a moment to shine. I always spend like his whole time of him speaking bitching about the defense. I don't know why I'm like this.
They're talking about epidural hemorrhages, okay? An epidural hemorrhage is entirely different than a subdural or subarachnoid hemorrhage. And he explained on the stand, and I hope that you got it because, frankly, I probably didn't understand it well enough to try to repeat it to you. But basically, there's different layers between the, from the skull to the top of the scalp. There are different layers. There's the glial layer, which is the fibrous tissue that's immediately attached to the skull, and then above that, there's the dura and the something and something else, okay? And you can have brain hemorrhages, you can have hematomas that result. And they occur in different levels, and depending on what level it occurs on, it's subglial or subarachnoid or subdural or whatever. The article was only about epidural hemorrhages. And he said we had a very small epidural hemorrhage in this case. The significant ones were subdural, subarachnoid, and subglial. Okay? Article has nothing to do with the facts or the circumstances of this case. Furthermore, you go to the next section of the article, and it says that in almost all cases of subdural hemorrhages in a child, it is the result of abusive head trauma, which is exactly what it is the result of right now, in this case. How many times you fall off the bed? There's an occipital skull fracture, which is back here, the back of the head. It's a hard bone to get to. It's a hard bone to fracture because your shoulders absorb some of the blow if you fall backwards, and this part of your head absorbs some of the blow. And it's the thickest bone in the scalp, or in the skull, rather, the occipital. It's the thickest bone in the skull, he said. Hard to crack, hard to bust, hard to split. It not only split, not only busted the full thickness, the fracture went all the way through the occipital bone, but it continued into the parietal area. Okay? Now, Dr. Clark didn't call it a parietal fracture. He called it...
The thought of a baby experiencing this type of pain and trauma is terrible for, you know, because, yeah, like, I feel so bad for this baby. Yeah, that's terrible.
A separation of the lambdoidal suture, okay, which is where the two pieces of the skull come together over here, right? And the reason he called that is because it was on the suture line. Okay? But the sutures really, they all develop at different times. I mean, the sutures solidify, and they come together and ossify the bone at different times in different children, different ages, and depending on where it is in the head, you know. But since this was bone, okay, it was just on the lambdoidal line. Okay? The other doctor who did the X-ray, and this is what Jill Oleg testified to. She said it's an occipital and parietal fracture, okay? But in any event, the fracture goes from here all the way up here. There's bruises on the face side in front of the head. There's a lacerated liver and a lacerated adrenal gland. He didn't have any of these conditions or injuries when he got to Americus on Saturday night. So he fall out of a chair, right? We went from falling off the bed to falling out of a chair. And I will tell you the same thing that I told you about the other fall, because it's just as applicable. The nature and extent of the injuries cannot be explained by a fall from a chair, particularly not a fall from this chair. That chair, the part that you would fall over, okay, is only 13 inches off the floor, okay? So if you fell over, that, you know, the only way you could fall out of that chair is to fall forward. You can't fall backwards in it. I mean, y'all, you know, everybody here probably has seen one of these chairs or something like it before, I bet, and you know, your kids probably have had one and all that, and you know, it's a big fluffy, probably is kind of a beanbag thing. I mean, the cushion's beanbaggy, you know, it's not a whole beanbag chair, the cushion's beanbaggy. It's a big fluffy thing, okay, when you sit down in it, okay, the way it's shaped like a dish, you sit down and you basically sink into it, okay? You couldn't turn the thing over backwards, you know, if your life depended on it, not from inside of it, okay? And if you fell forward out of it, even if you were only 18 months old, if you fell forward out of it and landed right square on your face and busted your forehead and did this and that and knocked out an eye and all kinds of things, you still wouldn't fracture the parietal bone and you still wouldn't fracture the occipital bone. If the injuries cannot be explained by falls, the only realistic possibility is that this child was a victim of inflicted trauma. Okay? This is not another explanation. I mean, it's either accidental or it's inflicted. And if it's accidental, I mean, if it's not accidental, it has to be this. And if it has to be this, if it's this, then it has to be by who is the question.
The defense's argument is that the dog ate their homework, I think.
Okay? So, Jay Williams. Did Jay Williams inflict the trauma on this child? That's one hypothesis he offers. Okay? I was kind of stunned by this one. The other possibility he offers is, you know, JD himself. You know, he's active, climbing, growing, 18-month-old baby. You know, he might have done this himself. There's no telling what he climbed up on and fell off of. I'm serious, that's what he said. He said that to you.
Maybe the baby was trying to escape the girlfriend. Wait, that's fucked up, though, because of what happened. I'm sorry I said that.
Like, you gonna believe that? Like, this child?
That's fucked up. I didn't mean that the baby would be trying to kill himself. I meant that the baby would be trying to climb away.
You know, if somebody had come out of that bathroom where they were, okay, and the child had been laying face down, you know, not breathing and unconscious and in respiratory arrest and with brain fluid seeping out of his mouth and his nose, okay, if you'd been laying like that face down, you know, on the side of the desk over here, and that was the only injury he had, you know, sure as heck it could be accidental in that case. Yeah, I mean, it might be. But to think that the kid climbed out of, it's too dumb for me wasting more time. I'm running out of time for me just wasting more time talking about. That kid did not climb on anything and fall off and hurt himself.
I love this. I agree with him. He's like, it's just too dumb for me to really fucking argue about. I agree. Like, I fucking love he straight up just fucking said that. You can just say that shit. He did. He just did. He said it.
The only other option.
And mind you, again, I think I said that earlier too.
The other person is Trinity Poague. Now, I'll grant you that this case depends in significant part on the credibility of Jay Williams. I mean, it does. You know, every case has witnesses. Some witnesses are more important than others. Some witnesses are essential to a case. Some witnesses, you know, are kind of interchangeable. You can use this one or that one or whatever to prove whatever you're trying to prove. Jay Williams is an essential witness in this case, okay? But I'm telling you, when you assess his credibility, the judge is going to give you a charge about assessing credibility, okay? Like you consider their manner of testifying, their circumstances, how they would know the facts and circumstances that they're testifying to, their ability to observe, whether it's corroborated by other testimony, okay? His testimony was corroborated by clear, undisputed evidence, okay? There is a video from GSW that Chief Lewis played for you, okay, that shows him walking out of the dormitory at 11:55, and shows him walking back in at 12:30, and shows him running out with a baby squeezed up against his body right here at 12:31, okay? He wasn't there. Not only that, said he's going to get a pizza. Well, how about this? There's pizza, okay, right there on the end of the bed. Says he's going to Walmart. Well, there's Walmart bags, and there's stuff in the Walmart bags. And reach in, and you take it out, and you take a picture. So, well, there's Walmart bags. There's a receipt that says these things in this Walmart bag were paid for at 12:14 p.m., okay? So if he left the dormitory at 11:55, and he's at Walmart walking out at 12:14, I'd say he's moving pretty efficiently if he managed to get there to pick up items and get through the cash register in 19 minutes. But he did, okay? His statements to Allen and Mathis, okay, to Mathis Wright, I said Mathis, I should have said Wright, I'm sorry. His statements to Lieutenant Allen and Reverend
I wonder if those tears, I did not even feel like going back for it, but I wonder if those little tears that we just saw, if that was like the show for the jury, or if, right here, if that was her realizing she's fucked. Is this a show for the jury or her realizing she's fucked? You tell me. I don't know. I think a little bit of both. A little bit of both. Because she was laughing. Day 1, 2, and 3, this bitch is laughing during trial. So I have a hard time believing all of a sudden now she's upset about it. So that's why I'm over here like, this has to be a show for the jury. But then I'm over here like, maybe she is upset for herself. I don't know. Maybe she's realizing she's fucked. Okay.
Well, there's Walmart bags. There's a receipt that says these things in this Walmart bag were paid for at 12:14 p.m., okay? So if he left the dormitory at 11:55, and he's at Walmart walking out at 12:14, I'd say he's moving pretty efficiently if he managed to get there to pick up items and get through the cash register in 19 minutes. But he did, okay? His statements to Allen and Mathis, okay, to Mathis Wright, I said Mathis, I should have said Wright, I'm sorry. His statements to Lieutenant...
I know I'm like at 1.5 speed, but I'm entertained how it's like a clip of her wiping her away, then it goes away for a second, comes back, she's got like the napkin dabbing, like, I don't know, it just feels so dramatic, and it is a dramatic event to have occurred, but for her to have gone the past 3 days laughing and smiling in the trial to this is where I'm like, it's just a switch up for me, so if she had come into it more like that, then I don't know, I wouldn't be questioning it, because I'd be like, even if you feel a way about it, it would have been consistent, right? Versus the way she was going from smiling and laughing to crying, it's like, interesting, okay.
Lieutenant Allen and Reverend Wright were consistent not only with what he told them, they were consistent.
Oh, the Reverend is the coroner, by the way. He happens to be a Reverend.
With what Poague told them. Okay? They're consistent with what she told them about falling out of the chair, etc. Okay? Big deal about the hospital records. Ladies and gentlemen, when you consider the credibility of this witness, I'm telling you, the hospital record does not disprove his testimony. It barely contradicts it. It's almost it's not a bump in the road. It's a pebble of sand that you walk over. Okay? The hospital record doesn't disprove his testimony. There's no one who comes in here and testifies and says,
I will say that must be some pretty good waterproof mascara, though, because it does look like she's wearing mascara, and no, it does not look like it's smudging.
This is what he told me. I wrote it down right here word for word. I know this is what he told me. Okay? There's a hospital record that's assembled by a team of people who are working desperately to save the life of an 18-month-old child. Okay? And doesn't disprove anything about what he said. His GBI interviews do not impeach his trial testimony. Okay? Now we talk about this for a second. Right? I talked about it briefly a while ago, but I'm going to go back to it for just a moment. The GBI things, okay? Pardon me, I'm sorry, I have to take a sip of this water. What he told Samantha Ford was that he didn't know what happened to the child. Okay? Now, defense counsel didn't play the interviews for you. He didn't refer him back to specific questions. He didn't refer her to specific questions. To say, what questions did you ask him? Did you ask him what happened? He says, I don't know what happened. She says, have you heard anything? The only thing I've heard is what Trinity told me. What Trinity told him isn't nearly as important for summarizing the interviews. Okay? It's not nearly as important in Jay Williams' interview summary as it is in Trinity's interview summaries. Okay? So, he says, well, what did he do? What did he say? He said, well, he told me he didn't know. That's what he said. He said he didn't know. And it may very well be that without those questions being in front of you to know what questions were being asked and how they were being asked, that may have been the full and only and absolutely correct answer. Moreover, his trial testimony was credible. The guy sits there, not showing a lot of emotion. It's been 2 years. You come into a courtroom, there's a lot on the line. You're seeking justice for your baby. Okay, there's a lot on the line. And there's y'all, okay? And y'all are a wonderful looking group of people, okay? But I'd be scared to death too if I were sitting over here, okay? And I'm testifying, and I'm asking questions, and Mr. Gamble's asking questions, and y'all are all, giving him a mean eye, not kidding, you really give him a mean eye, but you're all looking at him, okay? You're paying attention to him, okay? You're focused on him, and he knows you're focused on it, right? That is a tough position for somebody to be in, and you try to control your emotions because you don't want, anybody would. You try to control your emotions because you don't want to break down. You don't want to look, like Jell-O on the witness stand, okay? So you steel up, you tighten up, you say, okay, I'm going to get through this, and you sit there and you do it, you answer questions cleanly, directly, okay? You answer them crisply, and that is the thing that you think about, that you will recall from his testimony. That guy didn't evade a single thing, okay? He's not trying to dodge anybody's questions. He's not dodging, he's not ducking and dodging, he's not...
He did even say shit that didn't make him look good, so, he did seem to be pretty straight up, if I'm not mistaken.
Even you just, I don't know, I don't remember. That was a long time ago. He's answering the questions the best of his ability based on what he remembers at the time he's sitting there. His demeanor was appropriate. His grief was palpable. At this point he's testified, okay? He's in the courtroom when this happens. And Mr. Gamble says, well, about this jacket that the baby supposedly threw up on. Supposedly threw up on. Okay? So I go back in the records, okay, in the recordings that we have, right? And I look and I say, are there any pictures that actually show the jacket where it's puked on? Well, sure enough, you have it back there, you look at it a little closer, and you see just how prominent that is, okay? It is all down, wrong side, it's all down this side of the jacket, okay? It's not only down this side of the jacket, it's inside the collar. Okay, it makes my stomach weak just to hear that. Okay, but listen, I love my children. I love them with all the world. Okay, but my ex-wife was a nurse. Okay, and when youngins started throwing up, okay, I did everything. I changed diapers, I cooked meals, I did all kinds of stuff. Okay, youngins started throwing up. I'm like, Betsy, come here. Because I couldn't stand it. Okay, it makes me cute for them to do it. This guy tucks that child against his shoulders, gets in a car, races to the hospital. And while he's doing it, this kid is puking on him, not on his clothes, not on the floor, not on the seat of the car, or in a baby bed somewhere. He's puking down his neck, down his shirt, inside his jacket, okay? He doesn't let go. He doesn't stop holding him. He doesn't stop going to the hospital. He doesn't get to the hospital and say, here, somebody take this nasty young'un, look, he's done yacked all over me. He carries him in until he puts him in the hands of somebody who might try to save his life. And we're gonna mock him and say, supposedly someone threw up in his jacket. Come on. He was credible to what he testified to. And ultimately, ladies and gentlemen, there's this. He has no reason to harm his son. And Mr. Gamble says, you know what? They should have gone to Colquitt and talked to neighbors and friends and all this kind of stuff and asked about all that. And, they should...
One of the points he's going on here, though, it's like one of the ways that the defense attorney was trying to discredit Jay Williams was by acting as if the puke on Jay Williams' jacket didn't come from his baby or something. And it's just like, and he literally responded like, I never washed that jacket, you could test that today. And to prove that it's the baby's puke. I don't know if he was trying to imply that maybe Jay was drinking or something, or just whatever he was trying to do to discredit Jay. But like he harps on the most ridiculous things to try and discredit him, and everything he does makes him look like an asshole who doesn't know what he's talking about. And so that's where I think where the prosecution's going now, harping back on that again, because the defense spent so long on this bullshit. All right, so yes.
Should have been investigating Jay Williams. Well, first of all, they make him sit through 4 hours of interviews, on the first day, right? And they take his phone, okay? They do a search for a search warrant, they snatch his phone too, not one, two phones. They snatch 2 phones from him, okay? And they're investigating, but and when they're the dormitory interviewing people, okay, they're not interviewing people to say, tell me what you know bad about Trinity Poague, okay? They're saying, tell me what you know about this baby being in the dorm last night, And then from there, it may go on to other questions, but saying, what do you know about the baby being in the dorm? Left, gone, okay. So that's what they're asking for. They're not trying to build a case or attack the character of this girl. That's not what they're doing, okay? And there's no reason to go to Colquitt, because I tell you this, okay? You got an apartment in Colquitt, right? If this child had died in Colquitt, Georgia, on Sunday, January 14th, 2024, okay? And Trinity Poague had been there in Colquitt with him when it happened? You think they're going to be coming up here talking to people that live on the dorm? No, they're going to be talking to people in the apartment next door, in the apartment across the street, you know, the people he sees in the parking lot, the people he sees at work. But those people don't have relevant information in this case, okay? They might have relevant information if this child had died of malnutrition, okay, if he had died as a result of, you know, septic shock for some wound that didn't get treated, okay, if there was a negligence case or something like that where you have a baby that just doesn't get taken care of, okay, where defects have been involved, all these kinds of things, you have that, then sure, you go interview the neighbors, etc. Okay, J.D. Angeles died because something or someone smashed him in the back of his head and cracked his skull open, and then smashed him again and split his liver. Okay? He didn't die because he had some sort of chronic abuse. He didn't die because he cried at night, you know, and the neighbors somewhere else didn't hear him. Nobody's aiming for Trinity Poague. Nobody's aiming for Trinity Poague. You know, hey, I'd rather have a different defendant, okay? You know, if it were me, right, if I got to choose who my defendant is, you know, I mean, I'd rather have somebody that looks mean and surly, you know, and is older, and somebody looks at him and says, oh, you know, he just looks terrible. That looks like a guy who would do this. You know, that's what I'd rather have as a defendant. Not an 18-year-old college student, or, you know, 19, 20, whatever she is. They're not at.
Honestly, if you pulled the defense attorney off the street and accused him of murder, he might be believable because he just looks kind of angry and he acts mad.
Trinity Poague. They're trying to determine how this baby died and who was responsible for it. Now,
it's been a little over an hour, so I'm going to let the jury have a brief recess. We're just going to make it a 10-minute recess, and then we'll let Mr. Lamb conclude his argument. Okay?
thank you, Archie.
One eternity later.
So, now I'm going to switch. Let's skip through the break a little bit here, and we're going to go ahead and prep for double time because I like to go back a little before just so I don't miss anything. Oh wait, no, they don't go to break immediately. Hold on, I think he's going to finish his statement. My bad. Okay, well, we're about to double time through. Oh wait, no, they do go to break immediately. Okay, hold on.
Just before 12:30.
Okay, so we're double timing through here. Let's see. We're gonna skip all that. Let's go back. Shit. Are we about here?
First degree. Y'all see that where I changed it? I know that. That's why when we only addressed aggravated battery, that didn't sufficiently cover it. So I changed it. Okay, let's bring the jury back in.
I'm gonna double time this shit. I'm over here like, this bitch is guilty as fuck, and
I have the papers to prove it.
And yeah, and if you are asking me if I am having fun,
Most fun I've had in years.
and if you're asking me how do I feel,
Speaking for myself, I've never felt better.
and if you ask me if I think she's going to jail, then I would tell her,
And there's absolutely nothing you can do about it.
and if you're asking me what the defense attorney should do, I would say,
Take a look, it's in a book, a reading rainbow.
okay, that's all I got. Let's go.
All right, Ms. Lamb, you can conclude your argument.
Oh,
Okay, said that, you can see, but not only is he's a court, but the things he did, his actions, the way he came out of the door and talked to that child, and all that, and, you know, no matter what they ever asked. I certainly never asked until it came up in this trial. But then he testified to it. I said, so you're talking about your jacket, and they're talking about why we didn't collect the jacket to test for vomit, and he says, well, I guess you still could, and so that's what, we'll put him back up on stand later, if you'll recall. And I said, so do you have the jacket? And he says, yeah, I've got it. But where is it? Is it home? I said, what's it? He said, I never watched it. Sure either. They're there. I said, well, why have you watched it after 2 years? And he said, because it's the only thing, that's the last thing I have left from my baby. Hey, that guy is not going to beat this young to death, okay? Gamble's giving you a 5-minute window in which, I'm sorry, that hand up.
wait, that is my bad. I just realized I've still been on double time. Let me put this on 1.5. That's too fast. And we are going to backtrack it just a little here. And oopsie.
First degree. Y'all see that where I changed it.
Keep watching it, fuck it. But
I know
at
that.
least
That's why when we only addressed aggravated battery, that didn't sufficiently cover it. So I changed it. Okay, let's bring the jury back in.
That's my bad. I forgot to take it off the 2 times speed. Let's see. Replay. You have it straight today. I was having so much fun with those clips here. Okay. What happened was, visit my site at noladeafchild.com.
All right, Mr. Lamb, you can conclude your argument.
Talking about Judge Williamson said that you can see by the way, not only he's demeaning in court, but the things he did, his actions, the way he came around the door and talked to that child, and all that. And you know, to my knowledge, they had never asked. I certainly had never asked until it came up in this trial. But then he testified to it. I said, so you were talking about your jacket, and they're talking about why you're talking about why we didn't collect the jacket to test for vomit. And he says, well, I guess you still could. And so that's what put him back up on the stand later, if you'll recall. And I said, so do you have the jacket? And he says, yeah, I got it. But where is it? Is it home? He says, I said, what's it? He said, I've never washed it. Shirt either. They're there. I said, well, why haven't you washed it after 2 years? And he said, because it's the only thing, that's the last thing I have left from my baby. Okay, that guy is not going to beat this youngin to death. Okay, Gamble's giving you a 5-minute window in which, I'm sorry, that hand I heard on the table saw and it looks funny to me when I hold it up. He's not going to give you, he's giving you a 5-minute window, okay, where he says it had to happen. You know, that Jay Williams could have done it, he could have done it in this 5 minutes while she's in the shower. Never mind, they're still in the same damn dorm room, okay, but he says it could happen in this 5 minutes. That she's in the shower and he's out there with the baby. Okay, there is nothing about Jay Williams that would lead you to believe or support the conclusion that he would have done this to his child. Who had a motive? If you could have a motive, right? Like these cases are hard. Okay, I think Mr. Gamble may have misinterpreted me when I said that this is easy. I'm talking about that element of the decision-making process becomes easy when it gets to this kind of a case. Okay, but these cases are hard because these are the cases where every jury is going to give every defendant the absolute most presumption of innocence and the most benefit of reasonable doubt ever, because in your heart of hearts, like every other living, breathing human being, okay, you don't want to believe that somebody could do something so terrible to somebody so innocent. Okay, nobody wants to believe it, right? So if you get past that, ladies and gentlemen, your deliberations, you get to the point where, you know what, I believe it, okay, you've passed the reasonable doubt stage, okay? because you're giving her anybody else, you're giving anybody in this position, because you don't want to believe it. Nobody wants to believe it. So how do you make yourself believe it? How do you accept that Trinity Poague could do such a thing? Okay, yeah, so she have a motive. She resented and ultimately despised that little boy. Okay, now you know this from her statements, her text messages, etc., starting back in August of 2023. Right, starting in August of 2023. These are in evidence. Remember, they started.
Man, say what you want about the dude, about what could be perceived as unhealthy choices. Oh, god damn it, is my captioner not working? This is unfortunate for me. Hold on. Fuck. Let me refresh this. Okay, sorry, capture was not working. Alright, I was saying, say what you want about perhaps unhealthy choices that could be perceived made by the father of the child. But, shit, what the fuck was I saying? Oh yeah, you know what? Yes, if he wanted to, not be in the role of a father, if he wanted to, give the baby up, I feel he could have already done so a long time ago, and the fact that he had it would be perceived as proof that he did want to take on that role, even if he may not have, had the best resources to perhaps take what others would perceive as a better approach to certain decisions that came out. I still feel like nothing that came out would indicate that he had been part of abusing the baby ever, in my opinion. But, yeah. Okay.
These exhibits, these are the text messages that came from Paris Permore's phone between her and Trinity Poague. He started the back and moved forward because because that's the way they're stacked up.
I would say the closest negative thing would be, like, he was aware of her resenting the baby, essentially, and still stayed with her. And so I would say that may be the closest thing, if I'm not mistaken about that, to something that I could see that would be a direct cause of harm to the child that I really disagree with. But other than that, that's literally the closest thing,
Here. And She says, I'm going to sleep in your room. I can't do JD crying that much. Hopefully he's in a better mood in the morning. Okay. Then she's talking about getting in the shower, and she puts him in the washroom in the shower, and he gets water spraying on his face, and he apparently didn't like it and was acting, reacting to it or whatever. And she says, I'm trying to take a shower, and I had to bathe him, and I just sat him down and let him cry because I'm not about to baby him. Okay. I'm not going to baby a baby. When she was talking about Jay Williams, I'd say, I don't blame you, girl. I wouldn't baby him either, right? No, grown person. She's talking about a little kid. She's talking about a kid that stands that tall, okay? That's unsteady on his feet still. And she said, I'm not going to baby him. The witnesses that came and took the witness stand that were called by the defense said, oh yeah, she didn't like that young man. She didn't like him. She didn't like him. And not only that, he didn't like her. He didn't like her. She sends more messages. In August 17th of 2023, she says, why do I feel anger towards JD? When we were in the bed and JD kept touching Jay's face, I almost cried. Okay? Because the kid is being affectionate towards his daddy, it's upsetting her. And Paris doesn't understand. She says, what do you mean? Like you feel anger towards JD? She goes, I don't know, not jealousy, but I want to love him. But instead of loving, I just feel like angry, like I want to punch him. Laughed my ass off. Oh my God, that sounds so bad, doesn't it? Yeah, it does. It does. It does sound that bad. And then the explanation comes in the next two messages. Ever since he's gotten here, Jay has not touched me. He's currently on the floor. Okay? The baby is interfering with her relationship with Jay Williams. Later, 5 days later in August, she sent a message to him, to Jay Williams, and she said, I told you from the beginning I would always try to love JD the same as mine, but since me and you have gotten serious, every time I see him, I just get angry at the world, and I just have a gut feeling of anger. I don't know what it is.
And mind you, that's in August. The baby passed away in January. So he was aware for months that she had resentment, in my understanding. To me, the moment he was made aware of that, he should have called it off for good. But, so I could see it is dangerous to bring your child around someone who's saying something about that, like that about your child. But other than, perhaps like things like that decision, or you could say, maybe perhaps the child's diet was not the healthiest or something, but nothing indicates to any form of physical abuse, in my opinion, from him. And so the defense making that allegation is pretty wild to me, particularly when they have no evidence to back that up. If they had made that allegation and then came with some evidence, it would be an oh fuck moment, and that would really shift some reasonable doubt. But for them to make that statement with no evidence, and all the evidence still points to her, does not help them, in my opinion. Instead, it just creates shared culpability because she did nothing.
But just seeing him makes her angry. In December, she sends a message, and I'm gonna come back to it. Let's go to January. The day.
Oh, and by she did nothing, I mean in that scenario, she did nothing to help call the police, and she would be a participant, or enabling of the situation. Not like she didn't, she would have done nothing to help the baby. Not that she did. I don't think she was involved. I do think she was involved. That's what I mean. You know what I mean? Yeah. All right.
The night before, was murdered. Says, what are y'all gonna do about tonight? That's Paris's text. And the response is, no clue. I guess I'll probably sleep on the air mattress in the sink area. I can't do being around JD anymore. He hates me and I hate him. And if you examine her conduct towards the child, ladies and gentlemen, no, you will see that in fact that is true. There's an old saying that says, when people tell you who they are, believe them. November of 2023, she told Jay Williams that he had hit his face, had hit his eye, that he bruised his eye or cut his eye, injured his eye, that she was cleaning up near the cabinet in the bathroom, and she didn't realize he was behind her. She opened the door or the drawer. I don't remember which one he said. But she opened it up, and she hit him in the eye. Hit him in the face. She said, I felt so bad. I felt so bad, okay? Where is JD when he gets the blow to the face, okay? With Trinity Poague and nobody else. He ain't with his daddy. He's with Trinity Poague. In December of 2023, she sends a message that says, Jay, this is December 17th. She says, Jay, I don't know if I can do this anymore. This weekend was a struggle for me, and I don't know what to do. I love you so much, but letting JD hit the wall and see the damage it did really hurt me, okay? What in the world is that about? Hitting the wall. I asked Jay Williams when he testified, he says, I don't know.
Yeah, that's a lot, How could I understand babies and kids, you know, they get hurt a lot, they run into shit and blah 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 blah. But what are the chances that within such a short time frame, because mind you, this is between around August and January, if I'm not mistaken, so about 5 months. What are the chances that in that time frame the baby's going to run into the drawer, fall off a bed, fall off a couch, run into the wall, and you know what I mean? I don't know. I don't know. I just feel like that's a lot. Like, I understand some kids are more rough than others. They run around, they do more crazy shit and stuff like that. But I have watched a lot of kids. I've worked in childcare before, and I just feel like that's highly unlikely for a child to seriously injure themselves. You know, because usually when a kid runs into something, it's literally not that big of a deal. Half the time, they don't even have fucking bruise. Like, there's nothing wrong with them usually. It's just like an oopsie, they fell down. Like, okay, get the fuck back up, kid, you'll be fine. Not like that, but you know what I mean, basically, like, summary. Yeah, fucking, like, I don't know. It's alarming. It's alarm bells. So they're trying to twist that back. The defense is trying to twist that back on the father of the child. But I just find it real interesting how the alignment of those injuries correlates, in my opinion, potentially with some of these messages here.
I don't know what she was talking about when she talked about him hitting the wall. That baby was terrified when you heard those people that said he cried and cried and cried when she was there, and he would stop crying when somebody else picked him up. That was his reaction. There's an old saying, something like, you know, I never trust people who don't like dogs, but if a dog doesn't like a person, you know, I trust them completely. And I submit to you that basically the same thing is true of an infant. Okay? Like, you don't like babies, you don't like little kids, you know, you don't think they're fun.
You know what? I feel like that's true too, because babies have, I mean, some kids are just real friendly. They don't really care. You know, they'll be friends with anybody, but also sometimes kids do have a sense, like if they don't like you, there will be a reason.
And you know, I don't know, cuddly, snuggly, this wonderful, you know.
And some kids just don't like anybody, but some kids don't, like if they usually like people, particularly for example, like they're usually good with people and they don't like someone, there's usually a reason, you know.
You know, I'm sorry. If you're not that person, okay, and little kids know it, okay, they know. It's like, you know, they're not going to go to that guy, they're not going to go to that girl, they don't want any part of her, okay, and there's these things that have happened, and they happen when he's with her. Okay? And in this case, ladies and gentlemen, this is really important. I'm going to try my best not to run out of time, and I'm sorry, I didn't mean to talk this long. In this case, he says she hasn't given any confessions or anything, you know, like they don't have anything on her. That's what Mr. Gaines said. I wouldn't have said that. Couldn't say that if he hadn't said it first.
I apologize, I'm distracted because the following thought of mine is ageist, but wait a minute, I'm gonna make it once it pans over to her again. I'm gonna pause and say this. Hold on.
There's not. He's right. There's not. Okay, but there are implicit admissions that this case happened under her care, under her eye. Okay, there are implicit admissions to this happened. One of those implicit admissions is that she lies about what happened. Okay. The second one of those implicit admissions is that she changes the story. She creates essentially two separate events in talking to two separate sets of people to explain it. Okay. Third, she sends the text when she's at the hospital, and she sends the text to Paris. You know, she says, I babysit all the time, and nothing like this has ever happened. Okay? Now you parse that statement. You think about what that statement means. Okay? If I say, Stephen Douglas drives my lawnmower all the time, and nothing's ever happened to it. Okay? You know, until now. Right? I'm blaming Stephen Douglas. Okay? I'm saying this is different for Stephen Douglas. He drives my lawnmower. He doesn't normally break it. You know, but he did this time. Okay? If I say, if he breaks my lawnmower, okay, but I say, I've had this, you know, I have had this lawnmower for years, you know, and nothing's ever happened to it. Okay? And then I turn around and say, you know, it's an implicit admission, and my analogy may not be very good, but I think that you get the point. Okay? That if she wasn't involved in this, if she didn't do anything, then the answer is, I don't know. Not he fell off the bed. Not, oh, no, went off the big bed, it was off the air mattress. No, fell off the chair. No, didn't fall off the chair, slumped over in the chair or something. Okay? I don't know is the answer if you don't do something. But if you do something, you're trying to explain it, or trying to absolve yourself of attention and criminal responsibility, then you come up with other things and other people to blame, etc. All right? I've left this part for near the end, and that is talking about this offense, malice murder, okay, which is a separate charge in felony murder. A person commits the crime of murder with malice aforethought, he causes the death of another human being, okay? The court is going to charge you.
So, first of all, I feel like those messages are enough to find the malice. Like, I think there's a high possibility she gets charged with the malice murder thing. Second of all, I can't believe she's only 18. Am I ageist or misogynist for thinking this? Like, I cannot believe she's only 18 with some of the lines on her forehead above that she has, because I'm just now getting them. And I think I have them from being angry and upset, you know, or even when I squint too. But like this, you know, like being angry mostly, I think also does not help. And just anything kind of like over time, even though your body, like even when you're younger and you make expressions, you'll have those lines. But like because your skin has, I think it's more collagen or some shit like that, it has, you know, more shit that helps your skin look youthful and bounce back, but then over time you lose that, and so your skin that doesn't retain the bouncing back, and so then it starts forming those lines, you know. That usually happens in your later 20s, mid 20s maybe, but later 20s to 30s. And I'm 32 and I'm just now, like, I've started noticing it around 28, 29, but I felt like it would kind of go away sometimes, you know, but now I'm really noticing it starting to stay around 32, some of the lines on my face. And I just feel like if she was 18 at the time of the murder, and that was about 2 years ago, that would put her at maybe 20, maybe 21, I don't know, depending on when her birthday is or some shit. Now, I feel like she's real young to have some of those lines on her face, unless she spent a lot of time with her face in like scrunched up positions, you know, because that's what it does take to, like, it takes either having scrunched your face up, or, you know, or moved your face in that way from expressions over time to get those lines, or when you're younger, you know, like that's like, it's like, I don't know, that's like, you know what I mean? Like, I don't know, am I using the right words? You know where I'm going? I just feel like she's real young to have some of the marks she does have on her face. But I don't know if I'm wrong for thinking that. I don't know if that's misogynistic or ageist, or if that speaks to the amount of times she has made specific expressions. And I wonder what facial expressions would cause those lines on her face, or if that's just something that she was born with and I'm being like leaning into lookisms over here. I don't know. We'll see. Okay, let's just keep going. But she looks very angry today.
I think that there's two kinds of malice. Express malice is a deliberate intention to kill, which is manifest.
Usually she's like laughing in court and doesn't seem to be taking this seriously. Today she looks upset. It's just all I'm saying. But anyway, now they're going on to the malice thing. My bad. Yeah, I think I feel like that's easy to prove from the text messages alone, in my opinion. Like the direct evidence, not even circumstantial, direct, clear as day. You know.
Manifested by external circumstances that are proven. Implied malice is when there's no considerable provocation and circumstances show an abandoned and malignant heart. Okay, ladies and gentlemen, there's implied malice in this case. Here's implied malice. Okay, now I will not kill you, and the judge is going to charge you. Okay, he's going to tell you we don't have to prove.
Is that like a legal thing where they have to say the malice is implied? Because to me, it's like not even implied. It's blatant.
Nobody has to prove that because for they were premeditation. We don't have to prove premeditation. Okay, that's not part of the burden of proving malice murder. He's going to tell you that malice can be formed in an instant, and in an instant, a mortal wound inflicted, and it's malice murder. Right now, the reason that I'm bringing this to your attention is because you could reach the conclusion from this evidence, okay, that she either just lost it for whatever, that he left her with the baby again, he's going to get pizza and drinks, she's already mad because, the baby's ruining her weekend and all that, okay, and he left the baby and the baby won't shut up, the baby was crying last night, half the night, and she, had to get up and go to Paris's room till 2 a.m. and she's trying to play with the baby and wake him up, and now he leaves her with the baby again, and she gets out of the shower and he's crying and he won't shut up and she just slipped out, okay, and maybe she doesn't intend, what I think doesn't matter. I'm not trying to prove and I'm not trying to suggest to you or make you believe that she looked at him and said, I am going to kill you, okay? Like I'm not trying to convince you of that, okay? But I don't have to convince you of that for you to find malice murder, okay? What you have to find for there to be malice murder is that there's...
Am I not mistaken? Didn't someone claim that she made a joke about wanting to run the baby over, though, that's not enough to prove the malice murder, if that is true?
No provocation, and the circumstances show an abandoned and malignant heart, that there's just a point at which somebody just goes too far, okay? And when you use your hands or the edge of the bed or the edge of the desk or the floor or the wall or whatever the weapon was to cause this kind of damage, then the evidence is sufficient to show that she's guilty of aggravated battery and first-degree cruelty and felony murder and malice murder. Now, Mr. Gamble has made a big deal, as he should as a defense lawyer, about reasonable doubt. He says, you know, this is reasonable and that's reasonable. Okay, the judge is going to charge you that we don't have to prove doubt beyond all certainty or to a mathematical certainty. We don't have to prove guilt beyond all doubt or to a mathematical certainty, right? And we don't have to disprove every ridiculous hypothesis or allegation made by the defense. Like, I do not have the burden, frankly, of proving to you that this child climbed up on the dresser, you know, and did a high dive on the floor, you know, of his own accord. Because he had one injury, not a whole panoply of them. Okay, I don't have to prove that. I don't have to disprove that hypothesis because it's not reasonable. It's just dumb. And when you look at it, you say this is not reasonable. Okay, so if there's some hypothesis that he's tossed out there that I haven't addressed, that doesn't mean that I failed to prove it. You can take the evidence and analyze the evidence and say either this hypothesis has been disproven or not disproven, or this hypothesis is not worthy of attention in proof. When you consider the evidence, something else you take into account is that there are two specific false narratives, okay? And these are not just arguments that are you know, where somebody's off track on something, okay? These are false narratives, okay, that have been promoted to you since opening statement. In this case, I just didn't say anything about it until now, since opening statement, okay? That the diaper, it's not said directly, but it is implied, okay? That the reason James Gibson threw away the dirty diaper when he was examining the trash out of the trash bin on January 14th, the reason he threw away the dirty diaper was because there was a defense motion to test it. He files a motion and he says, ha, we don't have it, it's gone. You know, when I had to come to court and answer for it. Okay, that's not what happened at all. Okay, Gibson, as you heard from his testimony, made an independent.
I can't believe we're back in the poop diaper, but yet again, I don't understand a reason for them to have kept it. Where was the probable cause for that?
Judgment. Maybe he's even wrong. Okay,
like, what the fuck does it have to do with the skull fracture?
Everybody's wrong sometimes. You know, there's not an agent that's good enough not to make mistakes. There's not a lawyer, you know, a doctor, a cab driver, a carpenter, anybody else that's good enough that they never make a mistake. And maybe Gibson's wrong. I would stand by the decision he's made as his fellow agent has done, but it had nothing to do with an expectation or worry or fear that it was going to be tested. What he had to do, and the fact that it was photographed, unfolded and photographed, doesn't mean that he saw it as being of special importance, but he wanted to hide it, okay? If he saw it as being of special importance and wanted to hide it, he wouldn't have photographed it. The photographing is like everything else was in the trash bag, and he told you, you know, he says, I opened up chip bags and cups and wrappers and all kinds of things, okay? He photographed everything in there, not just the diapers. Okay, the second false narrative, okay, is that Jay Williams isn't legally J.D.'s father, and maybe he's not, maybe he is, maybe he's not. Okay? But that has nothing to do with this case. It is a fact, it is a reference that is not even necessary to have been made in any context or circumstance whatsoever. Okay? It is designed to make you think that these people, the family of this child, do not deserve the same measure of justice that somebody would if they could say, you know, not only is me and my wife, you know, but I've got 9 DNA tests to prove it. You know, this is my kid. Okay? Can't do that, can't do that. Certainly can't do it now. Okay, I bet he'd love to have a paternity fight now. You know, love to. Say, yeah, I'll fight about it. You know, and if I lose, I'll kiss him on the cheek and say goodbye. Okay, but he can't. Whether he's his father or not has nothing to do with anything. Petty contradictions due to different perceptions or memory lapses. And we talked about this before, and I'm not going to go into it much further. Okay, somebody says, oh, look, this is what I said. And they say, no, that's what you said. And it's been 2 years or more, and they're in two different contexts and two different eyes viewing things or two different sets of eyes, and sometimes they don't see things the same way. Failure to find or recover a weapon or other.
I think right there he's basically debunking the part where at one point, because he was told from his ex that it could have been a fall that caused the skull fracture, he thought maybe it could have been a fall, like she said. But then he started to believe that she did it, and the defense tried to weaponize that as if he was an unreliable because he had thought it was the fall and then thought she did it. But here he is kind of debunking, like, no, because he's just showing basically what he's processed as things occurred, you know?
Physical evidence at the crime scene. He says it can't be a crime scene because there's no blood. Okay? Some crime scenes don't look like the Manson family has been.
And that's another fucking thing where they're talking about, oh, why didn't you do blood splatter? Why would you do a blood splatter test when there's no fucking blood splattered?
There, okay? Some crime scenes, you know, there aren't walls full of bullet holes. Some crime scenes, there's not anything in the room that specifically points to it and says a murder happened here. Okay? Why would he not luminol the whole room looking for blood? Because he had just left the hospital and the child didn't have any external injuries. Okay? There's no blood because he wasn't bleeding. Whatever happened to the injuries that he suffered resulted from blows and force that caused him to have internal injuries that cost him his life. There's no weapon. Well, that really ain't right. I mean, that's really not true. Look at here. You heard testimony from the stand that if you pick the child up, Clark said, if you pick him up and you held him by the shoulders like that, you slammed him down on a hard surface. And Clark said something like a desk or a chair. I think were 2 of the 4 or 5 things he listed. Well, see, there's a hard plywood chair, there's a desk, and there's another desk, and there's a bed, and there's other photographs in here that show the end of this bed. There's a bedpost about that big that sits on the corner of it. Okay, and the fact that I can't come in here and say we have a videotape of her, smashing the kid against that chair, or, hurling him against the wall, or hurling him against the bed, and the fact that I don't have a video of it, he's going to tell you that means that you can't convict? Come on. I do have a picture. So you can see the bed, the corner, at the corner of the mattress right there. You can see it's like a metal bed post that sticks out of the thing. Investigative techniques, not a reasonable doubt. Joint interview. Okay, Samantha told you, Sister Samantha Ford, I'm sorry, I didn't even refer to her by first name. Agent Ford told you that she had interviewed Jay Williams twice for 4 hours. She had interviewed Ashanti Burr before as well. I don't recall what the specific.
By the defense's logic, speeding tickets should not exist because you cannot physically see the speed at which I'm driving, and there's no evidence for the speed. Regardless of what the speedometer says, regardless of what tools you have to measure my speed, according to the defense, that's not evidence. If you can't run next to the car as fast as I'm going and know the speed that you're running at, that's not enough evidence. So speeding tickets should not exist, and it's the defense's logic.
Of that particular interview were, what I would submit to you is that if it made a difference that in the third interview after their statements had already been made and sort of nailed down and it's just coming back for judicial information, if it made a difference, then he would have played the interview and said, look here, this is why, they're in there together. This is what's messing up all these statements. This is what's causing the testimony or the evidence to be tainted. Okay? It may be poor technique. Okay? It may be poor technique. It may be a violation of what you learned in investigator school to put 2 witnesses in the same room and talk to them at the same time for any period of time. Okay? But it doesn't create a reasonable doubt when that's not the evidence that the case relies on. Declining to order or obtain irrelevant testing. Okay, the diaper, the vomit. Oh my God, I can't believe we're still talking about this. Okay, so the diaper. Yeah, what's his name? Dr. Busman says, oh yeah, in this light, looking at a photograph that was taken under flash, and then put on a computer, processed through, displayed on this screen, which I'm sure has exact true color under this light. Yeah, it looks red, right? He's not trying to fool anybody. He's not trying to joke about it. Does this diaper look like it's got blood in it? Yeah, it looks red from here. Okay, and then he's right. I believe that you saw that the significance of that was lost on Dr. Busman. Okay, he didn't understand why anybody was asking about a dirty diaper. Okay, the significance of it wasn't lost on me, however, which is why I came back and pursued other questions. He says, the state never backwards to get him to back up. No, I ask questions on redirect, which I'm allowed to do, which I'm authorized to do, which I'm supposed to do to clear things up. Okay, and when I go back and ask Busman, what is it? It doesn't have to be blood in red, something red. Well, you know what? If you look at that picture, I'm not going to try to scroll back through it because I'll lose my place forever if I do, okay, of that child in the car seat coming from Parkwood to Albany when they went to meet at Chipotle, and he's got a sippy cup, okay, it has a liquid in it that is as bright red as the top of this cabinet right here, okay? I mean, he's drinking, a big cup of red fruit punch or whatever, okay? So what if he pooped red? If it mattered, then it'd be a different story. But there's nothing to suggest it mattered because there's no illness, disease, or any other process that could have ever been detected from a red poopy diaper that would have led to a conclusion different than this young'un died because somebody smashed him in the back of the head. There's a lot of audacity floating around this courtroom, okay? Jay Williams, we're going after Jay Williams' parenting skills now. It's like, you didn't take your baby to the doctor for his 9-month and 12-month and 15-month checkups, Jay. The world is looking at you, buddy. Jay, I can't believe this. That baby's only 18 months old and weighs 25.1 pounds, and you have him in a forward-facing.
That's only acceptable if you are white, rich, vegan, and go to music festivals. And don't wear shoes.
Car seat in a sports car. My. The drama, the tragedy, the humanity. Okay? Whatever. Right?
Oh, you gotta be an anti-vaxxer, too.
If you want to say that he needs a parenting class, I bet you he'd love to have to take one now. I bet you'd love to have to take one now, I mean, and if a trooper had seen him driving with a kid not restrained in a car seat or something, and pulled him over, he probably would have got a ticket for like reckless endangerment or something like that, and would have been prosecuted by whoever, would have had jurisdiction over it, right? But whether those things are true or not true have nothing to do with the heart of this case and the evidence where it matters. Everybody in this courtroom's got a job. Okay, we're all here for a reason. The lawyers, I mean, it's my job to prosecute cases. It's his job to defend cases. He's daggone good at it. And, the court reporter, she's sitting over here, she's taking down every word that's said. And we got bailiffs who are monitoring security and doing all those things, and a law clerk and somebody from the clerk's office, and everybody's here for a reason. And, I did this slide and I left off the judge, and it didn't sound like I'm being a smart aleck in doing it, but I was. I mean, I just I looked up and realized, I thought it said judge. It doesn't. Everybody here has a job. Okay? And you have a job. Okay? Your job, ladies and gentlemen, is this. It is defined by the oath that you gave at the beginning of this trial. Judge Sizemore said, raise your right hand. He says,
Our job is to talk shit.
you will well and truly try this case and a just verdict give, according to the evidence. Okay, there's two parts to that oath. There's two parts to that job. Part one is to well and truly try this case. And good Lord, I mean, y'all been great at it. I mean, everybody's been here every day. I mean, people nobody's like, hey, look at that juror over there, they look like falling asleep. Things that we deal with, or waiting, day after day for people who are invariably late and don't come back from lunch and don't take notes.
I'm falling asleep right now.
All those things, y'all been right. You've well and truly tried the case. You've done that part of your oath. But now, it's time to do the other part of your oath, and that is a true verdict give according to the evidence. Your job is to do justice with the state. That is your job. To do justice. To do justice not for him. Do justice for his loved ones. Do justice for your loved ones. Do justice for your community as a whole. Okay? Jury verdicts speak volumes. Jury verdicts speak to the speak to the community. Okay?
And if they do not convict, I will personally haunt each one of them when I die.
They say things to the community. People look at a jury verdict and they say, wow, man, in America, they let people off for that. But they look at jury verdicts and they say, this is the wrong place, wrong time. Do that. You could send a different message. You could send a message and say, hey, look here, y'all. Everybody out in the world, look here. If you do a pretty good job of not leaving blood, kill somebody with your hands, smash them against the wall, crush their liver with your foot or your fist or your hand, whatever you need. Who knows? Don't know. And the fact we don't know doesn't mean that it didn't happen. And it doesn't mean that it didn't happen at her hands. You want to send the verb? You want to send the message that says, hey, as long as you don't leave a lot of evidence on the scene, see ya. We'll walk you, We're going to require video. We're going to require video and confessions before we will convict. If that's the standard you want to set, ladies and gentlemen, that's the standard you set as DA, I'll try to adapt to it. Okay? But don't let yourself think that you're not speaking beyond this courtroom when you go and sit down to decide this case. J.D. Angeles was 18 months old. If you want to do it right, you take this paper, you elect a foreman, and you put a whole bunch of X's down those rows that say guilty. True verdict give. According to the evidence.
Move that aside.
Yes, sir.
George. My plan is to give you the jury charge, which will take about 15 minutes, and then let you retire to the jury room. Once you elect a foreperson and begin your deliberations, I'm going to let you decide if you want to go to lunch and take a break. I'll give you some more explanation of that when I finish.
Okay, so it looks like they're gonna speak more on the jury stuff, and then they go do their deliberating thingy. Oh, it looks like they give us some news here, so we will watch all of that, and then it looks like they go on break, and so we'll probably skip. It looks like they go in and out of breaks and news things, so we'll probably zoom through some of that and watch the news stuff. Probably, I think. And then go to the jury stuff. We'll probably do that unless I get bored while I'm watching it, and then we might skip it. I don't know. Okay, let's see what's happening.
Or I'm going to let you, we could even order out some pizzas or something like that and bring it to you. But I'll give you a little bit more about that in a moment. Can y'all move, Madam Bailiff, if you'll move that to the right or the left? Yes, sir. Just so I can see every juror. Thank you. All right. Ladies and gentlemen, we'll see if this works. Okay. Ladies and gentlemen, you are considering the case of the State of Georgia versus Trinity Poague. The grand jury has indicted the defendant with the offenses of malice murder, felony murder 2 counts, aggravated battery 2 counts, and cruelty to children in the 1st degree. I have previously read the indictment to you, and you will have a copy of it with you in the jury. Well, you have the original with you in the jury room. The defendant has entered her plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered by you as evidence. It is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law that I give you in this charge to the facts as you find them to be. The defendant is presumed innocent, presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you will be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. And facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial, stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court, and any matters of which the court has taken judicial notice. Evidence does not include the indictment, the plea of not guilty, opening or closing.
We don't even need time to deliberate. Let's just wrap this up and go home. This bitch is guilty.
Remarks by the attorneys or questions asked by the attorneys. Where the parties stipulate testimony, documents, exhibits only, this is the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence of this case. And by the way, you will have this jury charge, or this written charge with you in the jury room, along with the indictment, your verdict form, and all the evidence that was admitted as exhibits, other than the videos. The videos will be in the courtroom. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in the light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, then you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury, to decide. Similarly, the jury must decide the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witnesses' manner in testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility insofar as you are able to observe it. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. Testimony has been given to you in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You would evaluate such testimony as you would that of any other witness. However, the defendant does not have to testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. The defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. The law provides that criminal actions shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Sumter County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence or both. Now, this indictment has several counts. You will need to consider these instructions and the facts of the case and reach a separate and independent verdict with regard to each count. Count 1 of the indictment charges the defendant with malice murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. That the killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with the deliberate intent to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, then that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proven by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or...
Okay, but was the statement about wanting to run the baby over premeditation? Just curious. I'm just curious.
Back of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Counts 2 and 3 of the indictment charge the defendant with the offenses of felony murder. The state does not have to prove, for felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated battery and cruelty to children in the first degree are felony offenses, which I will define for you shortly. You may find the defendant guilty of felony murder, as alleged in counts 2 and 3 of the indictment, if you believe that she caused the death of another person by committing the felony of aggravated battery, as alleged in count 2, or by committing the offense of cruelty to a child in the first degree, as alleged in count 3, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Count 4 and 5 charge the defendant with aggravated battery. For aggravated battery, the state must prove that...
Well, if you believe that she was the one who caused the fractured skull, which is the cause of death, then that would fit, wouldn't it?
The defendant maliciously caused bodily harm to another person by depriving that person of a part of his or her body, by rendering a part of that person's body useless, or by seriously disfiguring a part of that person's body. For cruelty to child in the first degree, which is the charge in count 6 of the indictment, the state must prove that the defendant maliciously caused cruel or excessive physical or mental pain to a child under the age of 18. In deciding whether the defendant acted maliciously with regard to cruelty to a child, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. Now, by no ruling or comment that the court has made during the progress of this trial has this court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of the first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. I'll remind you, you're not to have phones in the jury room. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Now, as I mentioned, this indictment involves multiple counts. You should consider these instructions in reaching your verdict with regard to each count independently and separately. And we have provided you a verdict form with regard to that will allow you to express your verdict with regard to each count. So, using the verdict form, for example, with regard to count 1, for example, of the indictment charging the defendant with malice murder, if after considering the testimony and evidence presented to you, together with the charges of the court, you should find and believe beyond a reasonable doubt that the defendant in Sumter County, Georgia, did on or about January 14, 2024, commit the offense in count 1 of the indictment, you'll be authorized to find the defendant guilty of the offense, in which event, with regard to count 1, the form of your verdict would be, we, the jury, find the defendant, and you would check or X guilty. And then, on the other hand, if with regard to count 1, you do not believe that the defendant is guilty of the offense of malice murder, as charged in count 1 of the indictment, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict with regard to count 1 would be, we, the jury.
Over here, like, I have no reasonable doubt. I find her guilty. Let's get it. Let's guilty bitch it. Like, let's get in this room, sign this paper, let's order some food and get out. Like,
find the defendant not guilty, and you would, under count 1, X not guilty, or check not guilty. Again, you should independently and separately make such a determination with regard to each count of the indictment. Whatever your verdict is, it must be unanimous, that is, agreed to by all 12 of you. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. Now, in just a few moments, I'm going to ask you to retire to the jury room. But again, do not begin your deliberations until you receive the indictment, the verdict form, and a written copy of these instructions and the evidence that will be presented to you in the jury room. As I mentioned, what I want you to do is, once that happens, select your
who the
foreperson.
fuck even need to deliberate? Like, what do they need to think about at this point? I'm just curious. Like, what would need to be thought about at this point? What are their doubts for? Who has doubts and why? I need to know.
And either begin your deliberations, or you can start your deliberations, and if you want to take a lunch break, let me know. If you want to start your deliberations and have us order some pizza and bring it into you, we can do that, because it's right around lunchtime. I don't want you to rush. If you'd rather go to lunch and come back, that's fine. If you would rather have lunch as you deliberate, that's also fine. Whoever the foreperson is needs to make sure that the jury is not deliberating unless all 12 of you are in the jury room. So, in other words, if somebody steps into the restroom, you should suspend your deliberations. Okay? Or if you take a break, you should suspend your deliberations. With that, I'm going to allow you to retire to the jury room, and once you get the evidence, the verdict form, the indictment, and the instructions, you can elect a foreperson and begin your deliberations. Wait, we have 3 alternates. If you wait just 1 second. I've got it. Jacob Cromer, Johnny Lassiter, and Sadie Golden. You 3 are alternates, and we're going to sequester you separately. But all of the instructions I've given you about discussing cases and things of that nature apply. Y'all are not yet able to discuss the case or do any research or anything of that nature, even with each other, unless you're brought into the jury room. But I do need you to remain in the courtroom. We have a different room. Judge Rambo has a state court office over here.
What the fuck is an alternate jury member? Is that like they have extras in case they decide other people don't matter or other people don't show up or something? I don't know.
And y'all will stay in there and just remain available. Everybody else can retire to the jury room.
You know, in day 3, I was like, well, she's not laughing this time. And then right after I had said that, not long after, she was laughing. So now I'm over here yet again, like, well, she's not laughing this time, but we'll see. We'll see if that continues.
All right, if y'all come up and make sure all the exhibits that are going back are ready. Ms. Bland, you. Well, first, is there... Chet, if you'll grab that door, please. Is there any exception to the charge from the state or from the defendant?
No, Your Honor.
Okay, that'll be fine. Now, if you'll help them gather and organize the exhibits to go out.
I don't think I put it in there. See, are my exhibits all banned? Are they, I mean, like, do I have any missing numbers, or should I have every number?
All right, we're off the record.
You should have every number.
Except for like the three.
Okay, let's skip through all of this. Let's see here. So, from here, they were waiting for the verdict, and then I think some new stuff comes on. Let's see if any of this is boring or worth watching.
Let's head back to Sumter County, Georgia for more of the closing arguments in the pageant queen child murder trial.
The defendant there, Trinity Poague. She was a former Georgia pageant queen. She's facing life in prison because prosecutors say that she killed her boyfriend's toddler son, this little baby you see there, an 18-month-old named JD. His real name was Romeo, and his father didn't find that out until he died.
Yeah, he was found unresponsive in Trinity's dorm room. Later died at the hospital. She's being blamed for his death. Let's go back into the courtroom now. We're listening to the state's rebuttal case.
How do you make yourself believe it? How do you accept that Trinity Poague could do such a thing? Okay, yeah, so did she have a motive? She resented and ultimately despised that little boy. Okay, now you know this from her statements, her text messages that were starting back in August of 2023. Right, starting in August of 2023. These are in evidence. Remember, they started these exhibits. These are text messages that came from Paris Permore's phone between her and Trinity Poague. They started the back and moved forward because that's the way they're stacked up here. And she says, I'm going to sleep in your room. I can't do JD crying that much. Hopefully he's in a better mood in the morning. Okay, then she's talking about getting in the shower, and she puts him in the washroom in the shower, and he gets water spraying in his face, and he apparently didn't like it and was acting, reacting to it or whatever. And she says, I'm trying to take a shower, and I had to bathe him, and I just sat him down and let him cry because I'm not about to baby him. Okay?
Yeah, I don't understand that aggression at all. It's like, do you not know how the fuck to give a baby a bath too? Like, why would you? Like, I always put the baby in the bath after the water is done, after I've tested it a million times to make sure I think it's perfect for the kid. Like, I don't understand where this scenario even came from either.
I'm not gonna baby a baby. When she's talking about Jay Williams, I'd say, I don't blame you, girl. I wouldn't baby him either, right? No, grown person. She's talking about a little kid. She's talking about a kid that's not that tall, okay? That's unsteady on his feet still. She said, I'm not gonna baby him. The witnesses that came and took the witness stand that were called by the defense said, oh yeah, she didn't like that young man. She didn't like him. She didn't like him. And not only that, he didn't like her. He didn't like her. She sends more messages. In August 17th of 2023, she says, why do I feel anger towards JD? When we were laying in the bed and JD kept touching Jay's face, I almost cried. Okay? Because the kid is being affectionate towards his daddy, it's upsetting her. And Paris doesn't understand. She says, what do you mean? Like you feel anger towards JD? She goes, I don't know, not jealousy, but I want to love him. But instead of loving, I just feel like angry, like I want to punch him. Laughed my ass off. Oh my God, that sounds so bad, doesn't it? Yeah, it does. It does. It does sound that bad. And then the explanation comes in the next two messages. Ever since he's gotten here, Jay has not touched me. He's currently on the floor. Okay? The baby is interfering with her relationship with Jay Williams. Later, 5 days later in August, she sent a message to him, to Jay Williams, and she said, I told you from the beginning I would always try to love JD the same as mine, but since me and you've gotten serious, every time I see him, I just get angry at the world, and I just have a gut feeling of anger. I don't know what it is, but just seeing him makes her angry. In December, she sends a message and says, yeah, I'm coming back. Let's go to January. The day before, the night before, his murder. Says, what are y'all gonna do about tonight? That's Paris's text. And the response is, no clue. I guess I'll probably sleep on the air mattress in the sink area. I can't do being around JD anymore. He hates me and I hate him. And if you examine her conduct towards the child, ladies and gentlemen, no, you will see that in fact that is true. There's an old saying that says, when people tell you who they are, believe them. November of 2023, she told Jay Williams that he had hit his face, had hit his eye, that he bruised his eye, cut his eye, injured his eye, that she was cleaning up near the cabinet in the bathroom, and she didn't realize he was behind her. She opened the door or the drawer. I don't remember which one he said, but she opened it up and she hit him in the eye, hit him in the face. She said, I felt so bad. I felt so bad. Okay, where is JD when he gets the blow to the face? Okay, with Trinity Poague and nobody else. He ain't with his daddy. He's with Trinity Poague. In December of 2023, she sends a message that says, Jay, this is December 17th. She says, Jay, I don't know if I can do this anymore. This weekend was a struggle for me, and I don't know what to do. I love you so much, but letting JD hit the wall and see the damage it did really hurt me. Okay? What in the world is that about? Get in the wall. I asked Jay Williams when he testified, he said, I don't know.
See, at this point, I would have already had, it's 4 minutes into the jury deliberations, I would have already had my shit signed, been already trying to put my food order in. Like, let's get out of here, let's eat and go.
I don't know what she was talking about when she was talking about them hitting the wall. That baby was terrified when you heard those people that said he cried and cried and cried when she was there, and he would stop crying when somebody else picked him up. That was his reaction. There's an old saying, something like, I never trust people who don't like dogs, but if a dog doesn't like a person, I trust them completely. And I submit to you that basically the same thing is true of an infant. Okay? Who don't like babies? You don't like little kids. You don't think they're fun and I don't know, cuddly and snuggly and just wonderful, creatures.
Well, the prosecutor's there with that dramatic reading of the text messages. It's compelling to hear him and not an investigator reading those.
Yeah, and the old, the old dog thing, which we've all done. Like, my dog's a great judge of character, so if
this little baby was always crying in her care, and she even knew that.
Yeah, I mean, it's not, there's nothing legal about it, but it's a great clothes to throw into someone's head.
It's all argument. It's not evidence.
Yeah.
Let's get to our break. When we come back, we will have more of this rebuttal. It should be wrapping up soon. And notice on your screen in real time, because we've been pausing things, the jury actually has this case now. 5 minutes. How long are they going to go? Deliberating the fate of Trinity Poague. Stay with us. You're watching Court TV.
Disappearance of Anna Walsh. Her husband now charged with her murder. All eyes on his accused killer. The disappearance of Anna.
It looks like they keep going through a bunch of different things here. And ads and stuff for the rest of this. So it looks like this is going to go through ads of different things here. And then it goes through their court break. So I think we're going to skip all of these ads. I'm glad we stayed for the first part, so we could see a little more. But I don't think we need to stay for the rest. Right now I got it double timing. Let's see. Like this is about a whole other case. This is back on here though. Let's watch this. Hold on. Let's go back here. Okay, so we are about 11 minutes into this hearing. Once it gets back to the Trinity Poague situation, I do want to see what they have to say about that though, so I am ready for it.
All right, those closing arguments that we've been watching, the Pageant Queen child murder trial for Trinity Poague. She was arrested last year after an 18-month-old Romeo Angeles was found unresponsive in her college dorm room, and she faces life in prison if she's convicted.
Let's go back to the courtroom now. The remainder of the state's rebuttal closing argument.
Okay, Jay Williams, we're going after Jay Williams' parenting skills now. It's like, you didn't take your baby to the doctor. Hey, you for his 9-month and 12-month and 15-month checkups, Jay. The world is looking at you, buddy. Jay, I can't believe this. That baby's only 18 months old and weighs 25.1 pounds, and you have him in a forward-facing car seat in a sports car. My. The drama, the tragedy, the humanity. Okay? Whatever. Right? If you want to say that he needs a parenting class, I bet you he'd love to have to take one now. I bet you'd love to have to take one now, and if a trooper had seen him driving with a kid not restrained in a car seat or something, and pulled him over, he probably would have got a ticket for, like, reckless endangerment or something like that, and would have been prosecuted by whoever, would have had jurisdiction over it. Right? But whether those things are true or not true have nothing to do with the heart of this case and the evidence where it matters. Everybody in this courtroom's got a job. Okay? We're all here for a reason. The lawyers, it's my job to prosecute cases. It's his job to defend cases. He's daggone good at it. And, the court reporter, she's sitting over here, she's taking down every word that's said. And we got bailiffs who are monitoring security and doing all those things, and a law clerk and somebody from the clerk's office, and everybody's here for a reason. And, I did this slide and I left off the judge, and it sounded like I'm being a smart aleck in doing it, but I wasn't. I just did it. I looked up and realized it's like, I thought it said judge. It doesn't. Everybody here has a job. Okay? And you have a job, okay? Your job, ladies and gentlemen, is this. It is defined by the oath that you gave at the beginning of this trial. Judge Sizemore says, raise your right hand. He says, you will well and truly try this case and a just verdict give, according to the evidence. Okay, there's two parts to that oath. There's two parts to that job. Part one is to well and truly try this case. And good Lord, y'all been great at it. Everybody's been here every day. People like, nobody's like, hey, look at that juror over there. They look like falling asleep. Things that we deal with. Or, waiting, day after day for people who are invariably late and don't come back from lunch and, don't take notes, all those things. Y'all been great. You've well and truly tried the case. You've done that part of your oath. But now, it's time to do the other part of your oath. And that is a true verdict give, according to the evidence. Your job is to do justice with this baby. That is your job. To do justice. To do justice not for him. Do justice for his loved ones. Do justice for your loved ones. Do justice for your community as a whole. Okay? Jury verdicts speak volumes. Jury verdicts speak to the jury, speak to the community. Okay? They say things to the community. People look at a jury verdict and they say, wow, you know, like, man, in America, they let people off for that, you know. But they look at jury verdicts and they say, you know, this is the wrong place, wrong time. Do that. You could send a different message. You could send a message and say, hey, look here, y'all. Everybody out in the world, look here. If you do a pretty good job of, like, not leaving blood, you know, kill somebody with your hands, you know, smash them against the wall, crush their liver with your foot or your fist or your hand, whatever you need. Who knows? Don't know. And the fact we don't know doesn't mean that it didn't happen. And it doesn't mean that it didn't happen at her hands. You want to send the verb? You want to send the message that says, hey, as long as you don't leave a lot of evidence on the scene, see ya. We'll walk you, you know. We're going to require video. We're going to require video and confessions before we will convict. You know, if that's the standard you want to set, ladies and gentlemen, that's the standard you set as DA, I'll try to adapt to it. Okay? But don't let yourself think that you're not speaking beyond this courtroom when you go and sit down to decide this case. J.D. Angelus was 18 months old. If you want to do it right, you take this paper you would like the foreman, and you put a whole bunch of X's down those rows to say guilty. A true verdict given. 42 minutes.
Move that side.
Yes, sir.
Sorry.
All right, that's it. And as you see, the jury has it now 17 minutes. They've maybe picked a foreperson just getting into the...
Yeah, I would have been like guilty. Like, yeah. I thought that was a really good argument.
Deliberations, Philip Dubé. Overall thoughts on the case as this jury decides Trinity's fate?
Yeah, it's a rough fact pattern because when you think about it, I mean, here you have a 4.0 honor student studying nursing, I believe, which is a little weird. You would think that she would first do no harm, particularly with a baby. So it's kind of incongruous, the act, if you will, if she in fact...
I think it's hilarious. I thought this was going to go a different direction when they led with the 4.0 university student. Like, I thought they were going to go with the whole, oh, she's got her whole life ahead of you. But then instead he said, yeah, it's pretty fucking weird. You would think you would want to do no harm since you went to school for nursing. I was like, oh, damn, that did not go where I thought it would. That's hilarious, and I agree.
Did this to the baby with her future goals and objectives and endeavors. I mean, she could literally, with the stroke of a pen by this jury, go from being a crowned beauty queen to a defrocked killer. It's really unbelievable. And if that's really the case, then this young lady has really two sides to her. But on balance, you know, it could go either way, frankly.
Do we really have to call her a beauty queen now?
And if she is convicted, I'm convinced it will be because of those sort of insensitive, if not offensive, text messages that she sent. It looks like that she had utter contempt for that baby. And I guess the jury would have...
I feel like she probably could have gotten convicted without that, you know, for at least a good bit of those charges, maybe not the malice ones, but the rest for sure. But with those, that's nail in the coffin, like the nail in the coffin.
Have to decide whether or not it would be a stretch to go from that contempt to a fatal blow to the baby's head.
Yeah, and even that fatal blow.
Oopsie, wrong button.
Even describing it, Philip, we don't really know what happened. The prosecution didn't really say exactly how she created those injuries. Real quick before we have to go to break, was it a mistake for her not to get on the stand?
Yeah, but you know, there's a lot of cases, in my opinion, where the prosecution doesn't necessarily know the direct method that caused the cause of death. But if they know the cause of death, they know that it's a murder, and they know there was only one person who could have done it. That's, you know, I feel like that has to have, you know, been a thing. So let's look that up real quick. Murder cases where no murder weapon is found and murder weapon unknown. So let's see here. Apparently there's several notorious ones which have resulted in convictions. So I don't understand the logic. I'm like, I could not think of this shit off the top of my head, but I was like, I feel like this exists. This is like a common thing, right? Okay, look at the Alex Murdaugh trial that just happened. You know, there's just like, I feel like this is a thing, and there's unsolved cases as well. But there have been some that were found guilty, that were convicted. You know, there's both. There is both. But I just feel like, you know, when you have the rest of the forensic pathology, the circumstantial evidence, and the witnesses, that's enough, right? So, you know, yeah, I'll keep that Google search and put that in the description of this video.
And give more of an explanation.
Yes. I think she should have looked her jury right in the eyes and said, I did not harm that baby. As soon as he left and the baby was there, something appeared to be wrong, and she did whatever she could based on the limited information that she had, and unfortunately, they're fingering her for this. But that she...
And I think she should have called a damn hospital or offered an explanation as to why the fuck she didn't.
He's innocent.
And now we will see what the jury does with it. Phil Dubé, thank you for your analysis this hour. 19 minutes. This jury has been added. We will let you know if they have a question or a verdict. Coming up, though, Court TV's Matt Johnson is going to join us to give us an update out of Massachusetts. And Brian Walsh.
I would have already had my verdict done, and I'd be trying to get that lunch. Y'all said, they said he'd pay for some food, right? Let's get the food, too. The verdict's done. Let's get the food real quick, and then skedaddle.
For the death of Anna Walsh. We'll keep you updated on all of that and the death of Anna.
Oh, okay, so now we're skipping through all this. Fuck that. Let's do some double timing, and let's see if they mentioned this case again. So it looks like here, they're talking about some other shit. I just muted it because I don't care if it's not about this case. But I'm just kind of skipping through to see if they talk about this case. But if they don't, we're just going to skip through all of that. Fuck that. So it looks like it is taking this jury quite a bit of time to deliberate. Bitches, I would have had my shit done with, like, okay, or are they just doing this in, like, a loop? I feel like if it goes back to our topic next, they're just putting this in a loop. If it goes back to the Trinity Madison Poague case next, let's see. Oh, maybe not. Maybe not. Okay. Let's go forward here. I don't even know what the fuck this is about. I just don't have the context for it. I'm kind of skipping through like this because if there is anything else about this case, I just wanted to watch it. But it doesn't look like there is, so we'll be skipping through, skipping around here. Yeah, I don't care about any of that right now. I just don't. We're just... Ain't nobody got time for that. Let's see. Okay, it looks like it took the jury like 2 hours to deliberate. Is that a quick jury deliberation? It looks like they're coming in. Here they go. Let's back it up just a bit. And yeah, so here we go. And I'm going to bring back up the volume, and we are going to lower the playback speed down to 1.5. And now we're gonna actually watch this. Let's see what happens. Let's see what they decided.
And I'm Michael Ayala. We're both here today giving you your front row seat to justice. And we begin this hour in Georgia, where the jury deliberating the fate of defendant Trinity Poague now has a question.
Poague is the former pageant queen charged with murder and the beating death of her boyfriend's son, JD. The 18-month-old was found unresponsive in Poague's college dorm room, and later, that baby, right there on your screen, died at the hospital.
All right, let's go right into court now and hear the jury's question.
Court's 1, I'll mark this court 2. On court 1, I had written, somebody had written
Oh damn, I thought they had decided. My bad. Apparently it's just a question.
we were going to send them back a note asking them what they wanted as far as food goes. I scratched that out. I told them not to send any other note back. But this court 2 reads as follows. What are the following? Count 2, felony murder. Count 3, felony murder. Count 4, aggravated battery. Count 5, aggravated battery. And then it says EG is 1 for the head and is 1 for the liver. So that's the question. It's signed by the foreperson who apparently is Mr. Phillips. So I think the only response, my impression...
Is that a question? That's a shitty question. Did I not process that?
What I should do is bring them back in and tell them they have to read the indictment. I can't answer their questions about this. And they have to read the indictment, and then they have to consider my instructions as a whole and make a determination as to each count separately and independently, considering my instructions.
Do they have the indictment?
Yeah. Of course they have the indictment. I mean,
okay.
Yeah, right, man? Yeah. I mean, I saw y'all put it on top of the things.
Okay,
So,
now I'm worried. The fuck, jury? How the fuck do you even need... How is this even a question? She's guilty. Guilty. Get marked guilty. Get the lunch. Let's go home. How is this even... How do any of you have any reasonable doubt? I don't understand.
I'm not sure. I mean, I know off the top of my head, count 2 is felony murder based upon aggravated battery. Count 3 is felony murder based upon cruelty to a child. And then the aggravated batteries are, one is for the head injuries and one is for the liver injury, I think.
Yes.
But I don't think that's my place to tell them that. I think they have to read the indictment and then make a verdict considering all the evidence and everything that has been instructed to them. Do you agree with that, Mr. Lamb?
Oh, yeah, because if he answers their question, it could be perceived as telling them how to plead, I think. Maybe I'm wrong.
I think so. I mean, I don't think that that the court should interpret the indictment for them. If that's what you're saying.
You agree with that, Mr.
I think that.
I do, Your Honor. I do.
All right.
I mean, I think you
let's bring them back in.
just tell them that they'll reread the indictment, that information is set out in the indictment because it is. But I don't think you should interpret it for them.
All right, so while they bring in the jury, I want to bring in our guest. Joining us here this hour is criminal defense attorney Forrest Miller. Forrest, you heard what was going on there. Essentially, they're trying to figure out these charges. There's 2 felony murder charges, 2 aggravated battery charges. There is that top charge of malice murder. Maybe they kind of skipped over that or decided that wasn't the case. We don't know for sure. What are your thoughts on what we just heard?
Well, thank you for having me again. I appreciate it.
Just jumping over to malice murder, man, that's at the top of mind for me. I'm like, that bitch just did it. She killed him, and she's malicious. I'm like, the fuck? How does... I just...
Well, first off, the jury, it's coming up to the hour. It's 4 o'clock right now there. So, they want to ask questions. They want to make sure that they're doing their duty. I think that the judge is correct. He shouldn't be interpreting the indictment for them. That's their business and their understanding. But this is typical, right? A jury is going to try to make a decision, but they want all the facts and they want to be told how to think a little bit. So it's good on the judge that he's pushing back a little bit and letting them do their own thing.
All right, let's do this. I understand the judge is back in court speaking with the jury. Let's go in to hear what he tells them.
Question from the, I presume it's the foreperson, is that right? And it reads as follows. What are the following? Count 2, felony murder, count 3, felony murder, count 4, aggravated battery, and count 5, aggravated battery. And then it says, e.g., is 1 for the head and is 1 for the liver. And I'm going to respond to this by asking you to refer to the indictment. The indictment has the allegations contained in it. You have to review the indictment, then you consider the jury instructions that I gave you, and you have to make a determination. You determine the facts. I've given you the law as to each of those offenses that are charged, like what is aggravated battery, what is felony murder, what is cruelty to a child, and what is malice murder. You have to determine on each, with regard to each of those charges, considering the allegations in the indictment, whether the evidence supports that, given the burden of proof that I've instructed you on in some detail, and the facts as you find them to be. But I can't really answer your questions. I'm not going to try to interpret what the allegations of the indictment are for you. You do have the indictment with you, is that correct? Okay, all right. So I'm going to ask you to return to the jury room and resume your deliberations.
All right, I agree with what the judge did, Michael. He simply said to the jury, when you're asking was one of the charges for the head and 1 for the liver, you have to refer to the indictment that sets out those charges, as well as the jury instructions, which explain what the law is that the jury has to apply.
Yeah, it's interesting because the way our system works, you would think the judge would explain some of this to the jury, but that's not how it works.
It's not, and it's funny because I wouldn't think that as a former judge, right? But to your point, if you're not familiar with our criminal justice system, I think you might think that. It's really, it's something I think we know doesn't happen that way.
Exactly.
And I want to bring in Forrest Miller because I will tell you both, I'm a little bit surprised at 2:20 they had this question, because I would have thought a jury would look at everything in front of them, decipher it, figure out what they could do, and I think an indictment...
No, they were putting their lunch order in.
And jury instruction should theoretically really make it clear as to what the charges are. But Forrest, tell me if I'm off base.
Well, you're not off base, right? They should be able to kind of interpret the law. But when you're in the jury room, and I've never been in the jury room, but there's got to be some debates going on back and forth. And when you're debating certain fine points in the law, what this definition of this word means, you want to have a firm definition. And I think that's what's happening. They're debating back there. And that's good. That means that they're doing their job. They're fleshing out the facts. And this is the stuff you want to see from a jury, that they're actually thinking about it, at least from a defense standpoint. Because you don't want them to go in there, immediately convict, and then come out real quick. You want them to debate and discuss.
Absolutely. And Michael, I'm kind of smiling because one thing I should mention, have you ever in your experience seen that jury instructions may not be as clear and as good as they should be?
Absolutely. Which is why I'm saying one would think there would be circumstances where there may be or need some explanation. But, we all as attorneys, when we're in these cases, we go through a lot of work for us to make these instructions understandable. One of the things defense attorneys do is they want it to sort of sound the way they want it to sound, and they work the...
Theoretically, I agree that, all jury members have a due diligence, have the need to have a due diligence for looking into the facts of the case. They're obligated to it. But in this situation, we just sat through all of that. We've deliberated. This bitch is guilty. Let's get our food. Let's go home. That bitch is guilty. What is the 2.5 hours for? Come on.
The language within the law, and the state does their part in trying to get it to, say something that they wanted to say, or just kind of lean in their direction. But sometimes, and I'm sure you've seen this in your career, it can be confusing even for attorneys.
Absolutely. Just picking jury instructions at the forefront of a a case, a trial, you know, you're debating certain, which jury instruction do we give them? This one's more favorable to the defendant, this one's more favorable given the facts, right? And it is confusing because just a little change in definition could, in fact, change the outcome of the case. So you really want to be specific and definitive in what you're instructing the jury.
Let me ask you this. Does this, as a defense attorney, what do you think about the malice murder, the top charge? They didn't ask a question about that. They came back with these 4 lessers. Does that tell you anything as to maybe what they've done about that top charge?
I mean, it means that they understand what they're looking at, right? If they had any kind of, if there was any kind of ambiguity to the charge, they would have already submitted the question because they questioned about everything else. So potentially they already have her locked in for that. And given the facts that were presented during this case, they were pretty egregious. So I think it's likely that the jury's going to convict on that, but they wanted to be definitive about these last lesser crimes, and I think that's a righteous move by the jury.
All right, so your position is that, see, my thought was maybe there had been enough sort of acrimonial problems in there regarding that malice murder. The fact that did the state prove that she had this intent to kill the child? It wasn't some lashing out at the child and hit the child and he ended up dying.
How the fuck do you mean did the state prove? The state's got those text messages and like 4 different fucking witnesses claiming that the baby resented the child. Like, I mean, the baby resented the child. The girlfriend resented the child, you know, that she's claimed that. So, I feel like they more than did their due diligence on that.
Did she intend to kill him? I think that is a sort of higher mountain to climb for the state, whereas the felony murder, I think that's the one that they can sort of all agree upon. So, but you disagree. You think that they're just dotting their I's and crossing their T's.
What I think is that they've made the decision on that first one, whether it's a yay or a nay, the decision has been made. I think they just want clarity, like you said, dotting their I's and crossing their T's on the lesser charges. And that's why they ask questions, right? But I think that they're locked in on that first one already. Or they might have a question about that as well.
All right, let's listen to a little bit of the state closing argument and what they said she did, their position about what she did to this baby.
That girl killed that little boy. She killed that little boy. She cracked his skull. Out of anger, out of malice. We're talking about that plunder. She killed that little boy. She's the only person who could possibly have done it in the time frame in which it had to have occurred.
Cracked his skull, malice murder. That's what the state wants. But talk to us about what each of these means, Michael.
Yeah, from listening to the judge, the question they had was which of the charges, the aggravated batteries or the cruelty to a child, refers to the felony murders. The way the judge laid it out, he said one of the felony murders, there's 2 of them, is for the aggravated battery. That's for the hitting to the head and the laceration to the liver. And the second one refers to the cruelty to a child.
Right.
Again, and that's just the general sort of circumstances of the case. So that's the way he laid it out. And that seems like the question they had. So hopefully going back to the jury instructions will clarify that.
And to our point, maybe they're not well written. It may not answer the question for them. But we have seen juries, if it doesn't really help, they may ask it in another way. So we'll see what the jury does. Stay with us. Coming up next, we're going to switch gears, and go to Massachusetts for testimony in the Brian Walsh murder trial. We will be picking up with testimony from the cross-examination of the digital forensic.
Yeah, we're not doing none of that. This is about skipping through here. Yeah, they are definitely doing this other thing. The jury's still deliberating. We are about almost 3 hours in for the jury deliberations at this point. We are skipping through here. Oh, it looks like we are about to get back to the jury situation here. To our trial situation. Double timing here. Let's see if we finally get the verdict. We've got about an hour left of the stream that we are streaming. Hey, our shit is coming back, I think, any minute now. Let's see. So, okay, let's double time. Go ahead. Alright, our verdict should be coming in, I think. I think that this is guilty. It's got to be an obvious guilt charge, right? So, we'll see what happens here. What did they decide? Did they agree with me? I don't know. Her hair is now looking much rougher than it did before. Yeah, previously she came in with her hair styled in a great mood. It's quickly gone downhill. Oh, is something happening? We're still double timing through here. Let's find out. Yeah, I think she's fucked. I'd be real surprised if they did acquit her. Like, I'd be shocked.
All right.
Let's see if they
Ms.
agree.
Foreperson, does the jury have a verdict? All right, if you would pass that to my bailiff, please. All right, Ms. Poague, if you would please stand. The verdict reads as follows as to each count. On count 1, it says, we the jury find the defendant not guilty. On counts 2, 3, 4, 5, and 6, the verdict reads, we the jury find the defendant guilty of felony murder.
Shit, which one was which count? I don't know which was count 1, 2, 3, 4, and 5, and 6. Hold on, so is he telling us now that she's guilty of felony murder? Oh shit, let's find out, hold on.
2 counts, aggravated battery 2 counts, and cruelty to child in the first degree. Y'all can have a seat. Ladies and gentlemen, it's been a tough week for you, I'm sure.
Hold on, so. Let's reprocess this, wait a minute. So it's felony murder. Hold on.
Aggravated battery 2 counts, and cruelty to child in the first degree.
Felony murder 2 counts. Aggravated battery 2 counts. And cruelty to the child in the first degree. So that's the 5 counts if I'm not mistaken. So she didn't get one of the murder charges, did get another, as well as aggravated battery and cruelty to the child, if I'm not mistaken. Maybe I'm wrong. I think she got one murder charge and not another. Maybe I'm wrong. Let's find out for sure.
Great. Y'all can have a seat. Ladies and gentlemen, it's been a tough week for you, I'm sure, and I know that you probably had a lot of places you would have rather been this week than here. I do want to thank you tremendously for your service. You have shown up, you've been on time, and you've paid thorough attention. You've taken in a lot of information this week, and you obviously, from the fact that you've deliberated over this, you've looked at this very closely. So with that, your county appreciates the work you've done, and you'll receive a stipend. It's just a token of the county's appreciation. You are free to leave for the term. You're also free to, you can certainly step back into the courtroom through the other door if you wish to, or hang around if you want to speak with the lawyers, but you don't have to. You don't have to talk to anybody. You're welcome to leave at this time if you prefer. If you do, turn in your badges on your way out, and make sure that your notes are in the jury room. And I really appreciate it. Y'all are free to go.
I'm hoping he'll explain those charges more, because I'm just curious as to what, like, if I can find out more information about that, what specific charges she ended up getting.
Was there anything hold the jury for just a second. Ask them to step into the jury room. No, ask them to step into the jury room. Ask them to just step into the jury room. Yeah.
Oh goddamn! I just realized I was muted. Basically, I was just saying I really want to understand what she was charged with, because sometimes the judges will go over the charges better, but this time it's like it went by real quick, unless he does it more in a minute.
Chad, if you'll pass this down, please pass this down to the lawyers. I do want to let you all review the verdict form, and let me know if there's anything else that either of you are asking me to consider.
I'm over here like, damn, did I unmute that right the second time there? Shit, I don't know.
All right. May the jury be released. Mr. Lamb? Yes, Your Honor. Mr. Gamble?
Yes, Your Honor.
All right.
I had double time through here.
All right, my proposal would be to let's proceed with sentencing. I would like to give you all about 15 minutes and come back in, and I'll hear from both sides, and then I'll pass sentence. So it's 4:35. I'll be back in at 10 minutes until 5, and go ahead and hear from both parties and conduct sentencing. Thank y'all.
Okay, if he doesn't go more into this, I'm just go ahead and Google what did Trinity Madison Poague get charged with, and then we're not going to look at that yet. We're going to come back to that later. I just went ahead and Googled it. Okay, and then that way, if he doesn't explain it, I will pull that up to better process that towards the end. But let's keep processing. We're going to skip through this break here. It looks like they're coming back right around here.
Or vacating any of the sentences because
hold on. Let me go back a little bit because I want to hear the beginning of what he said. timing. There's about 30 minutes left in this video, so we should be done soon.
All right, we're going to address sentencing. Before we do that, I want to see if there's any disagreement as to merger of the charges or vacating any of the sentences because of the. I know that the aggravated battery charges merge with the felony murder charges, and I believe the cruelty to child does as well. But I want to see what both parties indicate.
No, sir, I don't think we agree.
Okay, what is your position on that?
The state's position is that, of course, the court could impose sentence on. That you go straight down the line. The court could impose sentence on count 2, which is felony murder. Count 3, felony murder, would be vacated because you can't be sentenced for 2 murders in the same case when there's only 1 victim. Count 4, aggravated battery, would merge with count 2, felony murder. Count 5, aggravated battery, would stand alone because you would only merge 1 felony with a felony murder, not 2. Even though the felony murder, because the felony murder is. Well,
can I see the indictment? Will you hand me up the indictment from the?
I mean, I have a copy of it. I don't know.
It's with the exhibits.
Is it in that box?
Well, if you have a copy, that would be just.
I just counted all the exhibits. I didn't even think about that.
You can hand it up. That's fine, Laura.
So
let the court reporter sit up there.
Yes, sir. Yeah, please.
All right, let me ask you this question. Felony murder in count 2 charges her with murder based upon the commission of aggravated battery by causing blunt force trauma to the head and torso, right?
Yes, sir. But that "and" is interpreted disjunctively, and I mean.
Let me finish my thought pattern,
yes,
and then
sir.
you can tell me your response to that.
Okay.
Count 4 charges her with aggravated battery by rendering his brain useless, and count 5 by rendering his liver useless. And then count 2, felony murder, charges him with aggravated battery for both of them. I mean, in either way, right? To the head or the torso. So why wouldn't both merge into count 2?
But first of all, with respect
Can we take a break? Are you looking for the indictment?
Yes.
Okay. If it's not in there, then they need to hold everything in that. Okay. All right. All right. Okay, you can go ahead.
So even though, which count is the count 2 is the one that relates to the aggravated battery?
Yes.
Is that right?
Yes.
Okay. And so it refers to an aggravated battery based on damage or to the brain and to the liver. That
head and torso.
Or head and torso. Right. That "and" is should be interpreted disjunctively. In other words, if there was a finding that only a battery to the head, that would be sufficient to support a claim. A finding of guilty on felony murder. If there was a finding of aggravated battery only on the torso, that would be.
Look, this part, I don't know about the law to know enough about the differences between why certain charges have certain penalties, but so I don't have much of an opinion at this point in time on what they're debating, because I don't understand the law behind why certain charges would be what would be the legal process, versus another charge method. But yeah, I'm just over here like, look, y'all found her guilty, that's good enough for me. Let's lock her up as long as possible. That's just me in this situation. I don't see much room for, she didn't seem to show any remorse, so how am I going to believe she's going to be rehabilitated into society and not do something like this again? But that's just me. I don't think Gypsy Rose Blanchard should be out either, but we're here now.
Sufficient to support it. So since either of them will support the felony murder, only one of them merges, and then count.
How do I know which one merges?
First one. If you go straight down the list of charges, okay, and you get count 3 is vacated, count 4 merge with count 2, and then now there has been a merger for count 2, which means count 5 would not merge; it's left freestanding, and count 6 can't merge because count 3 was vacated. So the sentence should be on felony murder and on count 5 aggravated battery and count 6 cruelty to children. That is the state's position.
All right, Mr. Gamble.
Yeah, we disagree on that interpretation. I believe that the court is correct concerning the merger of the aggravated battery. That's the only charge that should stand is the first count of felony murder, which is number 2. And then the others would have merged in one way or another and be out. And then the only other charge could be cruelty to children. I believe would be the only one that remained with the felony murder. That's our position.
Do you happen to have any case law that addresses this particular situation?
Yes, sir. If you, I mean, if the court wishes to take a...
Maybe we should take a recess.
Well, I'm looking right now, Judge.
Okay. And I mean, you do agree that then that the two felony murders, one vacates, right?
Yes, sir. Count 3 is vacated. That's correct.
But the fact that count 6 would have merged with count 3 doesn't affect count 3?
No, sir. Once it's vacated, then there is nothing for it to merge with.
Okay. So the question is, and I think Mr. Gamble agreed with that, the question is whether count 4 and 5 merge with count 2, because the felony murder charge in count 2.
Question: can't we do what's it called whenever someone's found guilty of all these charges, and then they are sentenced consecutively? How about that? Would that work?
Including both, whether it's, I guess it says and, you say that says is the disjunctive, which means or.
Right.
But it
Maybe, here's what I don't understand. Why does there even have to be a merger with this shit? She was found guilty of all that shit. Why are we merging anything? Let's give her all the sentences. All the sentences.
includes count 4 or 5 or 4 and 5. I mean, they could have found her guilty of both. Well, they did. They did find her guilty of both.
She should have enough sentences to make a paragraph.
So I guess I need case law on that. If the state is seeking a sentence on aggravated battery count 5. So we'll take 30 minutes. Mallory, you come with me, and we'll take. I'll give you some. I'll alert you when I'm ready to address that.
I am so tired, y'all. It's just like I am not even up anymore. Okay, so let's skip through this. Fuck that. Oh my god, I'm going to bed after this. Fuck this. I gotta get ready for bed still, though. Okay, here we go.
I'm being told that the state and the defense agree that the sentence that the court is going to impose is for counts 2 and count 6.
Yes, sir. I advise Mr. Gamble that after doing some additional research, or some initial research rather, on that particular question,
2, 4, 6, 8. Who can we incarcerate?
that I think that 4 and 5 would merge with count 2, and that being the case, the state's position is the court should sentence on count 2 and count 6, which I understand is the defense position as well.
Correct. Yes. Yeah, that's what I was finding too. I had never seen a case where you could back a charge out of the felony murder, even if it was. Of course, there are very few cases where more than one felony are charged in a single count of felony murder. But at any rate, then count 3 will merge. Will be vacated. Count 4 and 5 will merge with count 2, and count 6 is a standalone offense based upon the merger of count 3. The the fact that count 3 had to be vacated. Is that correct?
Yes, sir.
All right. I'll hear from the state concerning sentencing as to count 2 and count 6.
They are not talking about the type of vacation the defendant wishes.
And of course, if you want to present any witnesses, you certainly can. Now, I believe the sentence possibilities are life on count 2 or life without parole. And on cruelty to children in the first degree, the sentencing range is 5 to 20. 5 to 20. Okay. All right. All right. I'll hear from the state first.
The state proposes that the appropriate sentence in this case would be a sentence of life in prison on count 2 with a sentence of 20 years consecutive on count 6. I understand that Ms. Poague is very young. I think this is the terrible tragedy of these kinds of cases. I have a baby as a victim, and who was at the time a teenager as a defendant, and I think that the jury's verdict. It's not always very possible to get an interpretation of what the jury might have been thinking, but I think if you look at the way the verdict is structured, that it suggests to me, at least, that by finding a not guilty on malice murder, that there was a belief that there was not evidence of a specific, essentially a specific intent to kill or a deliberate intention to kill, and that would be the distinction between count 1 and the remaining count.
And I highly disagree with that, because there was evidence, if I'm not mistaken, if I remember correctly, I think it may have been with the wasn't it one of, if not the roommate, if it was either the roommate or one of the other chicks she went to college with, if I'm not mistaken, who had said that she wanted to run the baby over. And between that and other text messages we know were there for a fact, I think that's malice. I don't understand how they came to that conclusion. We have different opinions. You know, I'm wondering if people who hate their own kids made that call. I don't know. About that.
Else. And so, in my view, if I accept that as a finding of fact, you know, from my perspective in proposing a sentence, if I consider that or accept that as a finding of fact of sorts, that there's evidence of malice, that there's evidence of, you know, disregard, basically conscious disregard for the consequences of her actions, then I feel justified in asking for consecutive time. But if there is if I do not believe that the evidence supporting
It's consecutive, like never get out. Fuck that.
this jury in making a finding of a deliberate intention to kill, such as would support a malice murder conviction, then I'd feel constrained to leave the recommendation at life without parole. I mean, at life in prison as opposed to life without parole.
All right. Do you wish to present anything? Anybody wish to
What's the difference between
say anything from the family, or are you?
What's the difference between life in prison and life without parole? Is it like life in prison or life without parole? Obviously, you don't get parole, but life in prison, you could still get parole. Then what's the point in life in prison if you're still getting parole? Then it's not life in prison. It's just a really long time now, isn't it?
Presenting any testimony?
No, sir, not presenting any testimony, and I'm not, the father of the child is not father and or here, of course, but I'm not asking them to make statements to the court, and I've told them both that they could if they wanted to do so, but...
I mean, he already had to testify like 10 fucking times. I'm exaggerating, but kind of not really. You know what I mean? Like, let's just leave him the fuck alone. God damn.
We're not going to.
Okay. Mr. Gamble?
We recognize felony murder. I don't think if they're recommending life with parole, that's as lenient as a sentence could be under that particular charge. I don't think you can go below life in prison for a felony murder charge.
Right.
So we don't dispute that. We would ask, though, Your Honor, the cruelty to children, they're asking for consecutive 20 years. If you put that on there, you're coming very close to being life without parole, in that you will not come up for parole currently for 30 years.
I think it definitely needs to be consecutive. And like you said, it's close, but that technically...
And then add 20 more to it. Would be very close to her entire lifetime. And we would ask the court to consider, you've heard the evidence, and you know the generally...
Well, what about the baby's lifetime? Did she think about that? Did she think about that?
What the whole circumstances were. She was 18 years old at the time. A young girl that had not had any trouble with the law, any problems, and was doing well. Now, obviously, she's accused of a horrendous
18 years old is enough to know better.
crime that we fought about in court, but we accept the jury has made a verdict, whether I agree with it or not. So she has to now face what the consequences are of that. But it should not be so severe that it would be akin to life without parole. And that would be what happens if you make this consecutive serving time sentence.
Okay, so what did that baby do to deserve to die, by your logic?
Asked that on the cruelty to children, that it run concurrent with the life sentence that she is going to be imposed on her for the felony murder. So felony murder plus 20 years, but run concurrent with the felony murder charge.
All right, Ms. Poague, if you'll stand up, please. I don't do a lot of speaking when I'm passing the sentence. I've heard the case, and I've considered the tragedy on the left side, on my left side, and on the right side, and there's a lot of tragedy to go around here. The whole time that I'm hearing the case, I think about what the appropriate sentence would be, and this conduct all led, in my opinion, to the offense of felony murder. Even the charge that would have merged with count 3, but does not because count 3 is vacated by count 2. That's a lot of technical jargon, but the bottom line is you're going to receive a sentence of life in prison, which is the appropriate sentence for the conduct that you have been convicted of, and that is going to essentially be the sentence that the court passes in this case. You will be sent on. So on count 2, I sentence the defendant to serve life in prison, and on count 6, I sentence the defendant to serve 20 years in the state penitentiary. Those sentences will run concurrent. I do wish to advise you, Ms. Poague, that you have 30 days to appeal. You also have 4 years within which...
I guess the concurrent means, instead of consecutive, that it does give her a chance when she's old as fuck, maybe, to parole, I think. Which I don't even think she deserves, personally. But the baby isn't going to get to live again. If it were a different case where it was like some sort of freak accident, and isn't there like a murder charge for when you do technically kill somebody, but you really didn't mean to do it? Isn't that a thing? I'm sorry, that sounds fucked up. But if that isn't, like, in a situation like that, maybe I would see like I would be like, yeah, let's do like let her out one day because let her out because it's highly unlikely that's gonna happen again. What would be the chances, right? But in this situation, it's like I don't know. I really do think she has a risk of reoffending if ever given the chance. And that baby's never gonna get to live again. And it's just yeah, are we looking at the same case? I don't know. I felt like that should have been consecutive, but maybe there's something about the law and precedent of past cases with that sentencing that I don't understand, which would dictate why he gave this sentence he did.
You could seek habeas corpus. I hope this can bring some closure to the family. It's just a complete tragedy, and I hope that you can, in your older days, have some sort of life after serving this sentence, and life while you're in prison. You just have to make the best of it. But that's the sentence of the court. I wish everybody the best.
I'm over here like she doesn't even deserve a fucking life. Like that baby's not going to get to live their life again. So why the fuck? So I feel like it.
Or Mr. Gamble for review, and then to Your Honor.
Thank you.
This is it. It looks like this is it. I think that's absolutely all of it. So thank you for Court TV for streaming all this for us so we can fucking watch that shit together. So just to recap today, what we did was finish day 2. Why did I say day 2? I'm just so tired. Day 4 of this trial. This was a lot. So it took a few hours for the jury to come in. They did find her guilty. Oh, you know what? Might as well put this up. So what did Trinity Madison Poague get charged with? She was sentenced to life in prison for the murder of her boyfriend's 18-month-old son, Romeo J.D. Angeles. She was convicted on 2 counts of felony murder, 2 counts of aggravated battery, and 1 count of cruelty to children in the first degree. Let's see here. In January 24, she was a student at Georgia Southwestern State University. The toddler was found unresponsive in her dorm room and later died at the hospital. The prosecutors argued that Poague caused blunt force trauma to the head and torso, which resulted in severe brain and liver injuries. Poague claimed the injuries occurred after the child fell off of a bed, a claim refuted by medical experts. In addition to life in prison for felony murder, she received a concurrent 20-year sentence for child cruelty. She is eligible for parole after 30 years. She was stripped of her 2023 Miss Donaldsonville title following her arrest. And we've got the mug shot here. Let's pull this up. There we go. Let's see, can we make that bigger? I don't know, pulling that up. But anyway, so, yeah. Life in prison, and apparently they call her a beauty queen. And so, yeah, she was found guilty. I knew she was fucked, because the attorney, mind you, I don't know if it was just the attorney's approach, or if it was just him dealing with the hand he got, which was that bad, but whatever the case, it was so bad you were looking at this like, wow, you suck. And I'm looking at this now, and it says 41 degrees in Dothan. Is this a Dothan news outlet? Why the fuck does it say Dothan? Oh, yes, it is. This is Dothan News. Okay, interesting. Dothan, Alabama. Alright, I was about to say, why the fuck is it saying I'm in Dothan? No, I'm just using a Dothan source. Alright, anyway, I'm distracted. So today, what we looked at were closing statements from the state and the defense. And when the state was speaking, they had, the presentations together. They were pointing to all the evidence they had, as well as the witness statements, as to how they came to the conclusions they came to in their investigation. And just to recap, they're basically walking through everything, how the evidence cleared the father of the child. How at the time of the investigation, they discovered the only two people that the baby was with at any time frame in the time window in which the injury occurred, the fatal injury occurred, it was only with the father of the child and the girlfriend. The only time the baby was left alone was with the girlfriend. So to me, it's like, why would the girlfriend not have gotten help? Called the police, called the ambulance, gone to a hospital, nothing. If the boyfriend was somehow involved, but she wasn't, you know? But instead, she calls the boyfriend, and then the boyfriend is the one to take the baby to the hospital. It's just, you know, so the boyfriend ends up being cleared, and the defense is basically like, well, you didn't question the sister enough, but the sister wasn't around at this time, so what the fuck does the sister have to do with this? You know, like, he was using everything he could to deflect, you know, basically. But the defense in their closing arguments was basically saying there was no evidence. And even though there's not direct evidence of what happened when the baby died, there's a lot of circumstantial evidence, you know, including the evidence to clear the father of the child, and then the evidence that the baby was there with the girlfriend, as well as evidence of the baby's thoughts and intentions and motives toward the child related to a lot of resentment, and there were multiple witnesses who discussed how either showed evidence with the text messages or discussed their own perspective of how Trinity had told them in one way or another she did not want to be around this baby. And she had even made jokes about harming the baby. So, you know, there was just a lot that didn't look good for her. And for her to have been the only person with the baby at the time of the fatal injury and to have no explanation, no alibi, no nothing for what had happened is very confusing. If she wasn't involved, it doesn't make sense to me. Why not call the police? Why not call the hospital yourself if you have no involvement? Why not have, like, be able to say what happened at that time? It's just, it doesn't make sense. So yeah, she was obviously convicted of murder after about 3 hours of jury deliberations. And she was convicted of felony murder. What was it? 2 counts of felony murder, 2 counts of aggravated battery, and 1 count of cruelty to children in the first degree is what she was convicted of. And so, yeah, she's not going to serve, I mean, she was sentenced life in prison, but she will be eligible for parole after about 30 years. I think she should have had given her sentences, because she was given life in sentence for the murder, and the aggravated battery was kind of combined with it, and then the cruelty to children, she was given 20 years that were served concurrently with the felony murder. I wish that was consecutive, but, you know, to each their own. Perhaps I don't understand something with the law related to that. But yeah, so we're here now. It's been a long, wild ride. I'm glad she was convicted of murder, though, because I didn't understand what the fuck. I don't know. The attorney, the defense attorney just bothers me. Like, I don't know if it's like I don't understand his tactic for some reasoning with the law that I don't have experience on. But every approach he had, it just didn't look good to me. And I just feel like, you know, even if I'm not experienced in the law, I'm the type of everyday person that he would have to convince, right? And so, to that point, I think everyday people's opinions do matter on legal commentary when it comes to attorneys, because how we feel about your approach can reflect on if you're able to convince a jury like us in the future, one way or the other, you know? So, like, even though I'm not part of that industry, I do think it does matter when it, you know, I'm not an attorney, but I think it, like, does matter what I think or what other people who aren't attorneys think, because we are who you have to convince, you know, when you are making these cases. So if attorneys do better understand what we think of their approaches, then they'll better understand how to use different approaches to better defend their clients, in my opinion. So, I don't know. I think that there is some value in listening to people who are on the outside looking in when we are the ones who are either your client or your customer or the one who you are trying to convince of something, But yeah, that's just me. So yeah, I feel like I've been here for so long and I've just been basically here for hours at this point. Like, this bitch is guilty, let's go. Like, you know what I mean? So yeah, so I'm gonna go get the fuck ready for bed, go to fuck to sleep. I gotta work tomorrow and be responsible. Thank you for joining me today. I appreciate you. Sorry that I keep forgetting to unmute. It's probably definitely gonna keep happening. And I think I got a lot more coming up in the near future. So yeah, we'll see how fast I can get the situation I want to cover next done. I don't know if it'll be tomorrow or not. I would rather do more research on some things before I cover it if I can. But I might go ahead and start covering it before I've done my research just to get it going, and then do another part with more research once I hammer that out later. I don't know. We'll see. But yeah. Alright. I'm sorry I'm vague. Once I actually do that live, I'll be more clear on what I'm talking about. Yeah. I appreciate you guys. Thank you for joining me. Have a good night. Take care of yourself and all of that. And, yeah. Alright. Good night. Bye. Thanks for watching. Join the loyalty program at noladeathchild.com/loyalty and check in during live streams to get points for rewards.